Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Green bars lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, everybody. Good morning, good afternoon, good evening. Well, it is good evening for me already. Hello, welcome in. Today it's Monday. It is gonna be a busy day, busy night, busy time. I'm playing who knock knock jokes with our lovely Maria. Good morning, Maria. Good morning, Paula. Good morning, Zizzy, Susan, Lois, uh, Denise. If I say Paula, yeah. Good morning. Hello, everybody. This is so late for me. I am not used to beat this to. Oh no, I'm so sorry, Maria. My apologies. It did not work today. Hopefully one day it will. It is so weird. Oh, good morning, William. I'm trying to scroll up to make sure that I did not miss anyone. Annie, good morning. Hello, good morning, good afternoon, hello. I am so disorientated. I was so bored. Because this is like normal. Do not harm. Hello, hi, hello, good morning, my friend. Good afternoon. I'm just gonna say hello, whatever time it is over there. So it is. I'm already discombobulated today. I don't know what I'm doing. I don't know what time it is, what time zone it is. I don't know if it is morning, afternoon, evening. Hi, good morning, Forrest Nelson. Good to see you, everyone. I hope everyone had a good weekend or an improving weekend. I know that sadly, Susie, for you it wasn't probably the best of weekends, but I am glad that Puppy is improving and that everything, and hopefully you recover very, very soon from the other ailment you are going through. I know mine was a very stressful. Well, it started very awesome, right? My weekend before we start doing Okay, so good afternoon. Right, this is gonna take a while to adjust. Good afternoon, for those in Eastern time. So it's the weekend for me and Garden Bot started like a normal. We were absolutely adulting on Saturday. We got up, we got things done. We decided to go to Costco. Of course, where else would we go? So we went to cost adulting to the maximum to restock pretty good the house because we were running out of some stuff, and because of this, stuff that's going on, the tariff situation, and that's all I'm gonna say. We decided to top up things at home, so if the cost of stuff goes up, we don't suffer as much. So okay, we went to Costco. We spent a lot of money, but it is what it is. You gotta eat. You gotta have stuff at home. It is what it is. That's life. That's adulting. Um, oh, I hope everyone does, Forrest Nelson. I hope everyone has their foil hats to protect themselves from Lori. I think in terms of the trial, I'll get to it in a minute after my long story. But we'll just enjoy, see whatever happens, and we're just gonna have. Oh yeah, I do need my candy. Yes, I gotta have. Yeah, of course. I need to have my candy, Zizzy. How am I surviving this crazy hours that I'm doing? So what I was gonna say, so we were adulting, we came home, we put stuff away, we fixed our living room because it was absolutely dumb site. It was bad. So we got rid of an old sofa because we got a new sofa, but the new sofa was still in the box, so it's just oh, burning bush piles. Oh, better be careful. Oh, adulting, because we adulted so hard. So we got rid of the old sofa, and that old sofa went to my in-laws, right? So Garden Bot dismantles it. I help him moving out, putting in a van. We go across to their house, and obviously we get rid of the old sofa that they had, and we were mounting our old sofa, their new sofa. And Garden Bot was building using all these tools, all until the moment that he is under the sofa. I think it's tightening a bolts or whatever he was doing, and a piece of wood, like those little tiny wood things that come from IKEA furniture, falls on his eye. So, and he's like, at the beginning, he thought it was just like a little bit thing. He doesn't do much of it, so he rubs it to get rid of it. And he just starts to not scream, but being in a lot of pain. So we immediately get up, go to the bathroom with Optrex. I think you guys have it like an eye wash. We try to wash it out, to obviously to get rid of what it is. It doesn't work. I make him sit down, making him a cup of tea, of course, because everything in England it's fixed by a cup of tea. And that was a joke. And I set him down and everything, and it's just to see if it goes away. It doesn't go away. He's in a lot of pain. But stubborn as Garden Bot is, he needs to finish the sofa first before we went to the emergency room. We call it A&E here, accidents and emergency, while you guys it's emergency room or ED department. Hey, oh hi Hannah, good to see you. Hello, welcome in. So very stubborn, he carries on sentencing, and then finally, I convince him to go to the A&E. So welcome in, Anna. Nice to see you. So I finally get there. We get there to the A&E emergency department. We are there for half an hour, not even that much, saying that it's not like an emergency, that it's, well enough to wait until the next day for an eye infirmary emergency appointment. Obviously, it's a 24-hour service, so if during the night it was worse, we could always go back, which we did not need to do, which was fine. But that night, the Saturday to Sunday night, every time Garden Bot would go somewhere to the bathroom during the night or anything, I would be, "Are you okay? Are you okay?" Like every 5 seconds, because obviously I did not sleep very much that night. The next morning we went back to the infirmary. They checked them out. They did some tests. We spent about 8 hours there to do tests, to do vision tests, and to to dilute eye thingies in his eye, just to make sure that his vision was so but the thing is, I got worried. I get very worried about people, and Garden Bot is my husband. I love him, so of course I'm always 8 hours. It was excruciating. It was absolutely excruciating. We finally get home. It was about time for me to go to bed because I started my new hours today. So because I'm recovering the Lori Vallow trial out of Arizona, court starts for me at 7 p.m. and finishes at 1 p.m. And after 1 a.m., sorry, 7 p.m. to 1 a.m. And then I go straight from court finishes. I have a coffee, change, and then go to work for 2:30 in the morning until 8:45. And then I come home, sleep, and do all of it again. That's going to be my new hours. And then it started yesterday, so I had to sleep. So literally, my Sunday was spent in the eye infirmary department, which was awesome. I did a couple bits over on my phone while we were there, but it was absolutely boring. I do not recommend. So I kind of hope everyone had a kind of better weekend than me. Basically no sleep, yeah, because I got home this morning at 5 to 9 in the morning, and I was like, okay, let's go to bed. Everything in the house, all the curtains were closed because we have all like what was it called? Oh, English, what's that? the blackout curtains, blackout curtains, and we have all that through the house. Yes, definitely. 0 out of 10 do not recommend. Yes, to block out natural light so I could go sleep. And I have an eye mask. I go to bed. Okay, let's try to sleep. No, I was like, 1 ship, 2 ship, hey, macarena. Yeah, definitely did not sleep. So I got up, I was like, okay, let me try to do something else to, like, get my head around, tired, to try to do it again. Nah. Finally, I'm here on my desk, relaxing, settle down, I fall asleep. So I had the very uncomfortable 1 hour nap in my chair. In this chair. The chair is comfortable, but not to sleep. Do not recommend. 0 out of 10 recommend not sleeping in a chair. So, I know, I appreciate that. I was like, oh, an email. And it was so weird. I was texting people, and like people who were awake was your guys' evening, my very early morning. Oh, but honestly, today I had one of those days, because then I got to work, right? This is the last story before we get back, start watching the Daryl Brooks hearing from Friday that we did not do because I was too tired, and I apologize. Before we start watching that, because we only have an hour until Lori starts, because you guys know I could talk for an hour very easily. So I need to shut up and start doing the Daryl Brooks before Lori. But like I was saying, so I got to work. It was about 2:15 in the morning. I go early just to make sure that, I have time for my colleagues to come and open the door for me, so I can get in and, like, settle in at work. I was a half an hour banging on the window, like, so someone can hear, and I called the person about 25 times. No answer. Banging on the windows, banging on the doors. No one listening. Half an hour. I was like this close to just like, I'm just gonna go home. No one is answering me. So yeah. Oh yeah. That's today we are. Hi Tracy Kane. Welcome in, my friend. So yeah, we are definitely on a pro se day, because there's bombastic news out of the Daryl Brooks and trial as well. So it's crazy. And welcome in, Tracy. Nice to have you. Thank you very much for being here, girl. So yeah, so I got distracted. 25 calls it took me to, like, actually get someone's attention to be able to get into the into work, which is absolutely nuts. But hopefully today it's not gonna be as bad. Tonight, tomorrow night, whatever, next time that I'm in at work, it's not gonna be as bad as it is. So we're gonna start by watching the Daryl Brooks motion hearing from Friday. It is about an hour long. We can try to speed it up if you guys want to. But even before that, we have a new counter for Lori. So we are gonna be counting the many times that the attorney is gonna say not giving you legal advice during the trial, which probably it's gonna be a lot, because after what happened with Daryl Brooks, probably it's gonna be a lot. So that's our new counter, but I'll remove it for now because we're not on trial yet. But we are gonna start watching the hearing. Let me know how the sound is. I hope you guys enjoy, and yeah, okay. I'll be whispering in your ears, Izzy. Okay? No, I'm joking.
Room, please. State by Leslie Beasy and Zach Wichow.
Good afternoon. Attorney Michael Covey appears. Mr. Brooks appears in custody via Zoom.
Mr. Brooks, can you see and hear the court? He's giving me a thumbs up. Are you able to also see your attorney through the Zoom?
What was that?
Are you also able to see your attorney on Zoom? All right, and that's a yes, sir?
Yeah.
Can you answer verbally, please?
Yeah.
Thank you so much. And Any objection to appearing remotely today, sir?
No.
And has the state complied with victim rights?
Yes.
As everyone is aware, the court is live streaming through the Daycast function of Zoom that CCAP has made available for circuit courts in Wisconsin. And we've been able to verify it is up and running. If at any point in time anyone gets word that it is not, please let me know. We are here today to address a motion to withdraw that was filed by Attorney Covey. I do want to ask you a number of questions. The first question is it your understanding that Mr. Brooks would still like you to pursue this motion?
Yes, Judge.
All right. And Mr. Brooks, could you also confirm that for me, that you are seeking Attorney Covey to be relieved as your attorney of record for your appeal?
Yes.
For purposes of today's hearing, District Attorney Basie, do you agree, or is there any dispute that Mr. Brooks is indigent?
I have no information to say otherwise.
All right. And do you have any dispute that we are concerned with Mr. Brooks's direct appeal rights at this point?
No concerns.
All right. Do you agree with those two issues, Attorney Covey?
Yes, Judge.
All right.
He's absolutely indigent.
He's in custody. He's serving consecutive life sentences. He's indigent, and initially, even when he was the accused, was eligible for public defender representation. And do you have any information, Attorney Covey, that would suggest otherwise?
No, Judge.
All right, thank you. Then let me start with some questions. What I intend to do is I want to make a record of a number of things related to the inquiry that this court must make under the law. I think it's important to start with directing the questions to counsel, because as of right now, you do represent Mr. Brooks, and then I intend to address some questions to Mr. Brooks as well. Attorney Covey, have you received and have you reviewed the February 26, 2025 letter from the State Public Defender's Office?
Yes, I have.
Are you aware or have any knowledge of whether that letter was received by Mr. Brooks?
It's my belief that it was sent to Mr. Brooks and that he has received it. I haven't confirmed that with him personally, though.
All right, I intend to do that in short order. Is it true, Attorney Covey, that you were appointed for the purposes of investigating and pursuing potentially an appeal for Mr. Brooks on January 6th of 2023?
Yes, Judge. I was appointed for post-conviction and/or appellate relief.
Thank you. And what have you reviewed in your work on this case thus far?
Judge, I have spent probably hundreds of hours. I know this past summer, the vast majority of the summer, my free time was spent reviewing this case, including all of the transcripts, the entire court record, the vast majority of the discovery. I'll make a record of that. There's certainly, when we get provided with lots of audio and video evidence, not all of it is directly relevant to the offense. If, for example, if there's a squad video that's just pointing against a wall, I'm not going to spend hours reviewing that. But the key evidence, the interviews, the court exhibits, I definitely reviewed all of that discovery as well. We have about 5 banker's boxes of materials that I have gone through, including the prior attorney's notes before Mr. Brooks went pro se.
Have you met with Mr. Brooks either in person, by phone, or in any other way?
Judge, I have, and of course I can't talk about the substance of that, but I have met with them in person several times, plus numerous phone conferences as well. I haven't counted, but a large number of contacts.
Have you had written communication with him as well?
Judge, I'll write him letters. Mr. Brooks and I would generally communicate via the telephone, mostly telephone and in person.
Have you sought a number of extensions from the Court of Appeals related to the timing of filing any post-conviction motion or direct appeal?
Judge, I have basically two groups of extensions, if I may explain.
You may.
The file is huge. And so it definitely took me longer than normal to review the contents of this case. And so the first few extensions were just to get me through the summertime where I was able to review all those bankers boxes of materials. The second set of extensions were filed so that Mr. Brooks, after him and I had fully consulted each other, would have time to decide how to proceed. I know one of my more recent extensions was to give Mr. Brooks the opportunity to try to hire a different attorney if his family was able to do so. That's part of the public record, of course. So those are the two groups of extensions that I filed over the course of the last year and a half.
Do you know how many?
The most recent extension was the 7th motion to extend time. That was to give, I'm sorry, my apologies.
The record shows that on
I think there was
February
8.
14th, the 8th motion to extend was filed with the Court of Appeals. Would that seem accurate?
Yeah, I misspoke. It's the 8th motion to give Mr. Brooks time to litigate his case. In the event that I withdraw, he'd have a couple of extra months to review the file and to do his own research.
Again, I understand that you can't discuss confidential communications with Mr. Brooks as his attorney, but generally speaking, have you identified issues to pursue on appeal?
Judge, I can say this. There were several very specific issues that I spent an enormous amount of time researching for appeal as to whether or not there were viable post-conviction or appellate issues. I'm not able to say without breaking privilege.
Have you sent Mr. Brooks any drafts of pleadings related to any appellate or post-conviction issues?
Judge, since I haven't filed an actual appellate brief, we haven't done the notice of intent to appeal, nor an actual post-conviction motion, there wouldn't be any pleadings for me to send him. So we're at the point, if I may give a little bit more elaboration, usually it's a two-step process for post-conviction relief. The first part's actually the longest. It's assembling the court materials. I know the court reporter worked exceptionally hard to get me those materials, but that took a few months. Going through those materials, identifying issues that could provide post-conviction relief. In some instances, there are no grounds for post-conviction relief, and then there's a different set of options that I would go through with the client. So after going through all of those steps, I did have multiple contacts with Mr. Brooks, both in person and over the telephone, for him to decide how he wants to proceed. I'm not able, even if hypothetically I found 5 amazing viable grounds for post-conviction relief or appeal, I wouldn't be able to submit any post-conviction motion or notice of appeal without the consent of Mr. Brooks. If I found no grounds for post-conviction relief, then again, Mr. Brooks would have a set of options that I would have to go over with him. And I can say that we have gone through that process, and he has requested to proceed pro se, which would prohibit me from filing any further pleadings in this matter. I hope that clarifies the issue.
Well, it helps because my responsibilities ultimately when discussing with Mr. Brooks is to talk about the options. One option could be a no merit situation. So I generally just want to know if all options have been discussed with him at this point.
Absolutely, Judge. That I can say 100% certainty. And multiple times.
Is it your understanding that Mr. Brooks wants to proceed pro se or on his own, or as he sometimes referred to it as in pro person, I think was the phrase he used with some frequency.
Judge, he does want to represent himself moving forward.
Have you discussed with Mr. Brooks your background as an attorney and doing appellate work?
Judge, I don't, it's such it's a innocuous question. There's no issue with me answering it, but I'm afraid that if I were to go into any discussions.
Let me ask it this way.
Yeah.
So I would like Mr. Brooks, and I'd like, actually, let me state it this way. I would like the record to reflect your experience for purposes of my decision here today. So I'll just ask you some general questions. They would not in any way violate any type of attorney-client privilege. First of all, how are you a licensed attorney in the state of Wisconsin?
I hope so. Also, I'm in a lot of trouble today. Yes, ma'am.
How long have you been so licensed?
Approximately 20 years, actually 22 years, I believe.
Do you hold licenses in any other states or have permission to appear in any other courts outside the circuit courts, appellate courts, and Supreme Court in the state of Wisconsin?
Judge, I did take and pass the Illinois State Bar, and I was part of that community for a few years. I let that lapse because I have solely practiced in Wisconsin.
What about federal courts?
Judge, I was trained to do some federal courts, and I was actually accepted to be an attorney in the Western District. Then COVID struck, and the caseload for the states became so extreme for lack of public defender appointments that I never ended up practicing in federal courts.
Do you have any area that you focus on in your practice?
Judge, I focus mostly on homicides and sexual assaults, if I may. The state public defender's office, let me backtrack. I'm not a public defender. I'm a full-time criminal defense attorney. For most of the last 20 years, I had my own practice. Recently, I joined Corey Chirafisi for his law firm, CHIRAFISI. For most of the last 10 years or so, I have been practicing mostly homicides, class A, B, and C felonies.
Give me 1 second. Mr.
Sure.
Brooks, would you please direct the camera up? Thank you so much. I appreciate that.
Judge, the State Public Defender's Office has certifications to take certain levels of felonies. The highest level of certification is Class A felony, and I'm certified to do those in both the appellate and the trial court level. Approximately 20% of my work is with appellate work. I'm in trial more often as with the circuit courts.
In your litigation practice, both in the circuit courts and appellate courts, that's both through appointments and individuals who would privately retain you?
Absolutely. I have the highest level of certifications the Public Defender's Office can give.
Thank you. Have you had any general discussions with Mr. Brooks related to appellate rules and procedures, whether it be formatting, initial briefs, what response briefs are, the requirement for reply briefs, or even the difference between that and a post-conviction motion?
Judge, let me just say this again. I've certainly had lots of conversation with I've spent hours with Mr. Brooks in person and over the telephone. I'm going to speak in very, very general terms. The vast majority of those conversations have to do with the substance of the case itself, the issues that I was researching on this case, and there were some very specific issues which I'm declining to say now for privilege reasons, but that I was researching on this case, going over the case law, meeting with them to discuss lots of different issues. Certainly as part of that, I would have, with every one of my appellate clients, I would have conversations about basic appellate procedures, such as the difference between a post-conviction motion and going straight to the Court of Appeals and why that would occur. That is, as to the details of drafting a brief, rules of citation, the fonts and procedures that you have to do to submit an appellate brief. I, of course, have not had those types of conversations because it was my intent that if there was an appellate issue, I would be drafting that brief. I can say this, and I'm happy to do this to allay the court's concerns. Certainly, it's my intention to send Mr. Brooks a copy of the rules of appellate procedure for Wisconsin. We'll make sure he gets that. Additionally, in my experience of doing this for a long time, though the Court of Appeals will still hold pro se defendants to the letter of the law and the substance of the case, they won't give the pro se defendants any breaks on the substance. If there is an issue with page numbers or citations for a handwritten brief that would be submitted by a prison facility, I've never seen an issue where the Court of Appeals has objected to that. They're a little bit more lenient on those issues for obvious reasons.
Thank you. That was I don't want to say a concern, but a question I had, and that's good to hear. So thank you. Is there anything else you want me to consider in light of the motion that you filed with the court?
Just that I'm not, even if I was allowed to withdraw it today, I'm not going to close the file until Mr. Brooks has the entire file. I was speaking with our paralegal staff just yesterday, going through multiple bankers boxes of materials. The facility where he's being kept at right now will not accept those materials. It's just too much for them to take in. However, if we scan them, download them, and put things on hard drives, multi-gigabyte hard drives, we can send those out. So it will be a very lengthy, time-consuming process for us to do so, but I'll make sure Mr. Brooks gets those materials with one caveat. Because of the time and expense to do that, we wouldn't be making multiple copies. So if something were to occur where Mr. Brooks would want another full set of materials, perhaps 8 months from now, it would be challenging for my firm to comply with that request.
So let me make sure I understand this. The prison facility at which Mr. Brooks is currently serving his sentences will not accept the volume of material that you have in paper or even standalone electronic other than on an external hard drive. If
we sent them disk and flash drives, I'm very confident the prison would accept that. But they made it clear to our office, and it was their staff speaking with my staff, that they would not accept, if I were to ship 5 bankers boxes of materials, they would not accept that. But if we put those materials on computer electronics, then they would have a place where they could store it safely and easily, where Mr. Brooks could access it in their library.
It is not a secret that Mr. Brooks is no longer being held in Wisconsin. If he were in Wisconsin, would you have had better access to him in terms of going to the facility, even with your own computer, and as his attorney showing him discovery if need be? So
I was able to visit Mr. Brooks at the Dodge Correctional Institution, and additionally at the Wisconsin Secure Program facility in Boscoville. The prison facilities made it very easy for me to do the visits. I was able to bring my case files. I wouldn't have brought that volume of materials to a meeting anyways, had I desired to go through any piece of audio video evidence. There would have been a mechanism for me to do so in Wisconsin. If hypothetically, if I were to remain his attorney, I am able to have telephone and Zoom conversations with my clients. It would be a little bit more onerous for me to do in-person visits.
If you were able to do Zoom, you obviously can share screen, even information from your computer.
If that's what we wanted to do.
Do you know what, if any, materials Mr. Brooks was able to take with him from his trial to the facility where he is at?
Mr. Brooks might be able to answer this better than I will, but it's my understanding that somehow along the way, when he was transferred out of state, he no longer has those trial materials. So we would be working to give him a complete set of what we have. And that would also include downloading all the materials from the e-file and putting that on a separate flash drive as well.
But you're willing to do all of that?
Yes, we will get extra funding from the Public Defender's Office to get extra paralegal support to do that.
And they're willing to do that as part of the case closure should this motion be granted?
I have not put in that request yet, but I am certain they'd be willing to do it. They've done it before on other cases that were also very serious cases. I'm sure I can get the funding.
All right, thank you.
And frankly, if we didn't get the funding, we would do it anyways.
Well, I appreciate that. Thank you. All right, Mr. Brooks, I'd like to ask you some questions. First of all, are you aware that Attorney Covey has filed a motion to withdraw as your appellate counsel?
Yes.
And just as a reminder, even though I tried my best to talk to you at my cameras, when I want to watch you for your response, I look slightly down and to the right, or even to one of the other monitors that I can look at. So I just want you to be aware that when I do that, I'm actually paying attention to you. Any questions about that, sir?
No.
All right. Do you want to have Attorney Covey withdraw and act as your own attorney, sir?
At this time, yes.
The Public Defender's Office sent to this court a letter dated February 26th of 2025. It is front and back. I think the actual filing had some additional information on the third page, but that had more to do with who was copied on the letter versus the crux of the letter. But did you receive a copy of that, sir?
From what was the date?
February 26th of 2025.
I don't believe I received that.
Mr. Brooks, would it be helpful if at this point I switch to a single camera when I'm talking directly with you instead of having the multi-camera view?
I can see you just fine.
Okay, great. So I'm just going to read the letter into the record, sir. It's important. It is from Kelsey Loshaw, the Regional Attorney Manager from the Madison Appellate Office. Does that ring a bell at all?
I think from previous letters it might, yeah.
Well, this one is specific because it was filed after the motion to withdraw was filed, and there's a requirement in Wisconsin Statute 809.30 that the Public Defender's Office advise the court of certain information. Does that help ring a bell, sir?
No.
All right, then bear with me. I will read the letter. It says, "Dear Clerk, in accordance with Wisconsin Statute Rule Section 809.30 sub 4 sub B, I'm writing in response to the motion to withdraw filed by the SPD appointed appellate attorney Michael Covey. The rule requires the SPD to determine whether successor counsel will be appointed and notify the court of the determination. I ask that you pass this on to the judge assigned to the case because the judge is required by Rule 809.30 sub 4 sub C to consider the SPD's response prior to ruling on the motion. The state public defender informs the court and Mr. Brooks if the motion to withdraw Mr. Brooks directed Attorney Covey to file is granted, Mr. Brooks will be waiving his right to public defender representation, and no new or successor public defender attorney will be appointed." Sir, have you heard what I just read to you?
Yes.
Are you aware of the risk you take as it relates to to a public defender appointed appellate attorney if this court grants the motion to withdraw?
Yes.
Do you have any questions for me about that?
No.
The letter goes on, an indigent person's right to an appointed attorney for appeal does not encompass a right to an attorney of choice or to successive appointments. State v. Evans, 2004, Wisconsin 84, 273, Wisconsin 2nd 192, paragraph 30. If a defendant decides he no longer wants to be represented by an appointed attorney, he has the choice of terminating counsel's representation and proceeding pro se or with retained counsel. Id at paragraph 31. If a defendant elects to discharge his appointed attorney and proceed pro se, the defendant must be provided clear warnings regarding the dangers of self-representation before appellate counsel may withdraw. Id. Sir, did you hear me read the second paragraph of this letter?
Yes.
Do you understand it?
Yeah.
Do you have any questions for me regarding that?
No.
The letter goes on to provide the legal framework for the court's responsibility in determining whether a defendant validly waives counsel on appeal. And I'm going to read that paragraph. It is a direct quote from a case, State v. Thornton, 2002, Wisconsin Appellate 294, also found at 259, Wisconsin 2nd 157. For your information, State versus Thornton is a Court of Appeals case that dealt with an issue for the first time in Wisconsin in a decision dealing with the court's responsibilities in determining the waiver by a defendant of counsel on appeal. And in that particular case, and this paragraph starts out by giving a little statement about the state's summary of the issues. The state offers the following synthesis of the foregoing decisions. Before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, 1, of the Flores rights, parenthesis, to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report, parenthesis, 2, of the dangers and disadvantages of proceeding pro se, and 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. The court went on, we agree with the state that ensuring a defendant has received and understands the listed information is both necessary and sufficient to support a determination that the defendant tendered waiver of counsel is knowing and voluntary. In that particular case, the issue or the procedural posture was that the appeal was already pending. And so the Court of Appeals had some further things to say about the communication with the defendant being written. That's not applicable here. I'm having a over Zoom face-to-face discussion with you, but this is the framework that will guide the questions that I ask. Do you understand that, sir?
Yeah, I'm familiar with that case law as well.
Thank you. Any questions for me thus far?
Nope.
All right. So I just want to confirm, sir, did you ask Attorney Covey to withdraw?
Yes.
Did he send you a copy of the motion to withdraw?
Yes.
Have you reviewed it?
Yes.
Do you have any questions about it?
No.
Do you take any issue or claim made by Attorney Covey in dispute?
No.
Did you at any point in time tell Attorney Covey you're fired?
No.
All right.
Judge, if I could just clarify something. The conversations I've had with Mr. Brooks in every instance, they were quite respectful. There was no arguments. So when Mr. Brooks would ask me, when he asked me to withdraw, it was in a polite, respectful way as opposed to a "you're fired, get out."
Great, thank you. I appreciate that clarification. I still wanted to ask from his perspective. All right. Any dispute with what Attorney Covey just said, Mr. Brooks?
None whatsoever.
All right. Why do you want Attorney Covey to withdraw?
Judge, if I may, Mr. Brooks, this question could cause into some privileged information. You have every right to answer the question. You and I have had lengthy conversations about the substance of particular issues that I have looked at and my conclusions on those issues. I don't think it would be to your advantage to go in that direction. You can definitely answer the judge's questions, but I would just be guarded as to going to the substance of any legal research that I may have done, that I did do. Thank you, Judge.
You're welcome. I appreciate that. I can ask it in a more general way. Mr. Brooks, again, understanding the caveat that your attorney has given you, how would you characterize in general terms the reason you want to proceed pro se? Is it a strategy disagreement, or do you simply just want to represent yourself pro se?
I just want to represent myself.
So let me ask you some real specific questions then about some access to research materials and other things. I believe these questions go to your understanding of the difficulties and disadvantages as a pro se appellate litigant. Most of the time, well, if you file in the Court of Appeals, it is a written process that may or may not include appellate arguments in front of the court. Do you understand that?
Briefly, I understand the outline of what you're saying. Yeah.
So you're prepared to follow the rules and procedure of appellate procedure and submit written submissions, whether it be to the trial court or to the appellate court related to your post-conviction and appellate rights?
Yes.
Do you have, or what access do you have to legal research at the institution at which you are currently serving your sentences?
Honestly, not very much. It's very different. So it would take some time, and maybe a few conversations can be had in that area, but I mean, I don't know if that answers your question.
You've answered it. Thank you. Do you understand that could lead to further delays in your appeal or post-conviction motion?
Yeah, I do understand that. I kind of anticipate that with where I'm housed. It's like I said, it's a lot different. Things are done totally different here. So I'm aware that could pose some issues.
You don't dispute that you're no longer in Wisconsin serving your sentences, correct?
I'm sorry, can you repeat that?
You agree, I earlier said you're no longer in Wisconsin serving your sentences. That's true?
I would rather not say.
Judge, I can verify that he is no longer in Wisconsin. The Department of Corrections had requested me personally not to disclose his location. Of course, it's up to the court. I'm sure at some point it's going to get out. But I just had a conversation.
Let me answer that for a second, because
Sure.
we can take a brief segue.
Sure.
I am treating Mr. Brooks no differently than I would treat any individual who's serving a sentence in the state of Wisconsin. I repeatedly asked the Department of Corrections for information where he was at. I am a separate but equal branch of government, and they thwarted my efforts. I was only told he's in South Dakota and given email addresses for individuals that we could have contact. I need to be able, as the court, to send communication to him directly. That would be no different for any other inmate in the state of Wisconsin, whether they have an attorney or not. So today I directed my clerk to send an email to South Dakota and ask them for the information. It was provided and it is on CCAP. I have received no requests to seal an address. I have received no legal authority from anyone and no request. And so I'm treating Mr. Brooks the same that I would treat any individual, and that information is now on CCAP.
Thank you, Judge.
Mr. Brooks, do you believe that despite some of the challenges that you've described or at least stated about access to research, that you'll be able to overcome that if you are representing yourself?
I mean, like I said, it's going to be difficult, but there are conversations that I'm sure can be had to aid me along the way. But I mean, I have to be honest and say that it will be very difficult.
But do you understand that's the risk you willingly take if you want to be your own attorney and proceed pro se?
It's a risk. It's a risk regardless whether I was in Wisconsin or not. It's just going to be, the question was based on where I'm currently housed, which is more difficult than if I was still housed in Wisconsin.
I understand what you're saying. I'm aware, but do you acknowledge, sir, that that is a risk that you willingly take by asking if I approve the motion to withdraw and you appear as your own, you proceed as your own attorney? Do you understand that?
Yes.
All right. And again, I'm not trying to be nitpicky here. I'm trying to make a record, and I believe it goes to the dangers and disadvantages of being a pro se appellate litigant who is serving multiple consecutive life sentences, meaning you're in custody, further complicated by the fact that you're serving those out of state, and you don't apparently have the same access to resources as you would in Wisconsin. Do you disagree with anything that I just said?
No.
I want you to be aware, sir, that you have the right to counsel on direct appeal. Do you understand that?
Yes.
Do you have any questions for me about that?
No.
As you know, Attorney Covey was appointed by the State Public Defender's Office, meaning at the government's expense, to investigate and review your appellate options, and that the Public Defender's Office, through that letter that I read to you, has advised they will not appoint successor counsel under really any circumstances. Do you understand that? You want me to restate that?
No, I said yes.
Oh, I'm sorry, I didn't hear you. You covered your mouth, so I couldn't even see your mouth moving. All right, you understand that, sir?
Yes.
Do you have any questions about that for me, sir?
No.
The right to counsel in this circumstance, and I'm referring to not only 809.30, but the Wisconsin Constitution, Article 1, Section 21, includes the right to a direct appeal, the right to assistance of counsel for the appeal, and includes such thing as the right to opt for a no merit report and abandon an appeal, essentially. Do you understand all of those things?
Yes. Yes.
Thank you. The right to counsel, however, does not include the right to appointed counsel of your choosing. Do you understand that?
Yes.
It also does not include the right to insist that your appellate attorney pursue issues which he in his professional judgment choose not to advance. Do you understand that?
Yes.
In other words, if the only dispute, let's say, is over strategy and you change your mind later on, that's in that circumstance, the SPD will likely not reappoint. I mean, they've said that in their letter. You can change your mind, you can have remorse, regret, you could try to find your own retained attorney, and if that doesn't work out, that once this court grants the motion to withdraw, they will not appoint successor counsel. Do you understand that?
Yes, and to be clear, there was no disputes between me and Attorney Covey. So there was no strategy disputes. There was nothing of the sort.
Sir, I know from presiding over a previous hearing related to the waiver of attorney that we spent a fair amount of time going through your background. And I just want to confirm a few things with you. You can read, write, and understand the English language.
Yes.
You completed high school through the 11th grade and obtained an HSED. Is that also true?
GED.
A GED. All right, thank you. Are you currently taking any medications that would interfere with your ability to understand what is going on?
Not currently, no.
All right. Do you have any medical issues that would interfere with your ability to understand what's going on today?
No.
Are you under the influence of any alcohol or drugs today?
No.
It is also true that throughout the trial in this case, you represented yourself.
Yes, that's true.
Is there anything about this court hearing thus far that you have not understood?
No.
Are you asking this court to allow Attorney Covey to withdraw as your attorney of record?
Yes.
If you change your mind, I want to confirm once again that you are aware the Public Defender's Office will not appoint successor counsel.
Yes.
Are you aware that if you can't hire or retain an attorney on your own, the Public Defender's Office will not appoint successor counsel?
Yes.
Do you understand, sir, that you will be responsible for all aspects of your post-conviction litigation and appeal, including compliance with all court rules and procedures?
Yes.
Anyone make any threats or force you in any way to waive your right to an attorney in this case?
No.
Anyone make any promises to you in exchange for your waiver of right to an attorney?
No.
Do you believe you're making the decision to waive your right to an attorney freely, voluntarily, and intelligently?
Yes.
Do you need any more time to talk to Attorney Covey regarding your request that he withdraw?
No.
Do you further understand you may need to file motions in the Court of Appeals seeking an extension of time? Given the most recent extension goes to June 3 of 2025.
Yes, I'm aware. I didn't know it was that soon, but yes, I do understand that.
Judge, may I jump in for 1 second?
You may.
Thank you. And just for the record, we have sent Mr. Brooks copies of all of our extension motions and the Court of Appeals decisions. What I will do for Mr. Brooks is I'll send him again that my most recent extension motion that he can use as a template. And I'll include a closing letter with the instructions as to how to file that and to use a pre-appeal case number, some of the basic procedural issues that might help him understand the difference between a post-conviction motion and going straight to the Court of Appeals. Is, from my experience, the Court of Appeals is pretty lenient in giving at least several extension motions to pro se defendants. At some point, they'll put some harsher deadlines on. It's a gray area, but I am very, very confident that he'll have more time than June 3rd if he makes a proper request to have more time. It might take a couple of weeks for us just to get at those files to him. We've been working on it.
Mr. Brooks, do you understand that if the court permits Attorney Covey to withdraw today, you would be responsible to file the next extension request?
Yes.
And you are prepared to do that?
Well, once I receive the templates that Attorney Covey is going to send me, yes, I'll be ready to do that.
You understand he's not required to do that. He's just offering to do that, and it would not.
I know.
All right. You understand that's still something you are responsible for, whether he sends you that template or not.
Yes.
Is there anything else you want me to know or consider today, Mr. Brooks, as I consider the motion to withdraw?
Not really. I think everything was pretty much covered. Just understanding should be there that, you know, again, this facility is a lot different. So there are different types of hurdles that I've already seen that I would have to jump over to be able to get things done. So I just want that to be stated for the record, that it's just a lot different, and there's a lot of different procedure wise things here. So I'm still navigating that, as I haven't been here that long. So I'm still learning as I go. So that's it.
And you're willing to take on your own case with that difficulty and those challenges related to the institution?
At this time, yes.
Attorney Colby, anything you think I've overlooked here today as it relates to this motion?
Judge, I'm very satisfied with the colloquy. I think just to make a record, I have just one other issue. If I may ask Mr. Brooks a quick question.
Go ahead.
Mr. Brooks, I know you talked about that there are some difficulties. I just want to make sure, are you still allowed to have access to your legal files?
So the legal files is something that I haven't been explained. I didn't know that there was conversations about the whole flash file thing. I haven't even heard anything about that. I really don't know how. Somebody maybe here can explain to me how that will work. So I'm kind of like trying to figure it out myself, actually.
Attorney Covey, it's my understanding, based on what you've said, I mean, you believe the institution will accept the external hard drives, obviously any paper that you send through regular mail, just not banker boxes or large boxes full of materials.
Yes. So if I were to send them a 40-page packet of materials with appellate rules of procedure and an extension motion template, I think any facility would allow that to be processed through, so long as I don't have clips or staples. As for, but they balked. My initial email, I don't have this memorized. I don't want to make a false statement, but my initial recollection when I first contacted that prison facility was to say that we were going to send them the files. I was told they would accept the file, but then when I stated, or when staff stated that it would be 5 bankers boxes, they put the brakes on that. And then there was some correspondence between their legal staff and my legal staff as to the best way to do this. We'll likely be buying some terabyte hard drives to put the materials on that to send to him. I don't know how much access you'll have to the library. I know in Wisconsin, you can go in almost every prison facility, unless you're in some kind of segregated status for a fight, for example, with another inmate, that you can make reservations to go to a computer library to review your legal documents. I also know that the time is quite heavily rationed. He's not going to have 8 hours at a time to look at these documents. So that will be a challenge for him.
I was just going to say that too. There's no law library, which I've never seen a jail or a prison without a law library. So I don't know how that's going to work.
Do you have access to anything through a computer or online to access research material?
I have access to look at, I believe it's Westlaw, and those are tablet based. But even that is challenging.
I use a tablet-based Lexis. It's a similar platform. It can be cumbersome unless you know how to switch to the natural language search engine and how to limit the jurisdictions and what you're looking at. But I think it's similar to what you had when you were in Waukesha, is that not?
Hello everybody, sorry about the pause, but we've got movement already from court, so I'm just gonna swap feeds. We're gonna chat it up a little bit until it kicks in properly, until the date starts, but here we are on the stretch for the openings for Lori Vallow. Here it comes. Counter is up on the screen. Feed is coming up in a second. If I press the button, it will actually do it. So, and it is here. Feed is here. Feed is here. I cannot wait. This is like the Super Bowl. Is this what people that watch football feels like to watch the Super Bowl? No, I'm joking. I do watch football. This is what I watch soccer more than football, the American football, but yeah. So, I know. Like, to be fair, in terms of spoilers, there hasn't been much of that's a nice and there's not been a lot of tweets coming out from court, so I don't want to spoil it what happened or not what happened. There's some things that has happened, but I don't know if it is on camera or not. But if it doesn't come on camera, I'll explain what it is. Obviously the things that are not on camera because it's on Twitter. Hi William, hello, welcome back. Hello, good morning my friend, good morning, afternoon, hello. What happens on like sidebars and everything like that, I will be saying I'm not spoiling what is already happened, but will happen during sidebars because we're not going to be able to hear those. Not even the courtroom, but there's a couple bits that are outside of the presence of the jury and whatever that is that we can now, people are going to be tweeting about, and I'm going to be reading that out to you without spoiling what it is. So kind of more like that. So just a reminder, court is on a half an hour delay, so by court mandatory rules, so we are going to be half an hour behind of everything that is already oh, that's great, Mel. You don't get any spoilers. To be fair, it's nothing like major happening. So like I was saying, court is on a half an hour delay, so it's gonna start in about 5 minutes to start, which will be 2 p.m. Eastern. Court will finish at 8 p.m. Eastern time. They will break around 12 p.m. local time for an hour and a half break. What is going to happen is they're going to start for 1 hour and a half until 12, have an hour and a half break, then come back for the rest of the afternoon. So that's going to be the schedule, and the court is going to be Mondays to Thursdays. So there's not going to be Lori Vallow case on Fridays. it depends on what's going on. I might do a small stream or not, so we'll see how it goes. So just make sure that you have the bell notifications on, so it alerts you when we are live. And yeah, so yeah, thank you very much, Paula. Make sure you like this stream. It does help the channel a lot. And give me 1 second while I take Garden Bot's head off. So, yeah. So no, because I was gonna say I was gonna take his head off because he's building my desk. I really, really appreciate, but he needs to use tools. Oh, you like twice, lol. Well, you need to like a third time, Mel, because you. No, I'm joking. It's fine. It's so great to see you, my friend, as well. Wow, that is awesome, Lilo Miss. That is awesome. That is fantastic. We are on that road to 1K. Yay! Scary, very scary indeed. Oh, I can't see what is that emoji. Do not harm, but I'm pretty sure. Yeah. So, oh no. Oh, I'm so sorry, Paul. I hope it goes better. It gets better and you get settled in. Well, in terms of my camera, obviously this counter has to stay where it has to stay. Oh, coffee. Thank you very. Oh, definitely need that. Like by the mountains. Do you guys want me to say where I am on the screen, or do you want me to move up? Because right now this is what we can see, so I would always be in that little corner, and we're not going to be able to see the names of the witnesses and everything. So do you want to oh, I always need another cup, but I've got Powerade here to help me. And then if I really need, I have 2 of those, so I am prepared. So very, very prepared. Move up. Okie dokie. I will move up. Moving up. Move on up. I'm moving up on the world. Oh no, it's just on the stream that I'm moving up. So, oh, Paula, I am very excited that the nice weather is coming up, so I can start having my iced coffees. I got really into iced coffees last year, and I even had that little tool thing that you can make foam. So I was like, I cannot wait to make iced coffees. I am so excited for that. I cannot not wait for that. So moving up on the east side. No, it's just in the counter, in the screen. So, oh, Mal, but I was literally having so many iced coffees, and sometimes more than once a day, and I did not realize, but for me iced coffees are stronger than the normal hot coffees, so I was just like buzzing all the time. If you think like I'm bad like this and I haven't had any energy drink, I only had coffees, imagine me with Red Bulls or lots of more coffees on me. So yeah, I need the other mouse of the other computer for the counter. If Garden Bot would, sorry, just asking Garden Bot to, thank you very much, because I'm using 2 computers, one for obviously the feeds and everything, and the other one for the counter. Which way did the counter go? Oh, there it is. We need the counter back. So yeah. So that, sorry, just setting myself, because having two computers, two computers, and because right now I still have my old system. It is not the perfect one, but I can't wait for my desk. But we're gonna have to figure out a new layout of the of how we both have our offices. Cause like here you guys can see this screen, it's GardenBot's computer. So if you don't know who GardenBot is, for the new ones, hello. GardenBot is my husband. He's also a mod in the channel, and he helps when I cannot stream. He streams for me, and we call him GardenBot, but everybody knows his name. So yeah. Hey, I know the Jeffersons. I am not that young, Paula. So I'm old too. So I was like, yeah, no, I know the Jeffersons. I do know. I know them. I know them very well. Like, they're my neighbors. No, I'm joking. I do know them. So that is funny, Mel. So Yeah, I was explaining who Garden Bot is. That's who Garden Bot is. Reruns for you. I do want to watch it, but I have no time. There is this new thing that I've started doing called YouTube that occupies all my time, plus working, plus having the house and a garden bot to look after. It's a lot of there's a little bit of movement in core, but not much. There's just watching the amazing ceiling at the moment. So should start soon. I mean, I can leave that up there, so we can see exactly what's going on and when it starts. I am rooting that for the sound. It is as good as it's been in the Linda Sturmer case. I am so hoping that it is that good, because we've been very spoiled with court sounds this last, I think, 2 trials. So yeah, so that's been really good. Which, talking about Linda, oh no, like Lois, you and me are the same. I know a lot of stuff that's not valuable as well. Like, very fun fact, you guys don't have Kinder Surprises, Kinder Eggs, and we do, because Kinder Eggs in America apparently for some reason is illegal, which I don't understand. Why the Kinder Eggs are illegal over there, but if you know, just let me know why. Oh, I'm sure you know very a lot of stuff, Mel. So Lois, tell me,
President, the
why
jury's
do I
not present.
know?
I'm going to ask the
Oh,
state to
hang on.
approach and take a look at a letter from Juror 3's employer and pass it to the defendant when you're done. Sides reviewed the letter? Yes. Go ahead and just give it to my courtroom assistant. Thank you. Juror 3 also called my staff last week after the jury was selected, and the impression I got is Juror 3 doesn't have a problem with jury service. Juror 3's employer has a problem with jury service. So
Well, I think we lost a little bit of the sound because the sound faded a little bit. So, hello, Stephanie. Hi. No, you did not miss anything. Court, we just literally started because they are a half an hour delay. So, literally just started. But yeah, you did not miss anything. You still have your seat saved. Make sure that you press the like button, and I'll do all those fun YouTube things. Yeah. So, Jason, that's for you. If you, yeah. There's stuff going on, but we don't have any sound for some reason. So just hang tight, guys. It is not easy to talk on the phone now. Definitely not. So if you're on the phone, it's going to be a lot harder. So
keep Juror 3 after into the lunch hour individually about whether it's really him versus his employer, and offer to write a letter if he needs one to his employer about the requirements of jury service, and just sort of feel out that situation a little further, but we'll keep him on for right now. Please silence all phones. As I said, we are still missing one juror. As soon as those jurors all get here, we will proceed into the opening statements.
Judge, I did email the court staff about an individual, Brandon Boudreau, who would like to be present. He's in the courtroom currently. He has been noticed by the defendant back on March 6th as a potential witness. He has not been subpoenaed to date. He is here and would like to be present in the courtroom for the trial. I think that the court has previously allowed another witness that the defendant had also listed, reporter Nate Eaton, to be in this courtroom. The court had indicated that if these individuals were not subpoenaed, that the court would look at precluding them. It has been over a month since she has noticed him. He has not been subpoenaed. He is a victim in another case against this defendant. I'm asking that he be permitted to remain in the courtroom today.
All right, let me hear from the defendant.
Your Honor, our subpoenas were with OPDS, so I do not have any. We're looking for some confirmation for when those went out.
Well, is this a witness that is, first of all, have relevant information and likely to be called as a witness?
Yes.
What's the relevant information?
There's several things, but he will be called to talk about things that he was involved with my husband during that time.
Well, has the state interviewed this witness? Or potential witness?
Not with regards to this case. I don't know what he will be called to talk about things means. So I would like a little more information as to what the relevance is of this witness.
He has to have relevant information, which, as I've said, is testimony that makes a fact more likely or less likely. That's an issue in the case. So what fact would you testify about that make it more likely or less likely? Can you give me some sort of specific information that you would expect him to testify to?
Yes, Your Honor. His communications with my husband up to the date of his of this incident.
What would those communications be? And how are they not hearsay?
They're his communications with my husband. That's how they're not hearsay.
Okay, and what type of communications?
Phone calls, text messages.
I meant what substance? Can you give me some idea of the relevant information that he would provide to the jury that would help them make a decision?
Without giving away my entire defense?
Well, we don't just get to call witnesses that, are going to testify about, we talked about the weather that day, so you do need to give me some sort of information about what his anticipated testimony would be.
Well, his relevance in coming that day to do an intervention on me with the family.
Is this witness, Mr. Boudreau, is in the courtroom?
Yes, he is, Your Honor.
All right. All right, let's go on sidebar.
Talking. Right. Oh, Robert, hello. Good morning, my friend. You're not that now. Are you only doing Daryl earlier, so you can catch up on 2X. So Lori just started. We have on sidebar number 1. So Lori literally is just the color is not the great. So, hi, my friend. Welcome in, Robo. Nice to see you. No, she doesn't want to give away the lack of defense that she starts, Jason. But yeah, just a quick thing. So we counting the not legal advice, but we can count two things at the same time. We can count sidebars and we can count the not legal advice because I am assuming that sometimes on sidebar the judge is gonna say to her that she cannot give legal advice. Lois, thank you very much, my friend. I really appreciate you. I think you might be hitting one of our dear friends in the chat that haven't been green. They just lost their greeniness. They look a little bit gray. But thank you very much for that, my friend. I really appreciate the support. I know we've been trying to hit case one for ages. Literally the other day we were trying to yeah, to hit case one. We hit William, but yeah. Oh no, oh, you guys are amazing, thank you. I might cry, it might be a bit unhinged. Oh, hello. Cook bacon and eggs? Yes, we're gonna have some food coming up. Some bacon and eggs. Oh, thank you, Stephanie. Oh my. Hey, Jason! Jason, nice aim, Stephanie. Nice one. Thank you very much. Thank you very much. You got Jason! Nice. Awesome. That is so awesome. That is amazing. Jason, I hope you enjoy the membership and you look a little bit grainy, which is awesome. Well, basically the members videos that I've been doing, it's a look into our like private lives a little bit here and there. So, well, Jason can be on top of still more that is kind of, but that is awesome. Very happy that we were able to hit someone that is active in chat. So yay! I know that is awesome. Exactly. That is amazing, Stephanie. Thank you very much, my friend. I really appreciate you guys' support. You guys are amazing. And definitely giving me the boost that I need to carry on doing, even though it's gonna be a little bit crazy because it's gonna go until the very early hours of the night over here in the UK. But it's an effort that I want to do it, and I am happy to do it. So thank you. I really appreciate it. So shall we count sidebars and not legal advice? Because we can do both. What you guys think? Because like sometimes on sidebars the judge can say that he cannot give her legal advice. So that's what I'm assuming. We can kind of count both depending on how things go. What do you guys think? Yes, no, maybe? Yes, both. Well, both like sidebars and like the judge saying to Lori he cannot give her legal advice. Sidebar. So yeah. Aw, thank you, Stephanie. I really appreciate. Lois, we would be already in the thousands by now. Oh, hello, Fanny Pack. Hello, good to see you. Welcome in, my friend. So, well, in the legal advice could be included the legal advice sidebars. What do you guys think? Yeah, legal advice sidebars. I like that name. Okay, because I need the keyboard. So I'm already putting I will change the name later, because I need the keyboard, but I think Ardenbot might be using it, and I'm talking, and I'm doing two things at the same time. Probably sometimes doesn't work very well. Yeah. So I know for a fact that this is quite a lengthy sidebar, so I think we're gonna be talking for a hot minute. But while hang on, if I know how to spell sidebars, but I keep doing with the wrong mouse. This thing of having two mouses, right, guys? Sorry, give me a second. I'll look into chat. Oh no, what did I do? See, this is not why you should not trust me with a computer. because I do wrong things. Side bars. There we go. That sounds better. Thank you very much, Garden Bot. But now I need to resize the thing. I need to resize. There we go. Oh, it's gonna be quite small, this. Ah! I should not be in charge of doing this. There we go. That looks better. Perfect. Awesome. Right. Now, coming about, like, catching up. Oh, you're just hi, Lady in Grey. Good to see you. Hi, welcome in. It's nice to see you. I'm TCA. Katya, call me crazy. You can call me basically whatever you want. No, I'm joking. So we are on the first sidebar of the trial. So Lori doesn't want Brandon Bordeaux coming into the trial. No, she wants him to be excluded from the gallery of being watching because she might call him or whatever. And the state says that he's not gonna get called and it's okay for him. So they are on sidebar right now to discuss this. So yeah. Oh, you kind of already had us access to the behind the scenes, but now you have a little bit more apparently. But yeah. So, oh, you still try. Well, Jason, it's quite easily for me to help you. We can just see each other in real life, and actually, yeah. So I can sort that out. We can arrange that, and I'm sure we're going to be together pretty soon when the baby comes. So I can always help you out then as well. I know, Robert, I have been waiting for this for ages, and I'm just like, yes, we are here. So it is. Yeah. Hey, look, we talk about him and he comes. Hello, Garden Bot. Welcome in. Hello. Well, I know you hope you are alright. So. I love that, Lois. Oh, amazing. Well, I think it's Charles. Yeah, do not harm. This is about, well, the trial is about Charles, and the Brandon, I think, knew Charles, not Chad. I forgot his name for a moment there. I think. I'm not 100% sure as well, but yeah. I think we do need an iPad emoji, Lois. I think definitely need. So yeah. Oh, thank you very much, everybody, for the well wishes for Garden Bot. We really appreciate it. It was a crazy weekend for sure. Still not like 100% over it, but he's getting better. For sure. Yeah. Brandon was married to Lois. Was one of them. I've lost count of how many husbands she had. So it is gonna get wild. It's gonna get complicated. It's gonna be what? Who? Now there's so many. Oh yes, Melanie, isn't it? Melanie, her name, isn't it, Denise? Yes. So yeah, yes, I remember now. I remember. I did my homework. I literally all night last night while I was at work because I've been doing night shifts because of this trial. I've heard a lot of about this. Yes, Brandon Bordeaux is married to Melanie, a niece of Lori, because there's two Melanies. There's Melanie Gibb and then another Melanie, which is Melanie, I'm assuming, Bordeaux. So yeah, and yes, we have missed you, Denise, for sure. I know you are time with work and everything else, but it doesn't. Yeah, we still miss you, my friend. Glad you're still lurking, but yeah, and I'm glad the training just ended in time. Very, very happy about that. Oh no, I am so sorry, but we'll call you Mel, okay? So, oh, Alex, yes. Oh my days. It's so many players in this trial, right? So many people involved that I have to have a moment to like, who is Alex? Yes, Alex Cox is Laurie's brother that unalive Charles in self-defense and then try to, yeah, I think so. This is just wild. Can you imagine? Like, I don't know if we're gonna cover her second trial. I don't know if I have that strength for it. So, Jason, that is a great idea. You can make an eye patch of his letter work. That's definitely a good idea, for sure. So, ooh, I just got an email that is very, very exciting. Well, try not to show my address, but my samples for the merch is coming tomorrow. I am so excited. So excited. They don't need, so that is awesome. That is great news. But yeah, yes, the Lori and the boys. The thing is, there's so many people involved that in this trial that you need like who's who um paper just saying who is Alex, who is Ad, because there's another guy, another brother from Lori, Adam Cox, that I think is gonna be testifying. He might be testifying. So many key players, so many players in this case. We should change Garden Bot's name to Pirate Bot. Yes, no, this trial is only for Charles Vallow. So Brandon Burdo, it's only gonna be in May, June, something. So it's only for Charles Vallow, this one. So yeah. Oh, I missed something. Sorry, I missed something in the conversation because I talk so much. Um, oh my days. um, ah, thank you very much. See, Denise knows everything. She's gonna be the expert on this case for sure. Um, case one definitely is a pirate. So Denise is definitely is gonna be nominated the case expert. Yes, Denise, verdict expert, case expert for sure. So so it's rather interesting. Um, Sorry, just trying to catch up on chat because it's kind of rather moving a bit faster than normally does. So I'm sorry if I miss anything. I don't do it on purpose, but it's just yeah, this is new to me. So I don't know if Garden Bot is sure of anything anymore. So oh, movement? No movement. It is Stephanie. Well, you are the expert on a Linda stomach case, so but yeah, uh, you are the expert on this one. I think we're gonna have to give it to Denise. I think that she's gonna be the expert for the case. I think that's for sure. Um, I'm still trying to catch things, but probably I've already lost it. There's no point of trying to scroll back. So the fact that like this is not well, we in a way we all experts, Mel. In our own funny way, we are all experts in some things. For example, I'm an expert on absolutely nothing or talking. I literally can talk for England. I'm in England, so that's why that expression and it's perfect. But I literally can talk. There is no way. I think over the weekend I got a certain person that told me that I talk too much. That is just so rude. Telling me that I talk too much. Is that true? Do I talk too much? Like, no, you don't need to answer that. I know. Yeah, I am. We all rock exactly. We all are expert on something or other for sure. This still is a rather interesting one. I am not gonna I'm not gonna say that it looks like a coin that England has, but it does. It's probably, yeah. I need to talk more, Maria. Tell that to the garden bot. Yes, you did. You did say that I'd speak too much, garden bot. Well, I don't speak English to that one there, Columbus. But I'm also an expert of falling asleep in weird places. Yes, exactly. I think so, Mel. Like, absolutely. Yeah. See, Ivamus is an expert procrastinator, which is okay. Sometimes I am too. I literally sometimes leave things to the last minute. Um Jason, now you said the truth. Now you said the truth, my friend. Definitely, according to Judge Beth in Boston, anyone can be an expert. Well, yeah, see, there we go. You know. Oh, you need me to talk like all the time. Um, I'll definitely start. Yeah. Case one. I'll like that is a great idea though. Like, well, you are tempting me, man, but I don't really want to go to prison because then I could not do YouTube anymore, and then people would not listen to me anymore. Um, oh, I can be on the defense and still talk a lot. Believe me, I will find something to talk about. Maria, why do you have to ruin things? No, I'm joking. What did I had that I had vegetables this weekend? Nothing. Sorry, I did not. Your eyes are watering. Oh, that is hilarious. You'll cover if I get arrested. Okay, Robo Romano will take over. Are you really wanting me to get that bad arrested, Robo? That is just so wrong. Oh, okay. But still, you still have the information, Denise. So I'm still an expert. So accept your position, Denise. So veggies at this time of day. What time is it? What even is the time? That is way too early for vegetables. Vegetables, hang on. What time is in? It's 11 o'clock in the morning. Yeah, no, that is way too early. I am so what is it below an apprentice? So it is crazy. I saw that, Rava. Don't worry. Oh, it is 2:27. Well, right now it's 7:27 p.m. here. So it's half seven at night time. Novice, thank you. I'm a very novice. Oh, breakfast and dinner. Wow, that is a lot of veggies. No, don't like that. Don't want that. Thank you very much. I will have once a day, if that much. So yeah, right now it's about half 7 o'clock at night. Remember we only have like an hour and a half of a testimony to go until they go on break for another hour and a half. So that is awesome. Well, no, yeah, yeah, sorry. This thing of the delay of half an hour is confusing my head. Just absolutely confuses my head. The delay is just, I think I was the same one. What was his name? Zachary Young was on the delay thing. It absolutely confused me. But I hope normally the normal is when they are on a delay, when it is like verdict watch and everything, it is not gonna be on delay, which is good. I like that. Because I think with X and everything, that would be a big massive spoil if we were on in the half an hour delay, which is good. But not let's not talk about verdict right now, because we haven't even started. And I'm already talking about verdict. This is amazing. So yeah. Uh, I think they are about to come back on. They I need to turn off the notifications for X because I've already gotten quite a bit of spoilers, which is okay. I don't mind. I don't mind getting spoilers, but the sidebar took a bit of a while. It was a long sidebar. It only ended about 10 minutes ago, so we still have about 20 minutes to go. What I'm gonna do is, if you want to very briefly. Oh, what did I do? I pressed the wrong button again. Of course I did. If you wanted to come up on stream and just have a chat, you can. It's free. So it's to it's time to hit the like button, definitely. It's always that time, Jason. And so if you want to come up, just talk. It's free. It's like you call a friend. It's over the internet. You don't have to have your camera on. So just you can come up, talk to me, talk to the people in chat and everything. You can come up, feel free, while we're still waiting for court to resume. So yeah, I know. So it's because of this delay. It's crazy, and oh, our expert is in the house. Hang on, let me put a little bit bigger on the screen, expert.
No, no, no.
Yes, people need to see you. If I have to be it, you have to be too.
Hi, chat. No, I am. Training got over just about the time this went live for Lori. Um, so I'm also on my lunch break for about another 20 minutes. So that's why I'm able to do that. But I'm cleaning. But I thought I would jump in and say hi.
What are you cleaning?
The kitchen, because I only half cleaned it last night after supper.
Oh, do you want to come and clean my kitchen after that?
No.
No. Oh. To be fair, I have adult too much during the weekend. I think I can adult only now on Thursday. I think I can take it easy until Thursday because of this crazy schedule that I'm on. Because I'm basically gonna be in Arizona time for a couple of days and then go back to my time zone on the rest of the week. It's gonna be an interesting ride. I hope you're ready for the craziness.
Yeah. We're gonna see some crazy Katya.
Yeah, when don't you see a crazy Katya? when isn't that not? Even when I'm on a normal time zone, I'm crazy. Imagine now with a sleep-deprived Katya. That shall be fun. It's gonna be even more fun at work when I'm trying to bake bread and I'll bake myself.
So, did you work overnight last night?
Yes. So I started at 2:30 in the morning, my time, to 8:45 a.m. my time. Yeah. And it's.
Please tell me you came home and took a nap.
I took an hour nap. I couldn't sleep anymore. I tried. I forced myself. I tried. I couldn't. I had an hour nap. I'm gonna have another nap during lunch break from when we're on lunch break of Lori. I'm gonna try to take another nap and eat. And then after court finishes at 1 a.m. for me. I start at 2:30 in the morning. So literally court finishes, I'm gonna have breakfast, have coffee, get myself ready, go to work until 8:45 in the morning again, come home, sleep, wake up and do trial again.
Well,
so
maybe by tomorrow morning you'll be able to sleep more than just an hour.
Maybe no with this. Not with this. So
oh my gosh.
I might be in Arizona tomorrow, live stream the trial instead. So yeah. Oh, Sissy, Well, I'm definitely gonna be living on coffee for sure. Thank you very much, my friend. I really, really appreciate it. Definitely gonna get some more coffees with that. Sorry. And this is me without any energy drinks. Can you imagine me on energy drinks on stream? Whew. That would have been wild. Thank you very much, Zizzy. I really appreciate it. Definitely, that's gonna go on a coffee pot. Hey,
If you see me looking up, can you see him?
Hang on, I need to put you bigger. What are we looking at? Hang on. Oh, the cat. There's a kitty.
He's right over my head.
Is he gonna jump on you, or what's he gonna do?
No, he sits there and watches me.
Oh, hang on. Wait. No? Sorry. I thought Court was gonna come back. I thought I heard some sound.
No, he sits there and watches me.
He doesn't watch as you, stares you down. Oh my days. That's crazy.
Yeah, if I open the cabinet, he tries to get into it.
Oh my days. People are saying, Kitty, you beautiful cat. And Jason is saying it's Catty on the unit. It's not me, Jason. It's not me, Jason. But
his name is Gilligan.
Oh, Gilligan. Oh. Hang on.
And he's not quite a year old, and he weighs 10 pounds. And yes, after the show, Gilligan's Island, because my friend that found him as an abandoned kitten, she was kayaking. And she found him right on the edge of the water. And so she rescued him, and he was just teeny, teeny, tiny. And she put him in her shirt, and he went on a 3-hour tour while they were kayaking. So she named him Gilligan.
Several people are saying, like Marie and Jason are saying that the cat is making sure you don't miss a spot in the kitchen. So your supervisor. Supervisor's
yes.
looking at you.
Yeah.
Making sure you
pretty much.
Well, I am the same to Garden Bot. I am his supervisor. But to be fair, he's doing very well. He's a very good employee.
He's a very good employee. He's a very stubborn man.
Oh, you tell him, Denise. Please tell him that he's a...
Listen, Garden Bot. Cutie pie. As I shake my knife. Behave yourself. Use the ointment the doctor gave you before you make it worse.
Sorry, 1 second. Just technical difficulties. I'm hearing myself twice. StreamYard. 1 second. Sorry about that. I was hearing myself twice and I was gonna go bananas. That is not good. I don't like to hear my own voice. But Denise, just repeat yourself. Sorry, sadly, but to say to Garden Bot what you were saying and telling him off.
I was saying, cutie pie, behave yourself. Use your medicine like the doctor told you so that your eye gets better. There's a reason he's a doctor and you're not. Just saying.
I know Marie is trying. He does very well, but it's just he's very stubborn with this ointment thing for his eyes that he says he doesn't need it anymore when he clearly does. And let's not get started on that because I could talk for the next five hours about that. So about how stubborn he is and how I had to force him almost already to go to A&E to emergency department. Sorry. So yeah.
Okay, I'm jumping off so somebody else can jump in.
Yeah, just very quickly, Jason is saying, so do not make threatens with the pokey device on the internet that you not be comfortable being played in court. So just be careful. He can come back around.
I put it down.
You put it.
Okay, I'm going to jump out so somebody else can jump in.
Yep. No worries. It's always a pleasure to listen to you, my friend. And thank you very much for coming in. Always.
All right, bye.
Bye. So thank you very much, Denise, once again for coming in. Oh, and now they got the thing. It's a bit big. Let's adjust that on the screen. 1 second. So yeah. So if you want to call, or if you need the thingy again, just let me know. Again, thank you very much, Zizzy, for your support. I really appreciate it. Definitely, it's gonna come a few coffees or maybe 1 or 2 monsters coming handy. The sidebar went off for about half an hour or more than that, so we should be back any moment now. So hang on, let me have a look. 1 second. I need to go back on there. So where is it? Oh yeah, sidebar ended about 19 minutes ago, so we have about 10 minutes to go until they get back on court. So it was a long sidebar. I am not gonna spoil what was decided or not because I don't speak English. Well, it is not a good start for breaks wise. So yeah. I don't know if they have been sworn in. They have been sworn in when they were chosen back last week at some point whenever the jury was sworn in. They got done, but now we are on a sidebar because of the Lori doesn't want Brandon Bordeaux present while the trial is ongoing, says there's conflicts of interest. The state is not going to call them or anything, so they do not worry about that, but so they are on a sidebar through that. So yeah, that's what's happening. Yeah, I think the judge must be like trying not to coach her too much about like the legal advices because she doesn't really know what she's doing. So oh yeah, well, we doing the not legal advice sidebars countess, so kinda yeah. So the trial has started, but still, yeah. I'm sorry. I am looking, and I think I got a too big of a desk. I think the desk I got it's way too big, and I think Garden Bot is gonna kill me, unalive me. So. How long does it say? Well, apparently about 30 minutes. So oh my days. I cannot believe I think I got a too big of a desk. Oh, it looks absolutely ginormous. Garden Bot is gonna unalive me so hard. I think I'm definitely gonna have to change the setup yet again on how it looks. Well, me and measures do not go together, and I got so. Oh wow, that's really well. In a way, they can, but like the thing is, but then it's not really fair. It's not the judge's fault or just like. I don't know how I would feel about that. In a way, it is great that the judge helped. Yes, it is awesome. It's fantastic that he did, but it just, yeah. I know, I got too big, and I'm so like, it is gonna be. Sorry, Garden Plus. I need to take a picture of this. Hang on, 1 second. I need to take a picture of this. Garden Bot is on top of my desk, and absolutely, yeah, amazing. It's hilarious. Oh no, it doesn't sound bad. It just sounds that's
The
I.
defense can
Oh,
produce
hang on.
text messages or some information to provide to the court that shows he does in fact have relevant information. He might be called as a witness, but so far the court can't find that Mr. Boudreau has any relevant information to this case. Therefore, Mr. Boudreau struck again without prejudice from the witness list. He can remain in the courtroom. We're going to bring the jury in. The other matters that were raised by the defense we'll talk about at another time when the jury is not waiting.
Sorry. GardenBot is giving me ideas of how we can put the desk. It is it is not that big, but for the room that we have, it is rather big. So, yet again, we are waiting for the jury now to come in. So, Lori's motion was denied in a way because Brandon Bordeaux can remain in the courtroom for this trial, so she got denied her first motion. That's another thing we should count of how many motions she gets denied, which will probably be better. And if she gets something accepted, we would decrease the counter. That could be a funny idea, but then it would be probably too much things to count. But hey, we're here to enjoy and get justice for Charles Vallow and see how things are gonna be going. So now it's been almost an hour in, and still no testimony, no openings yet in the Lori Vallow. At this rate, I am assuming that testimony is only going to start after lunch, because it's already 10 to 12. I'm assuming. I don't know. Yeah, exactly. It should count how many. Well, we wouldn't go that many forward, Mel, in terms of the counter, really. Because it's only gonna be like very short days, finishing like 4 o'clock. I think it's half 4 o'clock, 4 o'clock. So, yeah, you're right. So, oh, why is sound not in? Well, jury is reading the jury instructions, but we don't have any sound. So we don't have any sound feed.
Testified
There
to
you
by
go.
a witness who has been sworn in and is answering questions from the witness stand. Therefore, it is important to remember that what is said by both the prosecutor and the defendant in opening statements and later in closing arguments is not evidence. The purpose of an opening statement is to help you prepare for anticipated evidence. The state can proceed.
Thank you, Your Honor.
Are you going to use, put a mic over there.
So I'm going to need you to stay close to me the next couple days. Mel, too. She can't go to Utah. They're planking some kind of intervention, but want Mel out of the way, so I'm left alone. I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thanks for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. Lori Daybell, the woman seated over here, wrote this to her brother, Alex Cox, on July 9th of 2019, 2 days before they killed Charles Vallow. But to understand why this is so meaningful, why this is relevant, you have to understand the context. So let's talk about it. In July of 2019, Lori Vallow was married to Charles Vallow. Lori Vallow lived here in Arizona, Chandler. Charles Vallow lived in Texas. In July of 2019, Lori Daybell was Lori Vallow, married to Charles Vallow. In July of 2019, Lori Vallow wanted to be Lori Daybell, wife of Chad Daybell. And in July of 2019, Lori Vallow wanted to keep the same lifestyle that she had with Charles. And she could get all of this if Charles was dead. She could marry Chad Daybell and become Lori Daybell. She would get a $1 million life insurance policy from Charles Vallow. She would get Social Security for herself and their son, JJ, as a child of a dead spouse. And all of this would be true if Charles Vallow was dead. So what about Nephi? Well, Lori Vallow, Chad Daybell, and Alex Cox all believed that those who disagreed with them were dark, possessed by evil spirits, sometimes called Z's or zombies. Sometimes they had names for these evil spirits like Ned. Lori, Chad, and Alex used religion, the Church of Jesus Christ of Latter-day Saints, and a story of Nephi, a prophet, who was directed by the Holy Spirit to kill Laban, to obtain brass plates and secure the long-term prosperity of Nephi's descendants. Lori used this religion and the story of Nephi as justification to kill Charles Vallow, just like Nephi killed Laban. On July 9th of 2019, Lori Vallow invoked Nephi when she messaged Alex to provide them with that religious authority to kill Charles. After months of trying to get rid of him, they were finally ready to be like Nephi. So how did this begin? We go back to 2018. Lori Vallow met Chad Daybell. You will learn that in November of 2018, that Chad Daybell came to Arizona for a Preparing the People conference. And he and others stayed at Lori and Chad's house. Charles was actually out of town with JJ. Lori and Chad acted as if there was nothing between them, but nothing could be further from the truth. By January of 2019, Lori Vallow claimed that Charles Vallow was possessed by an evil spirit that she called Ned. You will see text messages where Lori and Alex refer to him as Ned. During this trial, you're going to hear from some women who initially were close in Lori's circle. These women will tell you they met her through the Preparing the People conference. They are spiritual women within the LDS church. And initially they found Lori's spirituality infectious. But the more they listened to Lori, the more they started to find concern with what she was saying. One of them called it red flags. Lori began saying things like she didn't need to repent, that she was beyond that. And you'll hear from these women that that goes against everything that their religion follows. Everyone must repent. You will hear from Serena Sharp that in March of 2019, she attended a girls' weekend with Lori and some other women. They went to the temple, they had lunch, they did volunteer activities, and then Lori asked them to do something a little unusual. She told them that her husband was possessed by an evil spirit, and she referred to that as Ned. She told them that Charles was no longer in his body. She asked them to come together and try to cast out this evil spirit. Serena will tell you that she didn't ask Lori what would happen to Charles if that evil spirit went. She only knew that she had said Charles was already gone. She didn't know if he would come back or his body would just die. Later that month, on March 26th of 2019, Alex Cox texted his sister, Lori Vallow, and said, quote, "Ned is still alive, just confirmed." Lori responded, "It's not Ned. It's a new one. Ned is gone. No one has seen him, right? Just talk to him, question mark." Alex said, "Correct. Charles' body is alive." "What did you learn, question mark?" And Lori responded, "A lot. Still working on it. We'll call you later." As the year went by, Lori and Alex became more determined to get rid of Charles Vallow's body, whatever they wanted to call him. You will hear from Christina Atwood that she attended a gathering on June 9th of 2019. Again with Lori and some close friends, but this time Alex Cox attended. This was the first time she had met him. Christina will tell you that she heard Alex say that he just wanted to kill Charles. In fact, she heard him say this a couple times. And she heard Lori say, in response, that she had been drugging Charles, crushing up JJ's pills and putting them in Charles's protein drinks. Christina will tell you she was so disturbed by this that she actually went and confronted Lori the next day and told her that if Charles ended up dead, she would have to go to the police. That's how disturbed she was. Now, Lori, of course, said it was all a joke. What else could she say? But 1 month later, Alex and Lori created that situation to be like Nephi and killed Charles. What about Charles? You're going to learn that Charles and Lori had been together for a long time. They had adopted one of Charles's family members' children, JJ. JJ was everything to Charles. JJ was the reason Charles and Lori were still together. You'll learn that Charles knew about Lori's beliefs, that he was called Nick or Ned or some name. You will learn that Charles told a lot of people about this. And on February 26th of 2019, Charles made a big decision. He had a $1 million life insurance policy, and his wife, Lori Vallow, had been the beneficiary. He changed it. He changed it to his sister, Kay Woodcock. You will learn he did not have to notify Lori about it, and she had no idea. You'll learn that Charles desperately wanted to bring Lori back to the Church of Jesus Christ of Latter-day Saints. You will learn that he was close with Lori's brother, Adam, and he was reaching out to him during this time period. You will hear from Adam. Adam will tell you that he himself had heard the defendant say things that were outside the LDS religion, that she was translated. Charles was possessed. He knew she was no longer following the LDS faith. Then, June 28th, Charles found out that Lori and Chad were having an affair. You will hear that he reached out to Lori about it, Chad's wife, and out to Adam Cox about it. Now, you're going to hear about a lot of these things because the police executed numerous search warrants. You're going to hear that they executed search warrants on cell phone records, cell tower records, and iCloud accounts. You're going to learn that an iCloud account is basically a service through Apple where you can store everything, photos, emails, documents, whatever you want. This can be intentional, or sometimes it can be unintentional. Your phone or your computer may be saving items there without you even realizing it. You'll learn that for years, Lori Vallow had an iCloud account that was loriforstyle@icloud.com. But after Charles learned about Chad Daybell on that June 28th, she created a new iCloud account, lollytime@icloud account. Many of these text messages between Lori and others that you're going to hear about at trial were recovered from those two iCloud accounts. You're also going to learn about Charles's cell phone. The police eventually recovered it, and they were able to extract the data, look at the messages and things that had been in there. And you're going to learn about those text messages with Adam Cox from July 9th through the 11th. You're going to hear from Adam that they were talking about an intervention, about maybe recording Lori, saying these things and taking those recordings to the stake president, or just confronting the stake president about it. They didn't have an exact plan, but on July 9th, Adam agreed to fly to Phoenix to help try to talk to his sister, talk to the stake president, get her back into this faith. Ultimately, Adam flew to Phoenix on the 10th, as did Charles. Adam will tell you that he actually, when he got his reservation on the 9th from Charles, reached out to his brother, Alex. He asked to stay with him. And Alex said, sure. You'll see phone records. They had a conversation about it. But when Adam flew into Phoenix on the 10th, remember, that's after that message by Lori that he needed to stay close to her. Adam tried texting his brother. Adam tried calling his brother, and Alex didn't respond. Adam didn't know that his brother Alex had been summoned to help his sister Lori be like Nephi, that it was time to kill Charles. The text messages from Lori to Alex about that intervention that she knew about and being like Nephi show that by the evening of July 9th of 2019, Lori knew that Charles was trying to have an intervention. An intervention. In that text message, remember, she said they are trying to have an intervention. She knew it was Charles and others. She also told her brother he had to stay close for the next couple days because she knew that she was going to be seeing Charles on the 11th when he came over to pick up their son, JJ, to take him to school. She told him, it's all coming to a head this week. I will be like Nephi, I am told, and so will you. A few minutes after Lori had texted Alex that message on July 9th that they were going to be like Nephi, Alex called his sister Lori, and they talked for over 56 minutes, planning how they were going to get rid of Charles. Alex would stay close with his gun, and he and Lori would be like Nephi. July 10th of 2019 is a day before Charles was killed. We know from text messages that by 7:18 p.m., Alex was already at Lori's house. He brought a garbage bag with some clothes and an orange duffel bag with his .45 caliber handgun and 2 extra magazines of ammunition. He was prepared. We also know that the evening of July 10th, Charles sent a message to Lori letting her know that he would be over at 7:30 a.m. the next day to pick up JJ, to take him to school. Lori and Alex knew exactly when this murder would happen and where it would happen. They just had to make sure that Charles stayed in the house. You'll hear that on the evening of July 10th, Charles spent his last night alive on a date. He had been on several dating apps and appeared to be moving on. You will hear from his date, Nancy Jo, that she and Charles had met on an LDS dating site a few days before. You will hear that she had talked to him and texted him for hours. Sometimes they would talk for 3 hours on the phone. Nancy Jo will tell you that Charles told her about everything of his relationship, his wife's beliefs, everything that was going on. And he had told her about this change to the beneficiary of his life insurance. She will tell you it sounded like a lot of drama, but she still was interested and wanted to meet this person, and so they met that evening for dinner. She'll tell you that she understood on the 11th that Charles would be picking up his son, that he was actually going to meet a realtor about finding a place to rent here so he could be closer to JJ, and that he was going to try to get in touch with Adam to meet up. And then they were supposed to meet later in the day. She will also tell you that she actually told Charles, kind of joking, but in a way to end the drama, why don't you just tell Lori that you changed the life insurance policy so she knows it's not her? Nancy Jo will tell you the next day, she texted Charles, she called him, and she actually thought he had ghosted her. She didn't know he was dead until a few months later when she saw something on the news, a photo of him, and actually learned that he had been killed on July 11th. So let's talk about July 11th. That morning, Lori Vallow was up early and she was texting with Chad Daybell. You'll learn that we do not have those text messages. They were not saved in the iCloud, but we have them from the phone records. Alex was already at Lori's house with his gun, and everyone knew that Charles was a punctual person and would be there around 7:30 to pick up JJ so he could get to school. You're going to learn that, like many people, Charles had left his GPS data locating service on his phone. So that means when his phone is moving around, it was constantly documenting with GPS the location of the phone. During this trial, you're actually going to see this data mapped out. You'll be able to see Charles come to the house, and then you're going to see his phone leave with the defendant and what she does all day with it. What we know is that Charles arrived at Lori's house at about 7:35. He texted Adam Cox and told him that Alex, or Al, is here. You'll see from photos that Alex's truck was parked in the driveway. Adam responded, "Really, I wonder why he never called me back." Charles didn't respond to that. Adam then texted, "They're planning something." And Charles responded, "Absolutely." Adam told Charles, "I was supposed to spend the night at his house last night. She probably blocked that." Charles told Adam, "What you do is up to you." Adam then told Charles he was going to reach out to Alex and ask him to come get him and see what Alex would do. And in fact, he did text his brother. You'll learn that Charles read that text message from Adam, but he didn't respond. Adam sent one more text message to Charles at 7:49 a.m. on July 11th. He told him that he and his son were going to go play basketball at 8 p.m. to look for a specific church leader who was usually there and have a conversation with him. Charles Vallow never read that message, but you will learn that Lori and Alex did. Charles went to the front door of 5531 South Four Peaks Place, a house that he had rented for his wife, Lori Vallow, a house that he paid for. Charles would have had to knock on the door, alerting Lori and Alex that he was there. He got JJ, put him out in the car, and then Lori Vallow created the reason to keep Charles from just leaving with JJ. Lori Vallow wanted to stop this intervention. Lori Vallow wanted to stop Charles and Adam from trying to take her temple recommend away. Lori Vallow, who wanted to be Lori Daybell, and Lori Vallow, who wanted Charles's money. So Lori took Charles's cell phone, and she refused to give it back. Lori Vallow, or Lori Daybell, whatever name you want to call her by, is why Charles didn't just leave with JJ that morning. Lori Vallow is why Alex was able to shoot Charles. Lori Vallow is why Charles is dead. I want to tell you a little bit about the scene, this house, so you can understand what's happening here. When you walk in the front door, there's a big room. It was empty, no furniture. There were mirrors on 2 of the walls, windows on a 3rd wall, and the 4th wall had doorways going into the kitchen and a hallway off to the bedrooms. This is where Charles Vallow was killed. This is where Alex Cox shot him 2 times. The first shot to Charles Vallow was to his chest. It exited out his back. Charles Vallow fell to the ground. He put his left hand to this wound, and blood transferred onto it. You will hear from the medical examiner that this shot went through his heart, and that a person can take seconds to up to 2 minutes to die from that type of wound. You will hear that a person can still talk and move after they're shot in the heart. And we know Charles was able to move since he put his dominant left hand on his chest and transferred that blood to his hand. You will see that. As Charles lay on the floor of 5531 South Four Peaks Place, Alex Cox stood at his feet and fired a second shot. That shot entered his abdomen, and it exited his left shoulder. The angle was significantly upward. Dr. Baumgardner, who is the medical examiner, will tell you that this wound was shored. You will learn that shored means that there was something hard behind that wound. So when the bullet exited it, it caused a different tearing pattern than the other wound that exited Charles's back. It is this shored wound, this exit on Charles's left shoulder, that shows us that there was nothing accidental about this second shot. You will learn from the cell phone that at 7:49, Lori left Charles's house, or left her house with Charles's cell phone, his wallet, his rental car, and JJ and Tylee. She drove to Burger King, Walgreens, dropped JJ off at school before she and her daughter Tylee drove back to the house. During this time, while Lori is driving around in Charles's car with his phone, she spoke with her brother Alex twice. The first call was at 7:52 a.m., 3 minutes after she left. The second call was at 8:06 a.m., 17 minutes after she left. You will hear that when Alex and Lori are talking, neither of them had called 911 yet. In fact, you will hear that Alex didn't call 911 until 47 minutes after Lori left. Charles Vallow lay dead on the floor of that house for 47 minutes before he called 911. During this 47 minutes, Alex began staging the scene and making mistakes. you're going to learn that the police found a bat that was located on the right side of Charles to the north of his head. Like he had been holding it, and when he was shot and fell, it dropped, it rolled up against one of the walls that had mirrors on it. What you're going to learn that is, Alex forgot that Charles was left-handed. In fact, you're going to learn that Charles was a semi-professional baseball player. He pitched and he batted left-handed. So that bat was on the wrong side. Next, you're going to hear about an injury to Alex himself. Lori had told police that Charles hit Alex in the head with this bat before Alex shot Charles. Classic self-defense. But in all cases, we must look at the physical evidence because it doesn't lie. And the physical evidence doesn't have a bias or a memory loss. Sometimes it's the lack of physical evidence that doesn't lie. So again, we know that this room where Charles was shot had no furniture, mirrors, 2 walls. You learn that although Lori claimed that Charles hit Alex with that bat and then Alex shot him in self-defense, that Alex's gun had no blood transferred on it. Alex was allegedly struck in the head with a bat by a semi-professional baseball player. Doesn't go unconscious, and he never touches that injury. Pulls out a gun, is able to shoot this man twice, and then he takes the gun down a hallway and puts it into a room. Never apparently touching his head or this wound. And again, Lori says that Alex was hit with the bat in this room by Charles. But again, what we don't see is any blood on the floor. Charles strikes Alex in the head with a bat. They're grappling on the ground. There's not a single drop of blood on the ground in that room. There's pooling of blood around Charles as he lay there on the ground. There's not a drop of blood going down the hallway to where Alex put the gun. There's not a drop of blood in the room where Alex put that gun. There's not a drop of blood on the floor in the kitchen where Alex went to go wash his hands. There are no towels, sheets, clothing, napkins with blood on them, where Alex was holding his head and trying to stop this bleeding from this injury. You will see on body-worn camera, Alex Cox, who's on with 911, come out of the house. He will have a phone in one hand and his other hand up, and you will notice that he actually has a pair of sunglasses resting on the top of his head. You will see at some point, Alex sits down, and they ask him to move to another location. They talk to him for a while, and then you'll see him eventually touch his head a few times, and then he obtains a napkin or towel, something, and you'll see him at times rubbing his head, patting it. That is the only bloody item you will see. Those sunglasses on Alex's head. He is struck in the head by a baseball player while grappling on the ground. He then pulls out a gun and shoots his brother, puts away this gun, deals with his injury, and yet those sunglasses are still right there on the top of his head. No blood on the floors, no blood on the gun, no damage to the mirrors, bat on the wrong side. The lack of physical evidence to help support this self-defense claim. Next, trajectory. The medical examiner will talk to you about the trajectory through Charles's body. The detectives are going to talk to you about the trajectory through the room. Dr. Baumgartner will tell you that the trajectory of that first shot to Charles, the one that went through his chest, through his heart, and out his back, was front to back and slightly downward. It will be less than an inch downward. The detectives will tell you that the bullet from that shot, actually, as it exited Charles's back, ended up across the room in the baseboard. They pulled it out and recovered it. Both of them will say that this shot is consistent with Charles being standing upright with a person in front of him. The gun could be slightly down, or his hand could cause that little bit of downward angle. Dr. Baumgartner will tell you that that second shot that entered Charles's abdomen and exited his left shoulder, that the trajectory of that shot was front to back and significantly upward, 13 inches upward. Dr. Baumgartner is also the one who will tell you about that shored wound. What you will hear from the detectives, though, is that when they found Charles on the ground, off to the side of his left shoulder was the other bullet on the ground, not embedded. They'll also tell you that when they finally moved Charles, they took his body away, they cleaned up the blood on the ground, and they noticed a defect in the flooring, in the wood, consistent with a bullet striking the ground. That defect was located where Charles's left shoulder had been. You will hear that both Dr. Baumgartner and the detectives found the trajectory. The wounds were consistent with Charles laying on the ground, Alex being at his feet when that second shot was fired. The physical evidence does not lie. Charles was on the ground when Alex Cox fired that second shot. The injuries to Charles, the location of the bullet strikes, the trajectory of the injuries both in Charles and in the house all show this was not self-defense. This was a staged murder scene. I told you that Lori Vallow left the house at 7:49 a.m., and we know this because of Charles Vallow's cell phone. The 911 call was placed at 8:36 a.m., 47 minutes later. The police arrived at 5531 South Four Peaks Place at about 8:41 a.m. Lori Vallow and her daughter Tylee returned to the house at 8:48 a.m. When the police first contacted Lori Vallow, they thought she had no idea that her husband was dead, that he'd been shot and killed. Initially, you will see body cam footage of an officer going up and just getting her information. Lori doesn't ask, why are all these police here? Why is there a fire truck here? Why is my brother sitting on the ground over there? Or is he okay? Instead, she comments about her neighbors. You'll learn that the police then pulled her aside to do what they call a death notification, to let her know that her husband was dead. Only to their surprise, she told them she knew, she was there. So at this point, the police knew they needed to take her to the police station and question her. You'll learn that Lori Vallow was interviewed by the police. She was treated very kindly. The police asked her what happened. Lori Vallow told the police that she took Charles's cell phone. She admitted that she was the reason that Charles didn't just leave and take JJ to school. She told police in no uncertain terms that Charles was demanding his phone back, and she refused to give it back. She told the police that even as Charles screamed at her for his phone, she walked away from him, wouldn't give it to him. No matter what happened or what Charles said or did, she would not give his phone back to him. Lori told police that her daughter Tylee came out of the room during this screaming with a bat, that Charles took it away from Tylee, and Tylee fell on the ground, and she told Tylee to go out to the car with JJ. She still didn't return the phone. She told police that Alex came out, that he and Charles got into this scuffle with the bat, that Charles hit him in the head with the bat. She still didn't give Charles back the phone. What she did instead was take his phone and go around that wall into the kitchen. Left the situation. Time to let brother Alex be Nephi. While she's in the kitchen, she said she heard the gunshot, came out, saw Charles on the ground, and her brother standing at Charles's feet. Then she told the police she left. You'll learn that the police actually had no idea that Lori still had Charles's phone. Even when they're interviewing her, she still had it. Police are processing the house, looking for it. Where is it? I can't find it. Later in the afternoon, you'll hear that the police actually called Lori and Alex and asked them to come back to the scene. And when Lori arrived, they told her they couldn't find Charles's phone. And she told the detective that she found the phone in the car. Found it in the car. She gave Charles's phone to Detective Enclan and then provided her with Charles's PIN number to get into the phone. You'll learn that after those interviews in the morning, Lori and Alex went back to Alex's house in Santan. And there they went through Charles's phone. You'll learn that Alex actually took photos of some of the messages between Charles and Adam, including Adam's flight reservations. And he later sent those to his sister, Lori. July 11th. Lori didn't tell any of Charles's family he was dead. She didn't tell Adam that Charles was dead. She certainly knows they'd been talking. The next day, Lori texted Charles's sons from his prior marriage and told them, "Your dad is dead." Charles's sons reached out to their Aunt Kay about this, and you'll learn that Kay and her husband had to Google this, see if it was true. They found out that Charles had been shot. So what about the money? That life insurance policy. Charles Vallow had $1 million life insurance policy. When he got it, his wife, Lori Vallow, was the beneficiary. We know that Charles died on a Thursday, July 11th. That next Monday, July 15th, Lori Vallow called Banner Life Insurance. The call was recorded and you will hear it. She told the agent that Charles had been accidentally shot. It was an accident. And that she was the beneficiary. Both of those statements are not correct. There was nothing accidental about that shooting, and she was not the beneficiary. 3 days later, on July 18th, Lori Vallow learned that she was not the beneficiary. Banner Life Insurance could not and would not tell her who Charles had changed it to. But Lori was angry about it. And you're going to learn that on July 18th of 2019, there's another very important text message in this case. The first one on July 9th between Lori and Alex when they discussed being like Nephi. And on July 18th, 7 days after Lori and Alex killed Charles and Lori learned she is not getting $1 million life insurance policy, she sends a message to Chad Daybell. Quote, "So I talked to the insurance company. He changed it in March. So it was probably Ned before we got rid of him. You can't tell me who, of course, but it's done. I'll still get $4,000 a month from SS." In this text message, Lori tells Chad that it was probably Ned, that evil spirit inhabiting Charles's body, that changed the life insurance policy before they got rid of him, before they killed him. After Lori found out that she was not the beneficiary, she was so angry that she actually went through Charles's laptop, found the beneficiary change form, sent photos of that to Chad. She also confronted Kay about it. The $1 million she had expected to get was gone, but as Lori told Chad on the 18th, she was still going to get money from the death of Charles. Lori knew already that a month before going to see Social Security, how much money she would get for JJ and for herself as a caregiver as a result of Charles being killed. $4,000 a month. Ladies and gentlemen, the evidence in this case is going to show you that Lori Vallow Daybell conspired with her brother, Alex Cox, to kill her husband, Charles Vallow. When Charles let Lori know he was coming into town, she quickly got the pieces into place. Alex came to her house with a gun. Lori created the way to keep Charles inside the house so that Alex and she could be like Nephi. To kill Charles Vallow to better at least her life so she could be with Chad and she could live off that life insurance policy. As we go through this trial, you will see photos of Charles's injury, photos of the crime scene, and hear testimony that will prove that this was not self-defense. As we go through this trial, you'll be provided with phone calls, emails, text messages, and hear testimony that lays out the motive for this murder, money, and Chad Daybell. You will see text messages and hear from people who Lori trusted and who were later pushed away, people who really don't want to be part of this trial, but were pulled into it by this defendant and her desire to get rid of Charles to be with Chad. People who heard Lori for months saying Charles was gone, possessed. People who will establish that this murder was premeditated. You will hear text messages from July 9th by Lori to her brother, Alex Cox, that he had to stay near her, that it was all coming to a head, and she would be like Nephi, and so would he. A justified killing, just like the prophet. And later, the text message to Chad where she told him that Charles changed the life insurance policy before they got rid of Ned. A confession by Lori of how religion and money were twisted to justify Charles's murder. At the end of this trial, the state will come to you and ask you to hold the defendant responsible for the death of Charles Vallow and find her guilty of conspiracy to commit first-degree murder. Thank you.
All right. Will the defendant be giving an opening statement? Okay, because of the lunch hour, your opening statement will start after lunch. I'm going to excuse the jury for lunch. I'm going to ask juror 3 to stay back. I need to talk to you about something. Please remember the admonition, jurors. We'll see you. Let's start. Everyone be back in the jury room about 1:20 p.m. and we'll resume at 1:30. Thank you.
All rise for the jury. So we'll see if this what happened with George Gray is gonna be on televised. Otherwise, I'm just wrong app. Pulling up what happened on my phone. Hang on, there we go. Just bear with me a second. Where is it? So many tweets to go through. Right. Okay. Oh, I thought they said what it was for it. I don't know. So 1:30 p.m. that they're gonna get back local, which is in an hour and a half. What's the time in an hour and a half, like in Eastern? I don't know. We'll wait for Core TV to put the time and we'll figure it out. During lunch break, we're gonna be watching the coverage of Law and Crime about this case on lunch break. There's gonna be Gigi from Pretty Lies and Alibis there. I will put it up in a second as soon as they go. I don't know. I just need to figure that out, how they are gonna do or not. And we're gonna watch 5 p.m. Eastern. Thank you. Okay, they're gonna come back at 5 p.m. Eastern, Central 4 p.m. That's with the delay. So yeah, right. Hang on, I'm trying to think about what the yes, 5 p.m. Eastern, 10 p.m., 5 p.m. Eastern. That's already with the delay. So we'll be back. Yeah. So yeah, 4:30 their time, but it's gonna be 5 p.m. because of the half an hour delay. Don't forget, this court is always in the delay. They left exactly. They left for lunch break 30 minutes ago. So yeah. Ugh. My days. It's 5 p.m. your time, Eastern time. So yeah. So 1 second. Turn that off. Okay. Bear me 1 second. So I'm just gonna try to find. So what do you guys think of that opening? 789, nice. I do need to take a nap, but I need to leave you with some entertainment while I take a nap, and I have some food because definitely need some food. I can play you some music, but I don't have enough music to play for the hour and a half. But let me have a look. One thing, because there might be any other like some other sources doing a live war coverage during the, the break. I'm just trying to find that out. Here you go, found one. Oh, hang on, actually I found Pretty Lies and Alibis with Law and Crime just went live. So in 1 second, let me see, where did they go? Mm, 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 mm. Ah, okay, I think it's there. No, I don't know. Let's see if there's. Hang on 1 second. I don't know if they're gonna be just doing on chat or if it is just gonna be, I think so. 1 second. I don't know, because I want to see if they're actually gonna talk or if it is just gonna be like chat stuff. Because if they talk, I'll just put that and I'll go eat and everything. Sorry, Stephanie. Yeah, I was like, it was too detailed and it was a little bit boring. Yes, true, we know like a lot about the facts of the case already. But it was not like as grasping as I would think it would be. So so it was just a bit. Yeah, I kind of agree with you, Stephanie. Like, she could have done probably in another way, a bit more emphatic. Maybe it's not her style, and I get that, but it's just, yeah, she could have been a little bit more strong. That, yep, no worries. All right, okay, I'll see you very soon. Sorry, Paula. See you very soon, my friend. Zizi, I'll get back to you in a minute. So. Okay, sorry. All right. The show is gonna start soon, so until then we're gonna start. So, um, yeah, it's like I know Lori's opening is gonna be hilarious. It's gonna be I know I need a nap. I will take a nap as soon as I get something to be done over the break. I promise. Otherwise, I will just put some music until the thing starts, and then we'll do that way. It was very informative for the jury, but a bit dry in terms like sounded like a lecture on Unaliving in Red Room. You know, it definitely gave all the details and some more that they needed. But I guess it's just, I don't know, a bit more from what of what have I oh. Actually, it's actually quite funny. Kathy Russo on the chat of the Law and Crime is saying that the prosecutor Kay, that's just did the openings, is the longtime girlfriend of the Jordi Arias prosecutor Juan Martinez. I did not know. Oh, soup! What kind of soup? Oh, it's the broccoli cheese soup. Nice. So yeah, I don't know. Oh yeah, definitely. Yeah. So I think I've decided what am I gonna do is I'm gonna keep an eye on the feed for the law and crime thingy. But while we do that, I'm gonna just put some music so I can start winding down a little bit and I can have a bit of a nap. And we'll be back in about an hour and a half. This is gonna be the same stream, so we just can carry on there. I'm gonna put some music until the thing gets started. So I'll see you very very soon, guys, and I'll be in chat.
Courtroom buzz lights up the air. Faces tense as stories tear. Truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead. International eyes on the scene. Lines override, blurred and lean. Arrested dreams, shattered glass. In this court, who holds the past? Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. Families once so torn apart. Courts drama quick to start. Chains rattle, futures bleak. Yet in silence justice seeks. Around the world eyes new gaze. Every trial a twisted maze. Judgment passed through smoky gaze. In this court no room for haste. International eyes on the scene. Lines override, blurred and lean. Arrested dreams, shattered glass. In this court, who holds the past? International eyes on the scene. Lines override, blurred and lean. Arrested dreams, shattered glass. In this court, who holds the past? In this court, who holds the past? Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. Lawyers dance in verbal fight. Day turns into darkest night. Every turn, heart skips a beat. Justice tango on repeat. On repeat. On repeat. On repeat. No repeat. Families watch soul torn apart. Courts drama quick to start. Chains rattle, futures bleak. Yet in silence justice seeks. Around the world eyes to gaze. Every trial a twisted maze. Judgment passed through smoky gaze. In this court no room for haze. In this court who holds the past? In this court who holds the past? On repeat. On repeat. No repeat. No repeat. No.
She's a Portuguese soul in the UK, rolling dough at the bakery day by day. Sugar on her apron, flour on her face. But when evening comes, she steps into a darker place. Grab the keys to the car for that Costco run, loading up on snacks before the work's all done. 'Cause once she's home, it's time for the show. True crime on YouTube, spotlight aglow. Late night trials and conspiracies. She's digging for truth for the world to see. Documents on Discord, she's on the hunt. In the hush of midnight, she's on the front. She's got her boyfriend by her side. Together they host this chilling ride. Nightbots watching, chats alive. Everyone's hooked, ready to die. Her days are sweet and filled with bread. Her nights are dark, deep in her head. From morning dew to midnight files, she dances between the day and trials. Late night trials and conspiracies. She's digging for truth for the world to see. Documents on Discord, she's on the hunt. In the hush of midnight, she's on the front. Portuguese pride in the UK sun. She'll solve every case till the morning comes. Daytime bakery, nighttime sleuth. Our true crime addict revealing in the truth.
And that's prosecutor Trina Kay making her case to jurors in Maricopa County, Arizona, as the trial for the conspiracy to murder Charles Vallow is getting underway. Welcome to the Lunch Show here on Law and Crime. I'm Anjanette Levy. Thanks so much for being with us. It's 3:47 here on the East Coast. And of course, it's around 12:47 lunchtime out there in Phoenix. And they're on the lunch hour. We'll be taking your questions. So please submit those to us in the YouTube chat, and we'll get to as many of them as we can during this lunch break. This trial, of course, has been years in the making, almost 6 years, and it's finally getting started. It was July of 2019 when Lori's brother, Alex Cox, shot and killed Charles Vallow in Maricopa County and claimed that he did it in self-defense. Alex died months later of natural causes, you may recall. And if you've been following the case, you know how awful this was. Charles tried to get Lori help in the months before he was killed. He thought she had had a mental break. Prosecutors would say that Charles was the first victim in a dark plot hatched by Lori to rid herself of anyone that stood in the way of her marrying Chad Daybell. After Charles was killed, Lori's children, JJ Vallow and Tylee Ryan, were murdered in September of 2019. And the following month, in October, Chad Daybell's wife, Tammy Daybell, died. Her death was later ruled a homicide after originally being deemed, her death was deemed, she was believed to have died of natural causes. Lori and Chad Daybell married, and they were later charged and convicted of murdering JJ, Tylee, and Tammy Daybell. And Lori is currently serving 3 life sentences. Chad was sentenced to death, and both are appealing. Now, Lori, of course, is back in Arizona to stand trial for the conspiracy to murder Charles And she's representing herself. So we are going to get to see her opening statement after the lunch break. But first, I want to bring in Gigi McKelvey, who is on the ground there in Phoenix, Arizona. And with her is Tom Evans. He was a juror on Lori's trial in Boise, Idaho. But first, Gigi, I want to check in with you. And I want to hear what it was like to be in the courtroom as this trial finally gets underway and what the jurors were doing as Trina Kay made her opening statement.
Well, I think that Trina Kay did a great job of keeping it very simple for these jurors who likely don't know much about this case. It's very convoluted, but they were all ears, all eyes on her. I think the way she explained it was very easy to understand, really just focusing on that life insurance policy as the motive, not bringing in too much of the religion. She did mention a couple of things that were said in text between Lori and Alex shortly before Charles was killed. But so far, this jury seemed to be very transfixed with her openings, which I think she did a great job. We're not able to see Lori very well where we are, but she seemed to be focused on the prosecutor as well in her openings. And so after we get finished with lunch break, it will be Lori's turn to get up and do her openings. So we're very interested to see what she's going to say.
And I was wondering, your guest there, Tom Evans, Gigi, Tom, why was it so important to you to make your way to Phoenix for this trial? Obviously, you're really invested. You were a juror on the trial in Idaho.
You're right. I was a juror in Lori's trial, and when that trial was over, I decided to write a book about my experience as a juror. And then a year later, I went to Chad's trial every day of that, and I've written a second book about that trial. And so now I'm working on book 3, and that's why I'm here.
Oh, wow. Really? That's amazing. Now, Gigi, I know you have been covering the case from the very beginning. You're really invested in it, too. What's it like for you to see this case finally come to a head after all of these years? Because Charles was murdered back in 2019. It's been almost 6 years.
Yeah, and Charles was the first of 4 victims in this case, and it's time, to be able to hug Kay Woodcock today and just know that finally her brother is going to get justice here in Maricopa County. It's a long time coming, and what's crazy to think is that they nearly got away with it, Anjanette. It was initially deemed self-defense. Tammy Daybell deemed a natural death. It wasn't until JJ and Tylee went missing that they looked at both of these cases again and realized there's a lot of discrepancies, especially among Tylee Ryan, Alex Cox, and Lori Vallow's statements there in the police station that day. So it was nearly missed, but now, like you say, almost 6 years later, we are here in Maricopa County to seek justice for Charles Vallow, and it is past time.
And Jesse Weber is here with me too, Law and Crime host. Jesse, I'm wondering what you think of this. You've followed these cases from the very beginning as well. And Lori is going to be representing herself. She is representing herself. So we will see her opening statement after lunch. So now we are seeing this trial. Charles, the very first victim in all of this. We're seeing it begin after all of these years. What are your thoughts as we watch Trina Kay give her opening statement? To me, I thought it was pretty compelling.
I thought it was a great opening statement. And look, in terms of, and I'll get through the points that I think were really strong in a second, but look, Lori Vallow Daybell representing herself, great idea. Great idea. I can't imagine what's going to go wrong.
I was wondering if you would think that.
Well, let me put it this way. First of all, any criminal defendant representing themselves is an incredible risk. But when you're dealing with Lori Vallow Daybell, who's already facing 3 consecutive life sentences, you wonder what she has to lose. But look, even leading up to this trial, she's already taken a number of losses. She tried to have certain witnesses from the prosecution excluded from trial. Didn't work out. Look, in terms of her defense, I'll get to that in a second, but let me tell you what I thought Prosecutor Trina Kay did very well. Now remember, Lori Vallow Daybell isn't charged necessarily with the murder. She's not charged with taking a gun and shooting Charles Vallow. She is charged with conspiracy. So the idea is she had to have an agreement with Alex Cox, her brother, to kill Charles Vallow. And what did we hear during the opening statement? Remember, openings are not evidence. This is a preview of what we can expect the prosecution to lay out. The text messages showing a plan between Lori and Alex, messages where it says, thanks for standing by me. It's all coming to a head this week. I will like Neffy, I am told, and so will you. All this stuff about Charles being possessed, including text messages. That is very consistent with how she was ultimately prosecuted and convicted with respect to the death of her children. Lori allegedly drugging Charles leading up to his death. The $1 million life insurance policy that she didn't realize she wasn't a part of. And let me tell you, what I think was probably the most important text message explained during the course of this opening statement, where Lori allegedly sent a text message to Chad saying, I talked to the insurance company. By the way, this is after the death of Charles Vallow. I talked to the insurance company. He changed it in March. It was probably Ned, meaning this possessed entity, it was probably Ned before we got rid of him. That is a prosecutor's dream to have a text message like this. And obviously, when you look at the scene, the lack of self-defense evidence, shot to Charles's head, speaking to Alex after the killing, waiting to call 911. Really, I think this was a very strong opening statement. And I don't know what to predict from Lori Vallow Daybell, but I'll tell you what she should do. I'll tell you what she should do, Anjanette. Do you remember the videos that came out of both Lori and Tylee Ryan being interviewed by police after the death of Charles Vallow, and Tylee Ryan herself saying Charles was, acting like a crazy person. He took the bat from me. He was red in the face. If she focuses on that, I'm not saying it'll be successful, but that is probably where she should go.
Yeah, they talked about Tylee Ryan's police interview in pretrial hearings, and Lori wanted to introduce some of those. She was talking about how Tylee was an unavailable witness, Jesse. Can you get this?
I wonder why.
Get where I'm going. Yes, I wonder why she's unavailable, right? So she said she's an unavailable witness, and the prosecutor fired back and said, well, she's unavailable because, the defendant is convicted of murdering her and making her unavailable. So Lori is not going to be able to use those videos. Whether or not the state indeed does is another question. But, I think we will be seeing probably Lori's police interview from the state. So the judge said, go ahead, Jesse.
And I don't mean to interrupt, but I'm just going to tell you, she is not a trained lawyer. She may be told not to say something. There's going to be a short leash. She might say it anyway, and that's going to be in the juror's mind. She may be restricted in what she can say and argue, but does she know the rules of evidence and about what she's not allowed to argue and not? So I'm curious to look at that as well, if she brings up something she's not supposed to.
Yeah, it'll be interesting to see. And if Trina K tries to throw her off by objecting, if she brings up something she is not allowed to bring up. And another interesting thing, I don't know if you picked up on this, Jesse, but during the opening statement, Trina K did refer to her as Lori Vallow a couple of times. That probably really irks her. She wants to be called Lori Daybell. She does not want to be called Lori Vallow, and I think that was intentional. We're going to get to some questions now, so I'll throw this first one at you. Is the death penalty on the table, Jesse? This is Chris Mass from YouTube. Is the death penalty on the table in this case?
I don't believe it is, unless I'm mistaken about it. I don't believe it is, which, by the way, I think it would have complicated the case, right? Because you have a situation where if the death penalty is on the table, A, it's tougher to get a jury who, has to look at the evidence. And even in cases where you would think it's a simple solution, a simple decision to say if somebody kills their children, or somebody kills their husband, that they should be entitled to the death penalty. Not so easy. Even if you have a death qualified jury who says, I think I can do it, they may not be able to handle it when it actually comes to that decision. And so that would actually elongate the trial. We know that Lori is not the person that Lori has mental health issues, and that would definitely complicate it as well. So if you're looking for a more streamlined case of conspiracy to commit first-degree murder, that's the way to go about it. I'm not surprised that the death penalty would not be on the table here.
Yeah, and she faces, she can be eligible for parole after serving 25 years, but she's already serving 3 life sentences in Idaho. So, Gigi, let's bring you back in. We need to get some questions over to you. This is from Stace67. She is asking, I want to know more about the zapper on Lori. And this is the rack belt that the sheriff recommended and that Judge Boreski said Lori must wear in court so she doesn't have visible restraints on. So, what can you tell us about the rack belt, Gigi?
Well, first off, I can tell you with the last pretrial hearing that we had, it was kind of clear Lori did not want to wear the belt. She was pointing out they were going to have armed guards at the exits if she didn't wear it. So I would be nervous too. It's essentially a wearable taser that goes around your waist, and you have one designated person from the jail, I believe, that has the button that could literally put Lori on the ground. I mean, those things, it's like wearing a taser all the way around your body, and it is a one push thing. So if she gets out of hand and gets to where that person feels she's a threat to anybody in that courtroom, they can zap her and down she will go.
Yeah, it's just a simple remote control, and it's around her belt. And really, they could have ordered her to wear the vest, which is even heavier and would probably be more uncomfortable. But they can zap her, and it can be, from what I was reading, up to 50,000 volts. And it's an 8-second zap. I watched a video about it on YouTube. Let's get to another question. Air S from YouTube. This is from Air S is asking us on Law and Crime. I almost misread this, Gigi. Did Chad tell Lori that Charles is Ned? Is there any proof of that, Gigi?
The origins of where the name Ned came from aren't exactly clear. However, we do know back in 2019, late 2018, early 2019, Chad Daybell was conducting Google searches, very specific. Ned Schneider, Louisiana, died 1996. So for me personally, I do feel like Chad Daybell was the one that came up with that name, although this fake evil entity in Charles had 3 different names over the course of all of this, Ned being the first, then Garrett, then finally Iplos. But to me, I think Chad, because you see those Google searches in the documents from the police department where he was searching this very early on after meeting her.
Yeah, it's and we have Charles on body camera, which I'm sure the jury is going to see, and he's saying basically, she's calling me Ned Schneider, so he's trying to get his wife some help back in January of 2019, and it's all on body camera. It's all there. I think we should take a look now at some of the opening statement from Trina K. We cut up a little bit of this for you, so let's take a look at that, and Gigi will talk about it on the other side.
The Church of Jesus Christ of Latter-day Saints, and a story of Nephi, a prophet, who was directed by the Holy Spirit to kill Laban, to obtain brass plates and secure the long-term prosperity of Nephi's descendants. Lori used this religion and the story of Nephi as justification to kill Charles Vallow, just like Nephi killed Laban.
So Gigi, Trina K is laying it out there for the jury, this whole religious aspect of this, where Chad and Lori and Alex, I guess, she said they don't have these text messages from that day between Chad and Lori, but Alex and Lori are talking about this and using these religious terms. So this is going to be part of this trial.
Yeah, and I think the prosecutor's going to have to do a very good job of explaining it to these jurors as if they are not members of the LDS faith and have no idea who Nephi and Laban are, which are referenced in these text messages. Because I know for me personally, when I started covering the case, I had to do a lot of Google searches because I had no clue. So I'm not sure how much of the religion, I put that in air quotes, is going to be brought in, because you really can get thick in the weeds with that stuff. It's even for me, I've covered this case over 5 years, I still can get very confused. I think just enough to give the jurors a little bit of a taste that maybe this was driven by their religious beliefs that they essentially made up themselves would be enough. But to go too deep into it, I think would be a risk of losing that jury very quickly. Mm-hmm. And so I think Gigi, Tom can probably attest to that, because that was part of,
Oh, well, let's dovetail
that
over into Tom. Why don't you address that really quickly?
Yeah, I think if they make this case too complicated, they're going to lose the jury. This case goes so deep. There's so many layers to it, and I don't think it's necessary in this case for killing Charles. I think it was necessary in Idaho when they were trying to prosecute her for the murder of JJ and Tylee, but not as much here. I think keeping it simple, keeping to the facts as they relate to Charles.
Well, we will see. She brought up a little bit of it in opening, so we'll see if she gets how deep she gets into it once she gets into the evidence. Jesse, I'm going to go back to you now. This is from Hot Mess Mom TV from YouTube. I love that name. All of us moms, I think, can relate to that a little bit. Is the state able to bring up Lori's other convictions, or is that inadmissible?
So a couple of things. First of all, let me go back to the death penalty question. One thing I wanted to add to that, my understanding is in Arizona, conspiracy to commit murder wouldn't make somebody even eligible for the death penalty. It would have to be a first-degree murder charge, so just put a little clarity on that. Typically, no. Now, having said that, typically you're talking about the idea of bringing in other convictions. Typically, no would be inadmissible. You can make the argument that would be highly prejudicial. Now, here's the problem. What happens if Lori Vallow Daybell decides to take the stand? Then she can open up the door to those other convictions coming in. If she brings up things about, Tylee, or she brings things up about JJ, or she brings up the fact about her prior criminal history, if that should come in, then that can come in, and that would be highly problematic. Now, I also agree that from a prosecutorial point of view, while it might help the idea of telling this story, it could complicate it. Those deaths occurred after the death of Charles Vallow. I think there was a difference between bringing in a little bit about Charles Vallow in the trials with respect to the kids, since that happened before and you're establishing a pattern in a way. I agree that if you put that in, that opens up a whole other section of commentary. It's a whole other case. It will elongate this trial when arguably, if you just take what the prosecutor laid out in the opening statement, they have enough, if they can prove all that, they have enough to essentially prove conspiracy to commit murder of Charles Vallow. They don't need everything else about JJ and Tylee, in my opinion.
Yeah, I would agree with you 100%, but it will she's going to have to be very careful that she doesn't open the door to all of that. And she's already kind of demonstrated during some of these pretrial hearings that she can be a little bit of a loose cannon. So we'll see. I mean, and she wants to testify. She's kind of made that clear. Jesse, this is kind of a hard one. This is a kind of a hard question. I'm just prefacing my question with this. This comes from Margie from YouTube. She's asking, will she serve time in Arizona if found guilty, or will she go back to Idaho? So would she go back to Idaho to do the 3 life sentences, or would she stay in Arizona if she's convicted of Charles's case, and then later the Brandon Boudreaux case, let's say she's convicted on that? Would she stay in Arizona and do that time first, or go back to Idaho?
Well, it's difficult to say in terms of if she's convicted and what the sentence would be. Would she have to serve out a shorter sentence before going back to Idaho? Usually there's a conversation between Arizona authorities and Idaho authorities. But, from a practical reality, if she's convicted here, we are still talking about the fact that she would be serving, life in prison. And it's interesting because when you think about it, it's very similar to the Harvey Weinstein case, right? Harvey Weinstein, I'll give everybody a recent example, right? He was convicted in New York, although we know that conviction was overturned, and he was ultimately convicted out in LA, but he was serving the time in New York. So she wouldn't be the first person who faces trial on criminal charges in multiple jurisdictions, but it does become a question from a practical point of view about where she would serve that time.
Yeah, it's interesting to know. It's kind of, maybe they'd say, well, who wants her? Who wants to keep her? Maybe it would be that simple. Who knows? We're going to go back to Tom for this one. This is a question for you, Tom Evans, from Brittany. I think it's a really good one for you. Do you think the jurors, when you were in the courtroom, do you think they were confused at all? Brittany asks, I know the full story, so I followed what she was saying, but I could see being confused if this is the first time you're hearing it.
Are we asking if the jurors in this trial are confused, or the trial that I was in?
Yes. I'm sorry. Brittany wanted to know if you think the jurors are confused or were confused listening to Trina K lay all of this out. Since Brittany knows the whole story, you know the whole story, but in looking at the jurors, did you sense any confusion on their part?
I didn't notice any confusion in their faces. I was watching pretty closely, And I think she did a really good job of laying it out detail by detail in a way that was pretty easy to understand. And that's why I say, I don't think they need to bring in the deaths of Tylee and JJ and just confuse everything. Keep it simple to what the jury can understand.
Yeah, I think that's good advice. Gigi, here's one for you. How on earth, this is from Melanie Webb, how on earth was Lori ever deemed competent to stand trial, let alone represent herself?
Well, in Idaho, she was incompetent for 10 months, maybe a little more, deemed competent. Also, in order to be able to represent herself, they did another psychiatric evaluation here in Arizona. She was deemed competent. It's really hard to fake those things. They know when you're malingering. And so, look, if you've watched her at these pretrial hearings, although we do see her emotion taking lead a lot, she's not doing the worst job I've ever seen. So I think that she is definitely competent enough to know what she's doing. I mean, these motions do have some research elements to them. She does have advisory counsel, but at the same time, it's not as big of a train wreck so far that I thought it would be. At least in the pretrial, that emotion is what's going to be her downfall if she lets it get to her.
Yeah, it does seem that she, and this is why people usually have a lawyer represent them, it does seem that she does let her emotions get the best of her at times, especially in that hearing last Monday during jury selection. But we'll see how it goes for the rest of the trial. Maybe her counsel can rein her in a little bit. Here's another question for you, Gigi, from Pixie. How long does Lori get for her opening statement? Has the judge placed any time limits?
Not that I know of. I don't, oh gosh, knowing Lori, we could be here till the actual second coming if they didn't put a time limit on it, because she loves to talk and she may go off the beaten path. But I think that the prosecutor will probably be happy to object if we feel we're getting into stuff that's not relevant. So we'll see how it goes. I think that's the $1 million question. What is she going to put forth for that opening statement, and how long is she going to go?
I will be interested to see how she organizes this and how long she does go, because Trina K's, seemed like it was a good length. It was an appropriate length. Tom, we'll get another question over to you. This is from Roxy from YouTube. She asks, I have a question. Does religion influence jurors' decisions?
No. As a juror, I can't speak for other jurors, but myself personally, I was not influenced by that. You kind of have, as a juror, I think you have your emotional side and your more pragmatic side, and the pragmatic side has to be what matters in that situation. So you just take the evidence as it is, forget about any political or religious leanings you might have, and just go with the facts.
I'm going to turn back to Jesse now. Jesse, I think this is a really good question for you, and it's an exciting one because it comes from Scotland, which I think is really cool. So we have an overseas question, yes, from the United Kingdom. This is exciting. I love it when we get the questions from overseas. It's from Adrian Ferguson, and Adrian asks, how does Lori's side counsel work? How are they allowed to help her?
Yeah. So it's a great question. And by the way, let me just say from a practical point of view, many times criminal defendants, who, by the way, it's their choice if they want to represent themselves, if they go back and forth with that and they choose to represent themselves, sometimes courts will say, look, you've abandoned your right to get help from counsel. Now, I don't think we're at this situation. She is allowed to present her arguments. She is allowed to call her witnesses. She is allowed to move forward with the legal strategy she wants. However, she can turn to her help. She can turn to her legal counsel for aid in certain matters about how to introduce an exhibit or how to, prepare a certain filing for the court. She does have them. And they're not supposed to necessarily be like paralegals, but they are her advisors, which, by the way, I think from a practical point of view, helps streamline the case, make it more efficient. But, again, it's either, you can't really have a hybrid. You can't represent, you're not co-counsel. You can't put the opening statement and then then your lawyers then question witnesses. So you don't see that hybrid. She will be in the driver's seat, but if there are times she needs questions or needs help knowing about the rules of evidence or the local rules of that court, it seems that counsel will be by her side to help support her in that way.
Definitely. And you see her from time to time, at least during the pretrial hearings, she kind of leaned over and the advisory council would, coach her or counsel her. So we'll see how it goes throughout the rest of the trial. Gigi, I'm going to turn back to you on this question. This is from Barb Russell, and she asks, will Lori call Chad as a witness? Could you imagine?
Oh my gosh, I would love to see it, but no, he was not on her witness list. She had 11 witnesses and then one expert witness. It's questionable whether any of her witnesses are going to be able to come in because they haven't been sent subpoenas and they haven't been interviewed by the state. So last week, the state filed a motion to preclude all of her witnesses, which would leave Lori Daybell as the only witness if that is granted by the judge. It's going to be something that he addresses as it comes up in the trial, probably closer to that defense case. But he was never charged in this. The prosecutors here in Maricopa County said there just wasn't enough evidence to really guarantee a conviction. Whether or not that changes, who knows? But to me, it would make it seem like they don't have enough right now to charge him. Why would he have anything relevant to say about this trial?
Yeah, most definitely. And he was not on her witness list. And as we know, I mean, she loves Chad Daybell, so she's not going to put him in a position that's going to put him in any legal jeopardy. So, I just don't see that happening. And I wouldn't see her doing that. So Gigi, I know you have to get back to court. So it's been great being back on the air with you. And we will be doing this all week long. So we'll look forward to it. And we want you to get back inside. So thanks to you. And thank you to Tom Evans. It's been great having both of you. We'll let you get back to it. And then Jesse and I will take it from here. So Jesse, I'm wondering what you are thinking we are going to see when the lunch break ends. I mean, I'm wondering what we are going to see when Lori gets up there, because she will be allowed at the podium since she has the rack belt on. That's a security precaution that they're taking. She's going to have an armed guard around somewhere. I think there's one unarmed guard they will allow, but she is going to be allowed at the podium. And she will be allowed to address those jurors looking right at them. So what do you think? What do you think? Because she seems to enjoy being her own advocate. She thinks she can do this better than her lawyers.
It's the time and time again. So many criminal defendants believe that they know the story better than their attorneys. They can't advocate for me. Now, first of all, let me tell you, there is a chance she might reserve her opening statement. She might actually say, you know what? No opening statement now. Let the prosecution start calling their witnesses. She'll have the opportunity to cross-examine them and then reserve an opening statement for later on. Now, there's a lot of times you see that for a lot of reasons. They want to see what the prosecution's case is. But assuming she actually does move forward with an opening statement, again, she has to present not an argument, but an opening statement. It's very different, and she can't make those arguments. So will you see objections from the prosecutor? Perhaps. But what she should try to lay out is what she's going to say and what she's going to present as a defense. And if it's not, it has to be highlighting that she has no connection to this. She can't make arguments that, she's being, she could say that she was scapegoated, that this was a faulty investigation. She could say that the prosecution can't meet their burden. She could try to say, that this is a case where this was all Alex Cox. She had no part in this. This was self-defense. I'll show you why this is self-defense. If you look at the videos, Alex Cox had an injury to his head. Those kinds of things perhaps is where she should go, right? But and downplaying her connection to this. But she's also going to have to explain, maybe not now, but during the course of the trial, why she was interested in the insurance policy. Why? She mentioned, as I said at the top of the hour, why would she allegedly write it was probably Ned before we got rid of him. I think that becomes a part that she has to distance herself away from. But again, it does become a question, where is she going to go in this opening statement? And how much is she going to focus on the law? And how much is she just going to make these arguments that really don't apply? If she's going to be talking about religion, or she's going to be making these generalized statements, I don't know if it's going to do her much good. I can't predict what an opening statement from Lori Vallow Daybell is going to be, because if we look at everything that she has said, I mean, how many times were we questioning what she said on wiretap calls, the jailhouse phone calls? Remember the conversation that she had with Colby Ryan where she wouldn't give an explanation as to what happened to the kids? Do you remember the eerie conversation she had with Chad Daybell when he was saying that the authorities were searching his property, and it was so bizarre, and she is a bizarre individual. She has had competency issues in the past. So it's kind of an unprecedented nature to have her represent herself and what she's going to say. But we'll all watch and try to make sense of it.
Yeah, we definitely will. Now let's kind of fast forward and think past opening statements, because opening statements are not evidence, of course. Let's think about what challenges she's going to have in actually presenting evidence and representing herself. You kind of addressed some of that, but Elenia Goods from YouTube is asking this question, Jesse, about what her biggest challenges will be in defending herself. I know what I think some of them will be, but what do you think they will be?
She's not a trained lawyer. Does she know how to cross-examine witnesses? I mean, if you're going to be cross-examining investigators, what you want to do is highlight problems in the investigation. Did you look at this? How come this was overlooked? Why were you looking at me immediately? If she's being questioned about if she focuses on her interrogation with police, those are the questions. Why did you ask me this? Did you read me my rights? Those kinds of things. But she's not a seasoned lawyer, and even if you get, advice from your counsel, it's very different than practicing for years and years and years. It just doesn't, you're losing a significant advantage. There's a reason you have lawyers. And so the fact that she might, and it could be something little, does she know how to properly, you know what I was just thinking this. Prosecutors themselves will step out of line and they will ask questions that should be objected to. Is she going to make the objections? Her attorneys can't do it. So if she doesn't make the proper objections, the jury will hear things that they really shouldn't hear, but she doesn't know. Objection relevance, things like that. So she's going into a disadvantage. The prosecution is definitely going into advantage, even aside from the evidence in this point of view. One hand's tied behind her back, maybe both. So I think that from a legal point of view, this is not wise in any case, particularly one where the evidence is quite severe.
Yeah, definitely. And I think one of her biggest challenges will be holding in and reining in, keeping her emotions in check. And we saw her last week, Jesse. We saw her having an issue with that. So let's take a little bit of a look at Lori in court last week when she got pretty upset about something.
I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not going to let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice to the other side with the limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dworkin late in the game that they did. I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power, with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say...
And I shouldn't be able to represent myself because of that fact? That negates my constitutional right?
I didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want.
So there Lori was zealously defending herself, Jesse, but still, I mean, yikes. I mean, the judge at some points during that hearing, his patience, and he's a patient man, his patience was wearing thin. But see what I mean? She gets herself really stirred up.
And she makes arguments that might be irrelevant. Look, here's the thing, too, I should mention. If you choose to represent yourself, you're not given a pass. Okay, the judge might allow a little leeway, but only so much. You made the decision to represent yourself. I'm going to treat you like I would an attorney of this court. So she has to know the rules of evidence. She has to know the limitations of her arguments. She has to be prepared. Now, I give her credit, right? So leading up to the case, she talked about whether a government witness was truly an expert, talked about the right to a speedy trial, complained about news coverage of the case, talking about the discovery. She seems to be somewhat, knowledgeable in certain aspects of criminal procedure. But again, she is not a seasoned lawyer, and that is going to work to her disadvantage. And I think the thing that we have to look out for in her opening statement is she going to be making relevant arguments that will actually help her defense? Again, this is conspiracy to commit murder. In order to defend against that, you have to say there was no agreement here. There was no overt acts taken in furtherance of that. That is what she has to focus upon and nothing else.
The trial is that she's not going anywhere. She's not getting a bond. She can't, she's going back to Idaho if she doesn't get her speedy trial, or she's just going to sit there. So it's like the speedy trial argument falls flat for me, but it is her right. So let's go. We have a really good question from Brittany. This is a really good question, Jesse, and I think I know the answer to it, and you probably know better than I do, though. This is from Brittany again. If Lori gets out of hand, can the judge make her advisory council take over?
See, it's a great question. And by the way, is it just from Brittany? Like just Brittany? Like just share? Like
yeah, just Brittany.
Just Brittany. Okay,
Brittany.
Good for you,
yeah.
Just Brittany. I'm reminded of a situation of the Darrell Brooks case. We all remember that, right? You remember that? And
I do. Grounds.
Right.
I'm waiting for that moment here.
There's a difference between forcing you to have counsel represent you versus if you yourself are representing yourself in this case and you become combative, you do not follow the court rules, you may forfeit your right to actually represent yourself. And there does become a question of whether or not you will impose defense counsel upon you. But remember, there is a constitutional right by which a defendant has the right to represent themselves and have counsel. So it does become a tricky area. But if she steps out of line, the court will definitely have to step in and advise whether she cannot, forfeits her right to actually be present in that courtroom for certain points, or whether or not there needs to be defense counsel for her.
Yeah, and I wonder too, does that mess up the entire record then? I mean, you're switching horses in midstream. I mean, I just don't know how that would work.
I mean, it wouldn't be the first time that we see a change like that, but obviously, and by the way, you wouldn't be able to argue a mistrial for your own bad behavior.
True.
So you can't say, oh, this all was chaos in the courtroom. Yes, I caused it, but, I had to have new counsel brought in, or I was stepped out and, mistrial. No, if you cause the issue that creates a mistrial, you're not going to be able to use that to your advantage. You can't use it as a weapon.
Ineffective assistance of my own counsel. I don't think there is such a thing. Okay, so let's go to another question. This is from Cindy. I think it says Cindy T1. If she takes the stand, Lori, and all indications are that she is taking the stand, will she be allowed to question herself or just do the narrative?
It's the narrative. And what was the case that I saw? I'm forgetting which one it was because we cover so many here, but it was the guy out in Las Vegas. Yes, remember that narrative format? Yeah. You provide a narrative format. It has to be, you can't just, go off track, otherwise there'll be objections. You give a narrative format about what happens, and then you subject yourself to cross-examination by a seasoned prosecutor. And there are there's no protections really. You open yourself up, as we talked about before. But yes, she can give a narrative format. That'll probably be the most streamlined way to do it. Sometimes you can prepare certain questions that are asked, but usually I think for this case, it would probably be a narrative format.
Let's go back to some other questions. I'm scrolling through. Danielle Hefner from YouTube. I'll take this one really quickly. This is an easy one. Anyone know if Chad Daybell is actually on death row? Yeah, he was sentenced to death, and you automatically get to appeal when you are sentenced to death.
So wait, just one thing I have to add. We have great producers, Anjanette, and I stand corrected. I thought it was the narrative format. Apparently, the judge will not let her testify in a narrative format. She has to submit questions ahead of time to her standby counsel. So I stand corrected.
Okay.
Okay. So thank you to our amazing trial producer, Kathy Russin, for that. She knows a lot more about this.
Okay, got it. Thank you, Kathy. Yes, thank you. And thanks, because I don't think I was aware of that one either. So thank you so much. We have a question from J&J's Mom 47 from YouTube. If Charles was the first murder, why is the trial just starting now? Well, there are several reasons, Jesse, but I'll let you start, and then I can always chime in too.
Well, I think it was the way this investigation unfolded. I mean, it started with the disappearance of the kids, and then when their bodies were recovered, it led into everything else. Once you figure out what evidence that led to her being convicted of the children, you see this was there was always weirdness. There was always weird aspects of the story. His death. The alleged shooting of Brandon Boudreaux, or towards him, the attempted shooting of Brandon Boudreaux. There was the death of the children. There was the death of Tammy. But you first dealt with the death of the kids, and then Tammy, and then you realize, then she was ultimately indicted after that. So it just became a timing. It wasn't as if she was indicted for the conspiracy to commit murder of Charles Vallow first, and then the children. It was the way the timing of this all shook out, and she was already in the middle of the trial, or it was already leading up to the trial of the kids.
Well, and let's think of the timeline here. I mean, Charles was killed in July. The kids, were killed in September, Tammy in October. And really, I mean, I remember this. I remember working in local news and reading this story every Saturday morning about these missing children, right at the beginning of COVID. And it was just how the whole thing unfolded, as you said. And it almost seemed like they were suspicious about Charles's death, but maybe didn't have enough to charge it back in July, August of 2019. I mean, that's kind of that's the feeling I always got from covering this case. They couldn't say definitively that maybe it wasn't self-defense. And then Alex Cox dies of natural causes. I mean, it was just, as you said, the way it unfolded.
And let me also say this, the way that they prosecuted her in Idaho for the death of the kids was very consistent with how they're prosecuting her here. They're not saying that she was the one necessarily who killed the children, that she physically killed them, but through text messages, conversations, phone calls, witness testimony. It was the idea she was a part of this plan. And if you accept that this was all a pattern going on for several months, that the death of the kids, the way she was a part of that, is allegedly the same way she's a part of the death of Charles Vallow.
Yeah, definitely. I mean, they didn't say that she was the one that physically carried it out. But I mean, they were church. I always said they're her children. If your children are gone and you don't know where they are and you're doing nothing to find them, you've got a lot of explaining to do, a lot of explaining. We have a question from, I already did the question from J&J's mom. I apologize. Let's look at another soundbite. We're going to look at another piece of sound from prosecutor Trina Kay. And this is from the opening statements. And I think we both agree, Jesse, that Trina Kay, as we said, she did a pretty good job in her opening statement. So it was what she needed to do. So let's take a look.
Lori, Chad, and Alex used religion, the Church of Jesus Christ of Latter-day Saints, and a story of Nephi, a prophet, who was directed by the Holy Spirit to kill Laban, to obtain brass plates and secure the long-term prosperity of Nephi's descendants. Lori used this religion and the story of Nephi as justification to kill Charles Vallow, just like Nephi killed Laban.
And Jesse, this is kind of was my thought about this a lot of the time covering this case. It wasn't necessarily that they were religious, but possibly using religion and their beliefs to justify what they wanted to do. And that seems to be where she is going with this. And I think she will get into the religion a little bit. She has to. How can she not? Because you're basically, you have Charles Vallow on body camera telling the cops she is thinks I'm Ned Snyder, that I'm evil and I'm possessed and all of this stuff. So it's a huge part of this.
It's tied in to the timeline here, right? You heard from the opening statement that there are witnesses and text messages that would say she kept referring to this, entity within Charles as Ned. You can't just separate those conversations. And if you say that she thought that he was possessed, and again, let me go to alleged message between Lori and Alex. Thanks for standing by me. It's all coming to a head this week. I will like Neffy, I am told, and so will you. Or when Lori sent Chad a message, I talked to the insurance company, he changed it in March. It was probably Ned before we got rid of him. This is inextricably tied, the religious aspect to it, and I agree with you. It wasn't, one would say that it was just a devout twisted belief system, or is it being used to get rid of the people that were in your way of living a life without your significant other, as we heard during the trial with respect to the kids? Money, right? Why is an insurance company? The same thing with getting the benefits of JJ and Tylee. So you're seeing, what was it, money, power, sex was the theme in that first trial. I mean, you're dealing with very similar elements here. And let's not forget, Charles Vallow was an incredible witness in this case. He had filed for a protective order. He was talking about how he was concerned for his life. I mean, these are things that a prosecutor really needs to sell the story that the person he thought he loved had these twisted beliefs and he thought his life was in danger. And all the stuff, I mean, the idea that Lori was allegedly drugging Charles, poisoning, putting pills into his protein shakes, and then he just happens to die. This is all part of a timeline that the prosecutors need in order to find her guilty of conspiracy.
I still, Jesse, cannot to this day get over the fact, every time I watch that body camera footage from January, I can't get over the fact that a husband went to the police for help and nothing happened. I mean, it's stunning to me. And I hope that something good has come of this, maybe some better training and recognizing mental health stuff. We have some other questions, though, that I think I should get to. A question from Roxy on YouTube. Do inmates have access to legal resources and materials to represent themselves in court?
So I think the best way to explain is what's happening right now with the Sean Combs case, right? So he wanted a laptop with all of the evidence. If you're representing yourself, and even if you're not representing yourself, you have a constitutional right to put forward a defense, to participate in your defense. You can have access to the materials. You won't necessarily have access to, I mean, maybe there's a law library in the jail, but you do have access to the evidence. Now, it doesn't mean that you're going to have a personal laptop that you can use whenever you want. Obviously, there's certain limitations put on it, but you do have access within the confines of a jail and working with your attorneys to have access to the evidence and prepare. This becomes a question where she's representing herself. So, there, again, in the Combs case, a lot of those materials were attorney's eyes only, and he would be excluded from seeing certain things. Here, even if there were certain aspects of designation, she's the attorney now. So she would have a right to see it all in order to prepare for her defense.
Yeah, most definitely. She has complained, though, in some of the pretrial hearings about being kind of hamstrung by the limitations of being incarcerated. I mean, she can't just go out and interview people.
Correct.
Her investigator has to do it and that type of thing. And, so there may be some materials and stuff she has access to, but she's kind of complained about some of the limitations when she's kind of put herself in this position. Yeah, she has the right to represent herself, but she's kind of painted herself into a little bit of a corner. Let's go now to another question. This one is from Susan Lee. Can Lori and Chad, I think this is a really good question. I wonder this. I don't know if either of us know the answer. I'm thinking it's probably no, but can Lori and Chad speak right now between prisons?
That's a good question. My answer would probably be Not.
I don't think you can call
mean,
each other between prisons. Maybe write letters.
I don't have an answer to that one. I don't have an answer to that one. You know, it was one thing to say leading up to the trial, you know, you had these competing interests and co-defendants in a way. I'm not entirely sure. That's a good question. I would love to get a little more clarification, or maybe if someone knows if they've communicated and I'm just not aware of it. Yeah, I'm not entirely sure.
Yeah, and I mean, he's on death row.
Yeah.
And I've always heard death row is pretty restrictive, but
he
other
could
people
maybe
say
write a
it's actually
letter.
not.
He could maybe write a letter. Yeah.
That's what I'm thinking. Write a letter, or they have those kind of like internet-based services these days where you can write to somebody. I can't imagine that you can do this.
Yeah, I don't imagine.
I'm not so sure about that.
Yeah. Unless they were trying, I wonder, you know, unless they were trying to have a situation where they wanted to record that conversation, because we know jailhouse calls are recorded and it could be used as evidence later on. But I'm tough about that one. I don't know.
Yeah, I don't know either, but that's a great question, and I think we'll dig into it, maybe look into that a little further and bring you the answer later this week as we continue to do these live lunch show Q&As all week during Lori Vallow Daybell's trial. So Jesse, it's been great hanging out with you here on the live stream this afternoon. Always fun. Love hanging out with you.
Love hanging out with you, Anjanette. Even though we're not, you know, we're distances away. We get an opportunity to talk. Oh, by the way, wait, one more thing. We know for a long time that Lori had regular contact with Emma. So this is Chad's daughter, and presumably she would pass messages between them. So that's a little update again from our producer.
Oh, Kathy has a lot of tea. Well, Kathy's going to be on here later this week too. So
Kathy's much better than I am. So you're in good hands.
She's going to spill a lot of tea, as the kids say, later this week. So I've also heard about some weird stuff where they do stuff with the phones, where they do this, but that was probably old school, like turning phones like this. I don't know. We'll talk about it another time.
Is this the way you secretly communicated? Because you've lost me. You've lost me.
No, just stuff I've heard over the years covering crime. But yeah, it's been fun hanging out with you, Jesse. We'll do this again sometime. And we're going to wrap it up for now, though, everybody. Thank you so much. Stay.
All right, so that was the Law and Crime Show. Sorry. That was a good way to spend the afternoon break, the lunch break, and now getting us ready for the afternoon. Okay, so just one thing that I wanted to say. We know that the court is in like half an hour delay and everything, and we know that there is a lot of information about this trial on online. There is on X. There's like literally people live tweeting on it, and a lot of information. But because we are on delay and we've decided to try not to spoil as much as we can, so yeah, they are not directly communicating, by the way. What you mean, Denise? They're not directly communicating, by the way. So, I was just, ask if possible, try not to spoil anything in chat. So, we are, just going along, trying not to spoil anything, and just enjoy as we can. Pretty please, just as a thing. Oh, the M passing messages. Yes, so they would not speak directly. Yeah, I agree with that. That was probably a way that they found that they could communicate that probably they would not connect the dots to. But yeah. So it just wasn't interesting. I like them. I really like. I am obsessed. I think not saying that I like one better than the other one, but I think I really like Jesse, and he's cute. So don't worry, Garden Bot is not listening to me. I'm joking. But they do speak quite well. They seem to know what they are speaking about as well. They do their investigations and everything. So they're good they do a good duo, so it was very good to watch that throughout the lunchtime for sure. And now getting ready for the well the main show. So since the Lori Vallow is the Super Bowl trial for the true crime, I think one of the Super Bowl trials for this year, is her openings the halftime show? Is that what we're calling? Is the openings the halftime show? So that could be it. I mean, that would definitely be rather interesting. That yeah, that could be. Sorry, the halftime show. Um, Hey, welcome back, Paula. We are almost back as well. Court should be back in about 15 minutes time. Um, I was just looking for something. Oh, my phone is telling me that it's time to go to bed. Phone, it is not because we are in a crazy time zone right now, so I need to change that. Well, it can just be I can just save some battery, but I do need notifications on, so I need to change the time. Uh, this thing is gonna be. You know what? I'm gonna turn off this for now. How do you turn off the sleep schedule thing on? There. The one simple button. There we go. Um. Oh yeah, some halftime shows. I absolutely agree with that. I see some pretty good disasters halftime shows. I can remember only one right now. I think it was the Jeanette Jackson one. That incident that we all think we all know which one I'm talking about. That definitely happened. At the Super Bowl. But this was it this year? Oh my days, I don't even know anymore. I think it was this year or last year's. The one with Kendrick Lamar was actually pretty good. I liked it. I liked that one. Um, so that why are we talking about halftime shows? Oh, because I was calling it the Super Bowl of true crime. Oh, I completely forgot. I did not turn on the camera. Let's try to see if the camera, because Garden bought dimmed the light in the living room, so we'll see if the camera. Hang on, I need to get ready. Oof. Now, see, this is how crazy my body is. Now I'm yawning. Now that I'm talking and like trying to engage with you and everything, my body's like yawning. But now, um, yeah. Why that didn't show? I can see your comment, Robba, um, on StreamYard, but it doesn't show on my YouTube, which is weird. Yeah, I don't speak English, Paula. I am in my PJs. I am comfortable. I am working from home. Oh, Michael Jackson, yes, Mr. Michael Jackson, indeed. It was a very good one. Obviously, I think it was before my time, but I did see it on YouTube's. Hey God. It was very, very good. And there was another one, I think it was. Oh my days, don't quote me on it. I think it was Shakira and Beyonce, maybe. They were good as well, so, yeah. Oh, hello, Plum Awesome Bruce. Bruce, nice to see you. Hello, my friend. Um, I thought the judge had a no contact order for Lori and Chad. I think so. I'm not 100% sure on that one. Hang on. Not 100% sure. So, weird. Um, oh, it's 3:47 there. So right now here it's 10 to 10 p.m. So it's 10 to 10 p.m. So I'm trying to remain not like give any facial expression because I'm getting notification about what have happened in court, and I'm trying not to one spoil it anything because we decided not gonna spoilers, and second try not to give anything away. Oh, did she? Which interview? Is it this latest interview that she did? Because I know she did a new interview, right? And, um, yeah. Hmm. So, yes, it is. There is a 6 hour difference, Robert. So when it's midnight for you, it's 6 a.m. for me. So when you stream at midnight, that's why I'm generally always at work because yeah. Yeah, you are always smart, Robert. You are amazing, girl. Don't you even? Um. Oh, you're eating your. Are you nervous eating, Lois? So. Oh yeah, sorry about that, Robert. Yeah, I think you'll yeah gift the membership it run out. Sorry, my friend. But no matter what color, I can still see you. So yeah. Um. Oh, why so many notifications? Why am I getting so distracted? Oh, well, this is actually about Corey Richards, not about Valor. So, oh, Robert, thank you very much. Thank you, girl. Welcome back to the Grin Gang. You are amazing. Thank you very much. You are amazing. Thank you, Robert. Thank you, my friend. Thank you, thank you, thank you. Love you. Thank you. Oh my days! Tomorrow morning, when you start your stream, Robert, I am gonna be finishing work, so I'm gonna be like a zombie. Like, but hey, I'm not gonna be packing bread. Oh, thank you very much. Oh, thank you. I really appreciate it. Oh, I do. But the thing is, I'm trying not to eat too much because, oh, you know, clothes are struggling to fit. Um. Oh no, I can't. I'm still gonna be at work, so I can't sleep really. Um. Well, did you sometimes do lie about the serving size? What I'm gonna do probably is I think probably during the. I don't think I'm gonna be sleeping during her openings. So, because it's just gonna be too entertaining, I think. Yeah, I think it's gonna be way too entertaining. The openings for Lori's openings, I think they are gonna be way too entertaining to miss that. Well, maybe the first witness. Um, if I might take a snooze. So if you guys see that I'm turning off my cameras because I'm gonna literally take a little snooze. But I don't think that is gonna happen. It might happen more towards the end of the stream. That will be like pretty late here. Even though this is already pretty late here. It's already almost 10 o'clock and I'm actually cold. I think I'm gonna go grab another hoodie or something because I'm getting a little bit cold right now. I don't know why the temperature has been dropping so much during the night here that this morning or last night when I was gonna gonna go to work, I had to defrost my car. So which is crazy. It's like 44 degrees right now here. So hey Zio! Hey! Hi girl, thank you. Hello. How you doing? That I hope you're okay. I think I might go. I have to go grab a jacket, but I will wait until court starts, so I'm fine. Oh, I will definitely let you know, Robert. I do need to speak to you about Wednesday though. Definitely for sure. Um. Oh, well, I'm pressing in all the buttons now. Stop pressing all the buttons. Um. Ooh. You've been lurking again. Oh no, I thought I was being watched. I was not going crazy, was I? It's nice to see you, my friend. Hello. I hope you had a good weekend and you had a good birthday. Everybody was Zio's birthday on Saturday. Haha, I'm telling everybody. It's not a state secret. If he was, I would be the wrong person to say to keep a state secret because I'll definitely be talking to everybody. Not in a creepy way. Well, I would not say anything about Zio. I don't speak English, Plum, anymore. I am like, as late as it gets, I'll get more unhinged. And then it's gonna be the rest of the unhinged stream for the rest of the night. Well, into the early nights while I yawn away, and see, this is what it annoys me so much. Yeah, I know, yeah, another April birthday that we found. I need to turn off the notifications on X because it's starting to get really, really getting to me. Believe me, because it's kind of spoiling, and then yeah. So it's about 5 minutes to go. Still, my days, I can't believe it starts at 5 p.m. Eastern. I'm crazy. Y'all, why do I do this to myself? No, I'm joking. It's not that well, Hannah, considering that I have to normally I start after work. I start work at 4 o'clock in the morning our time. This trial ends at 1 a.m. for us. But now I'm gonna go to work after the trial. I'm gonna go to work. So trial starts at 1 o'clock. Finishes, sorry. Trial finishes at 1 a.m. for us. I have to be at work at 2:30 in the morning until 8:45, and then do everything again. So, yay! That's gonna not be crazy. So yeah, that is gonna be my schedule. Hopefully, oh, you want to start working? Oh, you do the really night shift. Yeah, I'm going to work after this. I mean, I'm actually gonna try. The thing is, if I show up earlier, they're not gonna get there until 2:15. I don't know. I'm gonna try to maybe go early, because if I start at 2 o'clock, because if the court does finish at 1 o'clock on a dot, saying goodbye and not saying goodbye to everybody, I'm gonna see if I can start for 2, because if I start for 2, that means I can finish at 8:15 in the morning. So that would be good, because I could come home earlier and sleep earlier. So that's gonna be the goal of it. To see if I can get away. But I do want to have a coffee before I go to work, because otherwise I'm gonna be sleeping inside of the oven, and that's not good. So it's definitely not good sleeping inside of the oven. But I don't want to be doing. The thing is, it's only technically 3 nights, so it's not gonna be that bad. The rest of the other 4 nights, I can, like, after the court finishes, I can go to bed, and we have Fridays off. So, well, I'm gonna try and stay out of the oven. I don't promise anything, Rubber. I do not speak English. I don't know. No, I'm joking. I'll be fine. Normally I have 2 energy drinks there, but I'll try not to drink them. Obviously, unless if I have to. It is very warm there and very, very cozy, Hannah, in the oven. So nice. And then the smells even. Oh yes, that is easy. That's fine. I mean, they said 5 to 6 weeks. I'm prepared to do whatever, like, the length of this trial. So that is absolutely fine. Then I'll just do a sleep study within myself after this trial. So, oh, I love it too. But the thing is, also, I do need to speak with Zio and Rubba, because at the end of this month, I might be gone for a week, because as you guys know, and I've been saying this for a while, my niece is born at the end of this month. We still don't know the date. We're gonna find out, I think, on Wednesday. And obviously, I want to be there for the birth and support my sister-in-law, and to be there, be with family, because it's a very emotional time for us, even though it's a very awesome time, but it's also going to be very emotional because of situations that happened in the past. And I want to be there for them. So I might have to ask our beautiful friends, Rubber or Zio, or both, to do the trial if they want for us. So I still need to sort that out. But I still need to know. I need to know first the date that she's gonna go. So, oh yeah, definitely. I want to be there 100% sure for my sister-in-law, for my family. So yeah, so I'm gonna have that. But obviously, if I know we're gonna have like a verdict watch type thing, I'm definitely gonna be here. I am not gonna miss a verdict for Lori Vallow. For like, I would obviously, it's not gonna be a judge is here. Wow, this judge seems very on time. Judge, it's not playing. Hang on. You did not miss anything. There was no sound whatsoever. I'm a professional streamer. Here we go, guys. You ready?
All right, we're on the record. State of Arizona versus Lori Daybell. The attorneys are present. The defendant's present. The jury is not present. We ready to bring in the jury?
Yes, Your Honor.
All right. Let's bring in the jury.
All rise for the jury.
All right, the jury is now present. Please be seated. All right, the defendant can proceed with her opening statement.
Ladies and gentlemen of the jury, I have been charged with a crime, a serious crime. And the only question here is, did I commit this crime? Conspiracy. Conspiracy is an agreement between two or more people to commit a crime. Okay, so you see here. Okay. There has to be an agreement. There has to be a plan. The evidence in this case will show that Charles Vallow and I got married in February 2006. It will show that it was my fourth marriage and Charles' third marriage. At that time, we each had 2 children. I had Colby, who was 9, and Tylee, who was 3. Charles had Cole, who was also 9, and Zach, who was 7. The evidence will show that our family moved from Austin, Texas to Chandler, Arizona in 2009. The evidence will show that Charles and I adopted our great-nephew, JJ, who was born in 2012. It will also show that Charles and I were married for over 13 years and were raising 5 children. The evidence will show that I was a licensed cosmetologist and worked as a hairstylist for 20 years while we lived in Austin, Texas. The evidence will show that Charles was a licensed life insurance salesman and worked as an independent contractor, selling life insurance policies and annuities, and owned his own business. The evidence will show that Charles and I purchased life insurance policies early in our marriage, and Charles had them issued to the maximum amount possible to each of us. The evidence will show that Charles was 17 years older than me, and that because of Charles' age and an issue that he had with high blood pressure, the maximum amount of life insurance that could be approved for Charles was $1 million. The maximum amount of life insurance that I could be approved for because of my age and my health was $2 million. The evidence will show that throughout our 13-year marriage, that we always had life insurance policies. When a 10-year policy lapsed, Charles would shop for another company who would approve us for the maximum amount of life insurance. The evidence will show that this was Charles' job. This is what he did. I helped him in this business, and this is what he did. The evidence will show that in 2016, Charles repurchased a new $2 million life insurance policy on me, and he was the sole beneficiary. The evidence will show that Charles and I had a happy marriage for 13 years, that he was, in fact, a baseball player, and that he played high school, college ball, and AAA ball, and that he was, in fact, a left-handed pitcher, a southpaw, they call him, but he was a right-handed batter, as could be attested to by anybody who knew Charles well and his high school baseball coach, Greg Davis. The evidence will show that Tylee was, and in 2014, our family moved from Chandler, Arizona to Kauai, Hawaii. We lived there for 3.5 years and returned to Chandler in 2017. The evidence will show that Tylee was 3 years old when Charles and I got married, and that when she became a teenager, the relationship between Tylee and her stepfather, Charles, became so difficult that Tylee and Charles had to seek a therapist, a family therapist, to stop them from fighting. The evidence will show that together, Charles and Tylee met with this therapist after we moved back to the mainland in 2017. The evidence will show that in April of 2018, Tylee's biological father passed away from a heart attack. And at that time, Charles called Social Security and made an appointment at the Social Security office.
I'm going to object to hearsay.
Sustain.
It will show that we did get Social Security for Tylee for her deceased father until she was 18 years old, and she was 15 years old at the time. The evidence will show that Charles and Tylee's fighting increased greatly in January of 2019 when Charles and I temporarily separated. The evidence will show that several people witnessed these terrible arguments between Tylee and Charles that increased to physical in 2019. Charles and Tylee had major increasing arguments, 2 in February of 2019, 1 of March in 2019, which was captured on video, 1 in May of 2019, 1 in June of 2019, and then the worst of all in July 2019. The evidence will show that in March of 2019, Charles pulled JJ out of his special school and moved him to Houston, Texas, while we were temporarily separated. Tylee and I then joined Charles and JJ in Texas in April 2019 to reconcile. The evidence will show that JJ was diagnosed with severe autism when he was 3 years old while we lived in Hawaii. The evidence will show that for 2 years, JJ was attending a school in Gilbert, Arizona, a special school for children with autism. It's called Lauren's Life Academy. The evidence will show that in June of 2019, in JJ's best interest, Tylee, JJ, and I moved back to Chandler, Arizona to re-enroll JJ back in Lauren's Life Academy since he had a difficult time with the Houston, Texas schools with no services for his autism. The evidence will show that Charles and I agreed it was in JJ's best interest to be in school where more services were available to him, so Charles and I rented a house here in Chandler. On the day in question, July 11th, 2019, Charles and I were renting 2 houses. one in Houston, Texas, where he mainly resided, and one in Chandler, Arizona, where I resided with our 2 minor children, Tylee and JJ. By this time, our 3 older boys, Colby, Cole, and Zach, were adults and not living at home any longer. The evidence will show that during the months of June and July, that my husband, Charles Vallow, began to send me threatening text messages. These messages were seen by my sister Summer, and that worried her. The evidence will show that Charles insisted on flying into Phoenix on July 10th, as we've heard from the state. The evidence will show that I advised Charles that he could not stay with us at the Chandler house because he could not get along with Tylee, and I did not want them to get into another fight like they had 3 weeks prior. The evidence will show that it was ultimately decided between Charles and I on text messages that he would stay in a hotel because he traveled for business all the time and stayed in hotels all the time, and that I would book it for him since I worked for him and booked all of his travel. The evidence will show that Charles did in fact fly into Phoenix on Wednesday, July 10th, and stayed in the hotel that I booked for him. The evidence will show that Charles paid to fly my brother Adam Cox into Phoenix from Kansas on the same day, Wednesday, July 10th, 2019. The evidence will show that Charles planned to come to our Chandler home and pick up JJ and drive him to school on Thursday morning, July 11th, 2019. The evidence will also show you that Lauren's Life Academy opens its gates at 8:25 a.m. in the morning. And the evidence will show that Charles showed up at our Chandler residence around 7:30 in the rental car I booked for him on the morning of Thursday, July 11th, 2019. The evidence will show that Charles began texting with my brother Adam Cox before he entered our residence, and that Charles and Adam were discussing in their text communications that my other brother Alex Cox was at the residence. The evidence will show that on the morning of July 11th, that Tylee was asleep in her room and my brother Alex was asleep in the guest room. The evidence will show that when Charles entered the house, only JJ and I were awake and present. The evidence will show that after we put JJ in the rental car, that Charles came back into the residence to receive his phone, leaving JJ in the front seat of the rental car with the engine running. He was 7 years old. The evidence will show that Charles began to scream at me when I refused to hand him his phone. The evidence will show that Charles' screaming woke up Tylee and Alex. The evidence will show that Tylee came out of her room with a bat to protect me, her mother, from her stepfather, Charles Vallow. The evidence will show that Tylee and Charles fought over the bat, and that after a struggle over the bat, Tylee fell onto the ground, and Charles lifted up the bat to hit Tylee with the bat. The evidence will show that Alex then intervened to protect Tylee from being hit with the bat. He did not have a gun. He was not wearing a shirt. He was pulling up his jeans because he just woke up and came into the room where he heard the screaming. The evidence will show that Alex and Charles got into a physical struggle for the bat and fell onto the ground. The evidence will show that Tylee, who was on the ground, was lifted up by me and sent outside to get away from the struggle and to protect JJ, who was still in the running car, in the rental car in the driveway. The evidence will show that after this struggle on the ground between Charles and Alex, that Charles prevailed with the bat and began to come towards me with the bat as I ran away from him into the kitchen. The evidence will show that at some point while I was running away from Charles, who was chasing me with the bat, that Alex apparently retrieved his gun. The evidence will show that I ran outside to the children and that Alex shot Charles in self-defense. The evidence will show that Tylee and I had both run outside without shoes. The evidence will show that JJ was still in the front seat of the rental car with the engine running and struggling to get out of the car, and Tylee was trying to keep him in. The evidence will show that Tylee and I got into the rental car with JJ and drove away. The evidence will show you that I drove the children away from the residence towards JJ's school. Can I grab a tissue?
Yep.
The evidence will show that I drove the children through the Burger King drive-thru that Charles had promised JJ. The evidence will show that we continued to drive towards JJ's school and that the gate was not yet open at JJ's school. So we drove a block west of the school to a Walgreens where I ran in to purchase flip-flops for Tylee and myself so that we could walk JJ into school on the hot pavement. The evidence will show that Tylee and I returned directly to our residence where we met with police in our driveway. The evidence will show that we were spoken to by the Chandler police officers. And the evidence will show that Tylee and I were told by the Chandler police detectives that Charles had passed away. The evidence will show that we were put into a police van and driven to the Chandler Police Department. The evidence will show that Alex was taken by police in a police car to the Chandler Police Department, and that we were all three separated into interrogation rooms and we were each interviewed. The evidence will show that next, Tylee and I were brought back together into a room at the Chandler Police Department and were introduced to a victim's advocate who was very kind to us. The evidence will show that after speaking to the victim's advocate, that Tylee, Alex, and myself were put back into the police van and driven back to our residence. We were directed by the Chandler detectives to take the rental car and return later to the residence after we picked up JJ from school. The evidence will show that we did as instructed by the Chandler detectives. The evidence will show that we drove to Alex's residence where we attended to the wound on the back of his head. The evidence will show that Alex was then contacted by the Chandler detectives to return to the residence so that Alex could walk them through the events that occurred with the detectives at the residence. The evidence will show that Alex, Tylee, and I did return to the residence as instructed. And the evidence will show that Alex entered into the residence with Detective Moffett, but that Tylee and I were met by Detective Inkland in the front yard. The evidence will show that at the time, Detective Inkland asked Tylee and myself if we had Charles' cell phone. Tylee retrieved Charles' cell phone from the rental car and gave it to Detective Inkland at 3:11 p.m. on July 11th, 2019. And at that time, Charles' phone was placed in the custody of Chandler police detectives. The evidence will show that Detective Inkland asked us if we knew the passcode on Charles' phone, which Tylee proceeded to give to Detective Inkland. The evidence will show that Tylee and I left the residence to pick up JJ from school, while Alex remained at the residence with the detectives. The evidence will show that by the time Tylee, JJ, and I returned to the residence, that all police, EMS, CSI, and detectives were gone from the residence and only Alex remained. The evidence will show that the next day, I contacted Chandler Police to inform them that Charles' belongings were still at the hotel. I asked the detective if I should go get them, and I was told that they would take care of it. The evidence will show that I asked the detectives, what should we do next? And they directed us that they would contact us in about 3 weeks after their supervisor passed off their reports and Alex could go to the police station and retrieve his gun. The evidence will show that the last thing I heard from Chandler Police Department until June of 2021, 2 years later, when I received a grand jury indictment from them for this alleged crime. The evidence will show that Chandler Police treated this incident as self-defense.
And object to that.
Objection sustained. The jury should disregard that last statement.
The evidence will show you that my brother, Alex Cox, passed away on December 12th, 2019, almost exactly 5 months to the day after Charles, my husband, passed away. The evidence will show that Alex passed away from a blood clot in his lung.
Objection. Again.
I'll sustain the objection. It's not relevant for this matter.
The evidence will show you that I am the only person being charged with this crime.
I would object to the relevance of that.
Sustained.
As the state has mentioned, they're alleging that insurance money was my motive. Social Security was my motive. Spouses having insurance policies is not a crime. Collecting Social Security is not a crime. Self-defense is not a crime. A family tragedy is not a crime. It's a tragedy. Thank you.
All right, the state can call its first witness.
Thank you. If I may go get him.
Oh, thank you very much for the good spelling. X was my friend and spelled it for me.
All right, sir, you're going to come up right here. My clerk will swear you in right here.
W-I-E-R-Z-B-I-C-K-I.
And your first name?
I-R-W-I.
Thank you. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you're going to have a seat up here.
Sir, would you please tell the jury your name?
My name's Sergeant Erwin Worsbicky. I work for the Chandler Police Department.
How long have you worked for the Chandler Police Department?
June will be 10 years.
Did you have any prior law enforcement experience?
I had 10 years in Illinois.
Back on July 11th of 2019, what were your duties at that time?
I was working as a patrol officer, I believe in beat 18.
And what were your hours?
0600 to 1600.
Is that 6 a.m.?
6 a.m. to 4 p.m. Yes.
Thank you. Were you dispatched to a residence at 5531 South Four Peaks Place in Chandler, Maricopa County, Arizona?
Yes, ma'am.
And what were you dispatched for?
It was a shooting.
Were you the first on the scene when you arrived?
I
What
was,
did you
ma'am.
see? Okay. What were you wearing at the time?
I was in full patrol uniform.
Does the Chandler Police Department, back then, did they have body-worn camera?
They did.
And can you describe where that was and how that works?
I believe back then I wore it on my left shoulder.
Okay. And how does it get activated?
You have to press a button and it'll turn it on.
Does it normally record audio?
Yes.
And did you have that on and did you activate it when you arrived to this scene?
Yes, ma'am.
Were there other officers on scene at some point when you got there?
After I arrived, yes.
You're saying it was 760, so I pulled a picture.
What other officers arrived on scene?
Right after I arrived, Officer Krautheim arrived.
Can you describe to us sort of what happened as you get to the scene? How did you guys, you and Officer Krautheim, handle the situation?
When I was getting out of the car, I believe the gentleman that called in was still on the phone, and we advised dispatch to tell him to come out with nothing in his hands except his phone. As he opened up or came out the front door, I started giving him commands as what I wanted him to do.
So you're talking with dispatch. Is that the same as 911?
Yes, it's the same dispatch center.
So is the person who's talking to the 911 person then just relaying information to you?
Yes.
So you're able to tell that tell dispatch to tell the person to come out?
Yes.
Did you and Officer Krautheim have someone come out?
Yes.
Can you describe for us the person's demeanor as they're first exiting?
He was very nonchalant, very compliant with us.
Okay. You said he still had his phone?
Yes.
Do you recall if his other hand was up?
I do not recall.
Do you recall where he came out of from the house?
He came out the front door.
Okay. When he exited the house, what did you guys have him do?
We gave him commands to come towards us and then have a seat on the curb.
Okay. So there's just two of you officers still at this point?
Yes.
What did you do at this point?
I decided to go check for anybody that was injured inside and clear the house, make sure there was nobody else in there.
Okay. What did Officer Krautheim do?
I believe he started speaking to the gentleman that we had come out the house.
So he stayed outside
Yes.
and you went into the house?
Yes, ma'am.
When you talk about clearing the house, can you tell us what that means? What do you do?
We just wanted to make sure that if anyone needed aid rendered to them, we could render aid to them, or if there are any more suspects in the residence, that we could try to apprehend them.
Does that mean that you walked through the entire house?
I believe so, yes.
Okay. And all that's when your body cam is on?
Yes, ma'am.
When you first entered that house, can you describe for us what you saw when you walked in that front door?
Yeah, initially when I walked in, it opened up into like a day room or something like that, and just off to the right, I saw somebody laying on the ground, motionless.
Did you notice anything about that room?
It was empty.
So no furniture?
No furniture, yeah, it was just an empty room.
The person that you saw to the right, male or female?
Male.
And can you describe how you saw him laying on the ground?
Yeah, he was laying on his back, I believe with both of his hands to his side, motionless. And then I went over to him to check his pulse.
Is that standard for police to check the welfare of any potential victims?
Yes.
When you checked the pulse, did you find one?
No.
Did you notice anything else about this victim?
Yeah, I noticed that there were 2 apparent gunshot wounds to his chest area, and there was blood pooling in like his kind of like neck collar area.
Did he appear to still be alive to you?
No.
As part of your job, both with your prior experience in Illinois and your experience here in Arizona, have you seen deceased people before?
Yes, ma'am.
Did you think this person was dead?
Yes, ma'am.
If you didn't think he was dead, are police trained to do CPR?
Yes, ma'am. We're all certified to.
Would you have
Yeah.
done that if you believed that would have helped him?
Absolutely.
So even though a person appears deceased to you, is fire still called out to check on them?
Yes.
Why is that?
They go through their own process and procedures, and I believe they usually give the official time of death.
Okay. Did you notice anything else in that room where that male was lying?
I can't think of anything right now, no.
Do you recall seeing any projectiles on the ground near the victim?
Objection, leading.
It's a yes or no question.
I believe I did, yes.
When you walked in the house after you saw this male on the ground, did you continue through the house?
Yes, ma'am.
And was that to clear it?
Yes.
And will paramedics or fire come in if you haven't cleared the house yet?
Usually no.
So they want to make sure it's okay as well?
Yes.
After you cleared the house, did you, or as you were clearing the house, did you ever locate any weapons?
Yes, I believe we located a firearm in one of the back bedrooms.
Okay. Did you touch that in any way?
I don't recall.
Okay. After you cleared the house, did fire enter?
Yes, ma'am.
And what did fire do?
They began to try to render aid to the victim.
By the time fire came in, were other officers now on scene?
Yes.
Were you still wearing and recording with your body cam?
Yes, ma'am.
Does the body cam, you told us that it's on your shoulder. Does it always show where you're looking?
No.
So your eyes or your head can be turned to a different direction than what the camera is actually
Yeah,
showing?
if I was turning talking to the judge, my camera would be facing the crowd.
I want to show you a video. And if I can have my paralegal bring that up and have him identify it. And sir, if you can just look at that and let me know if you recognize that as your body cam minus the audio of it.
Yeah, that's my body cam.
Do you recognize that as you in it?
Yes, ma'am.
And you have previously watched that?
Yes, ma'am.
Your Honor, the state will move to admit exhibit number 2, I believe. Exhibit number 2 into evidence.
Any objection?
No objection.
Two is admitted.
And Your Honor, if we may publish it.
You may.
So this is the house you're walking up to, correct?
Yes, ma'am.
As you're talking to dispatch?
Yes.
And this is the individual that is coming out that you asked dispatch to have come out?
Yes, ma'am.
And is that Officer Krautheim in the back?
It is.
Are you announcing?
Yes, ma'am.
Is that standard?
Yes.
That where you checked to see if this male had a pulse?
Yes, ma'am.
That the weapon that you told us that you found?
Yes, ma'am.
Are you letting people know on your radio that you've found a weapon?
I believe so, yes.
You told us that other officers were arriving?
Yes, ma'am.
Is that what we see here happening?
Yes.
And is fire also starting to come in?
I believe they were right behind him, yes.
That you continued to clear the rest of the house?
Yes, ma'am.
So what do we see there?
It appears that the fire is rendering aid to the victim, or attempting to.
Were you walking around trying to find identification for the individual on the ground?
Yes, ma'am.
Were you able to ever find an identification for him?
I was not.
So no wallet laying around?
No.
No ID in his pocket?
I didn't check his pockets, but no, I don't think fire found one.
So you're kind of talking with them to let them know who this is as well?
Yes.
Because they're documenting it.
Yes.
And is that the individual who came out with the phone from the house?
Yes, ma'am.
One that dispatch and 911 told to come out?
Yes.
When you were interacting with him there, what was his demeanor like?
He was extremely calm.
You told us that you were looking for the wallet for this individual. Did it seem unusual to you that you couldn't find one?
I wouldn't say it was unusual. I didn't know if he lived there or not, so I just kind of looked around to see if there was anything laying around.
Is this you still trying to see if there's anything in the residence that might be related to that individual?
I think I was just giving Officer Cohen a recap of what I already went and looked through.
I've shown defense counsel or defendant exhibits 3 and 4. I can have a paralegal bring those up to the officer to review as well. Do you recognize those as sort of screenshots of 2 different views during your body cam footage?
Yes.
State will move to admit exhibits 3 and 4.
Any objection?
No objection.
3 and 4 admitted.
And if I may publish them. So in this photo, when you were looking at it, were you able to see here's where you are checking to see the pulse of this individual?
Yes, ma'am.
And did this also reflect what you had talked about of the blood pooling that had run towards his neck area?
Yes.
Exhibit 4. Is this sort of when we first see you walk back in and we see fire working on the individual?
Yes.
You told us that when that individual who was on the call with 911 came out, that you observed the phone with him. He was kind of holding it.
Yeah.
Did you ever see any other phone in the house as you were looking around? Anything obvious laying around?
I don't recall, no. I don't believe I did.
No phone on the ground near the deceased male?
Not that I recall, no.
After you had cleared the house, allowed fire to enter, and other officers were arriving, were you tasked with going out to put up some crime scene tape?
Yes, ma'am.
What does that mean?
It's just tape that keeps the general public out, keeps the media out, so we have a secure scene, and it doesn't get tainted by anybody or anything.
So that included both the house and some of the street.
Yes, ma'am.
Did that sort of end your involvement?
Yes.
Thank you. I have no other questions.
All right, cross-examination.
It's Sergeant Worsbicky, is that correct?
Yes, ma'am.
I like to get that right. Okay. You said that the individual exiting the house was nonchalant. Is that correct?
I don't know if I used those words, but he seemed very calm, yes.
Very calm.
Yes.
Is that the same thing to you as nonchalant?
I wouldn't use that word, so I would say he looked very calm and unbothered.
But you said nonchalant a minute ago.
I don't recall saying that.
Okay. Does everyone act the same in a stressful situation that you've experienced? No? Are you qualified to give someone a psychological evaluation?
No.
No. You put your hand on my husband's neck for checking for a pulse, is that correct?
Yes, ma'am.
That's what you did when you first came in?
Yes.
Did you perform CPR?
No.
No. Why not?
because it was apparent to me that he was deceased.
And that's not your protocol
To what?
to perform CPR until fire comes in?
Not if it's going to make it even worse because they had apparent gunshot wounds to the chest.
What do you mean by that?
Well, if I start pumping on his chest, it's going to start spewing blood out of his chest even at a more rapid pace.
So when the 911 operator was telling my brother to do that, that same thing would happen?
All depends on when the call came into dispatch.
But I'm saying if you're doing CPR on someone with a gunshot wound in the chest, on the chest.
Could, yes.
Yeah, okay. And you said something else. You said fire gives official time of death. Is that correct?
Yes.
Okay. And what was that time of death? Do you know?
I do not recall.
And you cleared the house before fire came in. Is that correct?
Yes, ma'am.
Okay. And you were looking for some kind of identification?
When
Yes.
I cleared the house,
Yes.
I was looking for other potential victims and/or suspects.
Okay. But you were told on the phone that no one else was in the house but Alex. Is that correct?
I don't recall if I was told that or not.
Okay. Do you have any crime scene investigation experience?
Just my 20 years of experience as a police officer.
And you said something about, and this is just for me to understand, you said something about the casings being to the left of him or to the right of him?
I didn't say they were to the left or to the right.
Oh, did you say west or east?
No.
Oh, sorry, that was my interpretation. Can you tell me what the weapon was that you found?
It was a handgun.
Was it a 45?
Don't recall.
Okay. Could you tell what direction the bullet came from?
Based off the way the body was laying, I could assume it came from where his feet were at.
Near the feet?
Mm-hmm.
Did you see the projectile that was in the baseboard?
I don't recall if I saw that or not.
You said he did not appear alive, that you already thought that he was deceased. Is that correct, when you entered into the house?
Yes.
And what time was that?
I believe I was dispatched to the call at 8:41. So I mean, if I was going to make a guess on what time I walked into the house, I would say I was probably at the residence within 10 minutes.
So around 8:51, perhaps?
Possibly, yes.
Okay. And then when fire took over, is that the normal protocol for fire to take over and do the CPR?
Yes.
And so you didn't do CPR, but they did do the CPR. Is that correct?
Yes.
On top of the gunshot wound.
Yes.
Is that normal protocol?
I don't know what their protocol is.
Okay. I'm just asking because I wouldn't think to do that either. And then you said that you went outside to put up the crime scene tape. Is that correct?
Yes, ma'am.
So after you cleared the house, you left and went to the front yard?
Yes.
And then you were there for how long at the residence before you left?
I couldn't give you a time.
Did you stay for a while, or was that the end of your job there?
I don't recall. It was a long time ago. I have no idea how long I was actually on scene for.
And who is your direct supervisor?
I believe that day it was Sergeant Nocella.
I'm sorry, what was the last name?
Nocella?
Okay. And what contact did you have with Detective Moffat that day?
I don't know if I had any with him on scene.
Okay. What about Detective England, perhaps?
I may have briefly spoke to her while I was on scene.
Okay. 1 time, 2 times, 3 times?
I couldn't tell you a number.
Okay. And then when you have to report to your superior before you left the scene?
He was on scene, I would imagine.
Nocella? Is
Yes.
that what you said? Okay. And then you don't know what time you left, but you arrived at approximately 8:51?
Give or take, yes.
And then did you see me arrive at the scene?
I think as I was leaving, yes.
So approximately around the time that I arrived, you were leaving?
I don't know if I left when you arrived, but I was on my way out of the crime scene as far as I know.
Okay. And then you said something about 2 wounds. Is that correct?
Yes.
And how did you see the 2 wounds through the shirt?
Just was an observation that I made when I saw him laying on the ground.
So did you see 2 holes in the shirt?
I'm not sure exactly what I saw when I was there, but I could see that there were 2 apparent gunshot wounds to his chest.
And then I'm sure, well, I won't speak for you. So when they began CPR, they did open his shirt. Is that correct?
I have no idea.
Because when you walked by, his shirt was open.
Objection to question.
Yeah, please ask questions only.
Did you discuss this case with Sergeant Nocella?
I don't believe so. I would imagine he was on scene and he got briefed by the detectives.
He got briefed by the detectives? Is that what you
In
said?
fact, I would imagine, yes.
Okay. And then have you spoken to the case agent on this case? How many times would you say?
Who's the case agent?
Oh, Detective Duncan. That's my
Detective
understanding.
Duncan?
Mhm.
I mean, I've spoken to him many times in my career.
Regarding this case, how many times do you think you've spoken to Detective Duncan?
I couldn't even put a number on it. I would say very few.
Very few? Like, how many would you guess?
I would say maybe 5 times.
5 times. Thank you. And would that be in-person kind of discussions or?
Yeah, I wouldn't even say they were discussions, probably just in passing.
Okay. So how many times have you emailed with Detective Duncan concerning this case?
Objection to relevance.
Overruled, you can answer if you know.
I have no idea.
What about text messages?
No idea.
Phone calls?
Ma'am, I have no idea.
Okay. And your report that you wrote about this, about how long after the incident did you make your report?
I was done by the end of my work shift at 4 o'clock.
And then did you ever make any revisions to that report?
I don't believe so.
So you left the scene approximately sometime in the morning, and by 4 o'clock that day you had written your report. Is that
Yes.
correct? And you've never changed anything on your report?
Not that I recall, ma'am.
And the report is exactly as you left it when did you review it for this testimony today?
Yes.
And it was exactly the same as when you wrote it at 4 PM on July 11th?
I don't know if I wrote it at 4 PM. It was
Or
done
by 4 PM.
It appears to be, yes.
Okay. Thank you, that's all I have.
All right, redirect.
Sergeant, you were asked about the shooter's demeanor. Were you just telling us what you observed?
Yes.
What did you observe?
I just observed him very calm and collected after just shooting somebody.
And that's both seeing him come out as well as having some interaction with him on the curb?
Yes, ma'am.
When a person is been shot and you check for a pulse and you believe they are deceased, As a police officer, are you supposed to touch the body?
No.
Is the body basically a crime scene?
Yes.
Based upon your training and experience, did you believe that the victim was deceased?
Yes, ma'am.
Do fire have EKG, heart monitors, and things that they use to determine if maybe you missed a pulse?
Yes, ma'am.
When you talked about giving CPR, if an individual is now a crime scene, would giving CPR to that deceased person change the crime scene?
Yes.
And so as someone who believed the person was deceased, you did not want to modify or change the crime scene?
Correct.
You were asked about the gun. Is the gun part of the crime scene?
Yes.
Were you responsible for processing the crime scene?
No,
Why didn't you go in there and pick it up and start handling it?
because I didn't want to alter where it was laying when he got done using it.
You were asked a lot about when 911 was called, when you were dispatched. This was a few years ago,
Several, yes.
2019.
Yes, ma'am.
Is there something called a CAD report that documents when 911 was called, when you were dispatched, when you arrived, and even when you left?
Yes, ma'am.
Would looking at the CAD report help refresh your recollection as to when those events occurred?
Yes.
If I may have my paralegal provide him with a copy of the CAD report.
You want me to?
Starting, does looking at the CAD report help refresh your recollection as to when the 911 call was received?
Yes, ma'am.
When was that?
It was received at 8:36.
Does looking at the CAD report help refresh your recollection as to when you were dispatched?
It appears it was dispatched at 8:37.
So your memory of saying 8:50 or so was perhaps incorrect.
Yes.
Was looking at the CAD report indicate when you arrived?
8:43.
So again, that was a little earlier than your memory was.
Yes, ma'am.
And does looking at the CAD report help determine or refresh your recollection as to when you left the scene?
Yes, ma'am.
When was that?
It's 5:31 p.m.
As a police officer who is one of the first on scene, do you provide briefing or information to your sergeant or the detectives on scene as to what you saw, observed, and did?
If they ask me directly, yes, somebody will brief them that's on scene.
But you have to provide somebody that information to then provide to the detectives?
Yes.
Why is it done that way?
Because usually a supervisor is going to want to know what's going on and what we did, just so the detectives know exactly what they're walking into.
So for instance, if you had to move the gun, they would want to know that, right?
Yes.
Or if you had moved the body, they would want to know that too, right?
Yes,
And if you had found any evidence, would they want to know that as well?
absolutely.
And so is that what you would have to do that day when you are speaking to sergeant or detectives?
Yes.
I have no other questions, Your Honor.
Does any member of the jury have a question for this witness? If so, please write it on the provided form. I'm not seeing any questions come down. You can step down, sir. All right, state can call its next witness.
Thank you. And if I may go get it.
All right, go ahead and have a seat over here to my left.
Sir, would you please introduce yourself to the jury?
I'm Robert Krautheim.
And where do you currently work?
I currently work at the Sandra Day O'Connor Federal Courthouse
Back in 2019, where were you working?
as a Chandler police officer in Chandler, Arizona.
How long did you work for the Chandler Police Department?
25 years.
When did you retire?
About 3 years ago, February.
When you were working there in July of 2019, what were your duties at that time?
I was a patrol officer. I was responding to calls for service.
Okay. And do you recall what your shift was at that time?
It was a day shift. I think I start my shift at 6 and end at 4.
Were you working patrol for Chandler Police Department on July 11th of 2019 at about 8:36 a.m.?
I was.
Were you dispatched to 5531 South Four Peaks Place in Chandler, Maricopa County, Arizona?
Yes.
What were you dispatched for?
A shooting that had just occurred.
Based upon the information that was, well, let me ask you this. When you are arriving to a scene, do you get information relayed to you about this call?
I do.
Why is that?
The call taker is asking the person on the phone what's going on, where it is, who's there, just basic information. And then dispatch relays that information to me as I'm driving to the call for service.
Is that so you have a better idea about what you're walking into?
Yes, it's on a computer, but verbally, the stuff that's really pertinent before I arrive is just verbally done over the air.
So when you were arriving on the scene, did you think this shooting had just occurred?
I did.
When you got to this 5531 South Four Peaks, were there any other officers on scene yet?
Yeah, Officer Wiz was there.
Is that Officer Wisby?
Yes, I'm sorry, I apologize.
What were you wearing?
Patrol outfit, basically a patrol uniform, police uniform, body worn camera.
And back then, where was your body-worn camera?
At the time, it was a lipstick camera, so part of it was here, but the camera's actually on my right shoulder.
Okay. And was that on and recording as you sort of arrived on scene and while you were present there?
Yeah, I started recording while I was driving there.
Okay. When you arrived, did you know whether or not the 911 caller was still on the phone?
Yeah, she was still on the phone.
And when you were talking with dispatch, did you arrange to have this person come out, or did Officer Wisby do that?
Yes, dispatch advised him to come out of the home without anything and hands up in the air. That's kind of standard.
And did he comply with that?
He did.
What exit did he come out of?
At the front door.
Okay. Can you describe sort of his appearance and demeanor as you observed him coming out of the house?
His clothes were clean. He was calm, not emotional at all. Different than what I would have anticipated.
When he first exited, did you notice any injuries to him?
He was holding, it was a white rag at the time. It was just kind of red and white. He was holding on the back of his head.
When he first exited or later?
As he's coming out of the house.
Did you notice any difficulty walking or talking when you first had contact with him?
No,
Any difficulty sitting or standing?
no,
Did you learn the name of this person?
I did.
What was his name?
Alex Cox.
Did you observe him sweating at all when he first came out?
No,
Any type of jitters?
no,
Any uneven or broken voice as he's talking to you?
no,
At some point, did you notice an injury to him?
I did.
And where was it?
On the back of his head, towards his right side.
And what did you see?
I articulated my written report as about an inch laceration, a small like knot, and it was bleeding a little bit.
Alex Cox patting or rubbing the back of his head with some sort of rag or paper towel?
Yes,
Without going into what was said, did you talk with him?
I did.
Did you offer him medical treatment?
I did.
Did he ask for medical treatment?
He did not.
Was there anything about his talking with you or actions that made you concerned that you thought you should override that?
Yes.
Let me make sure you understood. Was there anything about what you observed with Alex Cox talking or his ability to move that made you think you should override his decision to not get treatment, and you thought, oh, he better get treatment, he's so bad off?
Oh, zero, none.
At some point while you were talking with Alex Cox, did you see a female and a teenager show up at the scene?
I did.
And did you eventually go speak with those two?
I did.
Where did you speak with them?
Just on the other side of the street. They had parked right across from the house.
Did you speak with the adult female?
I did.
Did you ask for a driver's license to identify her?
I did.
And who was that person?
Lori Vallow.
Do you see Lori Vallow in the courtroom today?
I do.
Can you point her out and tell us what she is wearing for the record?
She's at the defense table wearing a white shirt underneath looks like a black jacket.
Your Honor, may the record reflect the witnesses identified the defendant.
Shall.
When you went to speak with Lori Vallow, did you know that the deceased person in the house was her husband?
I did.
When you went to speak with Lori Vallow, did you ask her whether or not the individual inside her husband lived there?
I did not ask her that.
Can you describe for us Lori Vallow's demeanor as you were interacting with her?
Calm, nonchalant, just kind of a matter of fact, just talking to me as I'm talking to you now.
When you went to speak with Lori Vallow, can you tell us approximately how many police cars were parked around there?
Well, I don't know either myself. I know there was at least mine and Officer Wiz's. There's a fire truck there. I think there was an ambulance there, and I think there may have been another police car. I can't remember, but there was a lot of emergency vehicles just near the home itself.
And was her brother Alex Cox sitting sort of in view of her?
Literally across the street, like the desk of the prosecutor would be her car. This is the street, and I had Alex seated right on the sidewalk.
When she first arrived, did she actually walk up to where you were with Alex Cox?
Yes, she did.
And you asked her to go back to the other side of the street?
I did.
Did she ever ask you how her brother was doing?
No.
Did she ever ask you if her brother needed medical attention from being hit by a bat?
No.
Did she ever ask you why there were so many police cars around the neighborhood?
No.
Did she ask you why there was a fire truck parked in front of her house?
No.
So other than gathering basic information, did you really talk to her about anything else?
No.
And were you wearing that body-worn camera when you had contact with her?
I did.
After you talked with Lori Vallow, did you go back and stand near Alex Cox again?
Yes.
If I can have my paralegal go up and show him exhibit number 1. Do you recognize exhibit number 1?
I do.
Is that a copy of your body cam footage from July 11th of 2019?
It is.
Is it missing the audio other than during your interaction with Lori Vallow?
Correct, yes.
And did you initially identify that previously as your body cam?
I did.
State will move to admit exhibit number 1.
Any objection to exhibit number 1? Any
No
objection
objection.
to
No objection.
exhibit 1's admitted?
And if we could publish it.
Go ahead.
So is this you responding to the scene?
Correct.
And was your camera flipped upside down initially?
Well, the camera wasn't, the orientation of the software was.
So that's why we see the axon and stuff in the bottom corner upside down.
That is correct.
So this was a gated community?
It was.
As you're driving, did you go by the fire truck here?
I did.
And is it standard for fire to stage a little ways away from the scene when it's a shooting?
Yes.
Why is that?
So they could respond quickly.
Do they want you to clear the residence first before they show up?
Yeah, it needs to be safe for the firemen. We had to make sure there's no one else in the house that was armed or in the area.
And as you're arriving, is the person, the shooter, still inside the house?
I can't recollect. I think he was at the door right now or just coming out to the door.
Why did you pull your weapon?
I was just told somebody killed somebody, so yeah, for my safety, I wanted to make sure I rendered him safe before I put my gun away. It was a threat to me.
So when he came out, he had both his hands up in the air.
Mm-hmm.
So at that point, nothing touching his head yet, no.
Correct.
Now, did you stay out with him while Officer Worsbicky went inside?
I did.
While you're talking with him during this whole time, at this point, he still hasn't brought anything out to try to place on his injury.
Correct.
When he came out, did he already have those sunglasses on the top of his head?
He did.
Why did you have him move over here?
I actually physically couldn't hear him. Fire trucks are incredibly loud, so I had to move away.
So fire had already pulled up to now go inside the residence.
Correct.
And can you kind of see them in the corner going in?
Yes.
Did you learn whose truck that was in the driveway?
I don't recollect right now whose truck it is. I think it's his, but I'm not sure.
And who is that other officer there?
That's Officer Wizbeski. Sorry, I've been calling him Wiz since I've known him.
Shorter. Were you initially trying to control the scene yourself, sort of helping to tell people where to go and what to do?
Oh, absolutely. My head's on kind of a swivel. I'm always kind of looking around like people just walk up to you and asking what's going on. And got to make sure no one's going to walk up to the house. So you just try to keep it as pristine as you can.
So we see him putting his head now, or his hand on the back of his head, correct?
Yes.
And you indicated there's a fire truck there. You asked him if he wanted any medical attention,
I did.
and he declined it.
He refused.
Who are those?
That's Lori Vallow and her daughter.
So when you said across the street, we just saw a red SUV. Is that what you're talking about?
Correct.
So at this point, did you know the name of the individual inside the residence?
Yes.
And who was that?
Charles Vallow.
And did you at this point understand who that woman was that walked up?
Yes.
And who did you believe she was?
His wife.
Normally when someone is shot and killed, is there a team of detectives and crime scene specialists who will come out to handle the case?
Yes.
And are you, as patrol officer, sort of stuck with taking care of it until they arrive?
Yeah, we deal with the burning, bleeding, and blowing up stuff. Anything that takes time and a lot more in-depth stuff, that's what the detectives do.
And then what do we see here that just came up?
Looks like an ambulance.
You told us that you understood when you were arriving that this shooting had just happened. Do you recall at this point when the 911 call came in?
No, I don't remember specifics on the time. I think at 8:39 I was dispatched to it. And I would imagine the call for service came in a minute or two before that.
And approximately, do you recall how long it took you to get to the scene?
Probably 4 or 5 minutes.
We see more people walking up. Are you trying to stop the contamination of the scene by having more people walk in there?
Yes, I told the firemen kind of what was maybe in the house, and Officer Wiz was already in the house, and so we were just trying to control how many firemen went into the house.
So when you're the first on scene, are you trying to have the least number of people go in there as possible?
Yes,
Are you trying to not touch anything that's not necessary to be touched?
correct, yes.
Obviously, if fire's going to work on a person, they're going to have to contaminate it somewhat.
Yes.
Is that when we sort of see fire now leaving?
I couldn't, just from recollection, I couldn't answer that.
We see something in Officer Becky's hand. Is that the crime scene tape?
Yes. We do an inner and then an outer perimeter.
Is it normal for a patrol officer to have to stay with the individual who is the shooter and ensure that no one else is contacting them?
Yes.
So you don't want any of the neighbors walking up to them?
Correct. At this moment, I'm still basically fact-finding. I'm just trying to figure out what happened, when it happened, who was involved, kind of thing. And yeah, I try to keep them separate.
At some point, do sergeants and others start arriving on scene?
Yes, that's my Sergeant Nacella.
When you have a scene like this where detectives are going to be called out, do all the different patrol officers provide their information that could be relevant to one person who can then brief the detectives?
Yes, I briefed my supervisor to let him know from my point of view what I know and what I was told. And then at some point, I think he would disseminate that to the detectives.
Okay. So is this you kind of telling him at this point what you've learned?
Yes.
And can we also see what the body camera looks like on the shoulder there?
Yes, he has the same type.
What made you decide that you needed to go over and talk to Lori Vallow?
Again, it's fact finding, really. It's who are you? And when I say who, I always like to identify them by their Arizona driver's license, because although my name is Robert, I go by Rob. So I don't want to assume her name is just Lori. It could be something specifically or longer. So I usually ask people for identification.
And that's so you can put that into your report appropriately.
Correct.
So we saw the ambulance leave. That means they didn't transport him.
Correct.
Did you learn that you actually couldn't cordon off this area the way you had initially thought because there was only one way out?
That is correct. We initially, as you can see, cordoned off part of the road so anybody couldn't just drive up to us. We later learned that's the only way that part of the neighborhood could actually exit the neighborhood. So we had to change the tape a little bit.
And then we see fire leave here as well. So now it's just police basically at the scene?
Police and I think a crime scene technician.
And are you still the only person responsible for making sure that no one is talking with Alex Cox?
I am.
Okay.
Is this where you go over to speak with Ms. Vallow?
Yes.
Gotcha. Okay. You guys are all right.
You could turn up the volume.
Let me just get do you have a driver's license quick? Yeah, I can just grab it. Thank you. L-O-R-I. What does your middle initial stand for? Noreen. Noreen. N-O. V-A-L-L. What's a phone number for you, Lori? 755? 545. You know, not in Santana. This is your home.
Right.
Gotcha.
Right.
Okay.
We just moved in here.
Gotcha. How long have you guys lived here?
Sorry?
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah. Okay.
That's why the neighbors don't know us.
Gotcha.
Like, hi neighbor, sorry.
Are you working at all?
No.
Okay. And you're still about 5'6", 120?
Did you also get biographical information from teenager?
I did.
Was that Tylee Ryan?
It was.
Let me stop it now. After you had talked with Alex Cox and Lori Vallow, did you go brief some of the detectives about what you had learned?
I did.
Did you tell the detectives that Lori Vallow did not know that her husband Charles was dead?
I told them that I did not advise her of such.
Did you believe that she did not know that her husband was dead?
I did.
Why did you believe that?
Well, I was under the understanding that this just happened. She just arrived back on scene, and I did not advise her of what happened in the house.
When you spoke with Alex Cox, did he provide additional information that made you believe that she was not present when the shooting happened?
Yes.
After you advised the detectives of this, did you then return and remain with Alex Cox and for a significant additional period of time?
Yes.
Were you eventually asked to transport him to the police station?
I was.
Can you describe his demeanor during the transport?
Calm. Didn't ask. We just talked about things not related to this at all. Just a conversation between like me and you, just normal, average tone, calm.
And did you stay with him at the police station until a detective arrived?
Yes,
Did that end your involvement in this case?
it did.
I have no further questions.
All right, cross-examination.
Can you pronounce your last name for me? I don't want to get it wrong.
Krautheim.
Krautheim.
Yes.
Yes? Okay, Officer Krautheim.
At the
correct?
time, yes.
At the time. Okay. Thank you. Thank you. Appreciate it. You mentioned about Alex being calm when he exited the house. Is that correct?
Yes.
And then he's also, you were advised that he had told the 911 operator that he composed himself and then called 911. Is that correct?
I don't remember the compose himself, but I think he did.
But you stated in your report that Alex was very calm throughout the entire time talking with him, correct?
Yes.
Okay. And the scene itself, was it chaotic?
No.
Were people running around screaming?
No.
Were people running in and out of the front door?
No.
So were the officers calm?
It was just me and another officer.
Were you calm?
Yes,
Was the other officer calm?
he was.
Were the detectives calm?
They were.
Was the fire department calm?
I didn't interact with them very much. I couldn't answer that.
Your friend the Wiz was calm?
Yes, the other officer, yes.
So when I arrived at the scene, things were pretty calm.
Is that a question?
Yes.
Oh, yes, you were calm.
No, I'm saying when I arrived at the scene itself was calm environment.
It was.
Okay. So if I would have been hysterical, that would have been more out of character than if I was calm when everybody else was being calm. Isn't that
Objection,
correct?
Speculation.
Sustained.
So you said that Alex was calm and was holding a towel in his right hand and holding it up to the back of his head. Is that correct?
He did.
And you said, oh, sorry, it's in my other note. Just now that his head had a 1-inch laceration. Is that correct?
Yes,
That's like a cut down his head. 1
it
inch?
is.
Okay. And you said a small knot.
I did.
Is that correct? Okay. And so, and that it was bleeding a little. Is that correct?
Yes,
Okay. And so a small knot is what you declared it, but would you not call it a goose egg?
tomato, tomato.
Okay. Did Alex ask for medical treatment?
He did not.
How many times did you ask him if he needed medical treatment?
I think 3 times.
Okay. And there was EMS right there next to you?
Yes.
So an EMS person could have just come over and checked the back of his head pretty easily, yeah?
Yes.
Yes. But no one asked anybody to do that? Correct? Okay. And he didn't seem disoriented to you at all?
No.
So you didn't think he needed any kind of medical attention at the time?
No.
And he didn't ask for any at the time?
Correct. He did not.
And you didn't supply any at the time?
Correct.
Okay. But EMT was right there next to you?
Yes.
Okay. That's another thing that you said, calm and nonchalant. Is that correct? You
Yes.
stated that Alex was nonchalant. What is your definition of nonchalant?
Kind of like how I am now. I don't have a lot of emotion. I'm not afraid. Just nonchalant.
Is that your typical demeanor?
I guess it depends on the situation and the circumstance.
I mean, this can be a stressful situation, right? So it's your demeanor right now.
It is.
Testifying in court can be a stressful situation.
I guess it can be.
So if that was Alex's normal demeanor, then it wouldn't be out of the ordinary for him to be nonchalant.
Objection, speculation.
I'll allow it. I'll allow the answer. He doesn't know the demeanor, but you can answer.
Can you ask the question again?
Yeah, so if Alex's normal demeanor was like your normal demeanor, and even in a stressful situation, if he was nonchalant, it wouldn't be out of the ordinary for him to be nonchalant again, because that's his normal demeanor. Correct?
Objection to compound question.
I'll sustain that objection.
You mentioned that I had parked across the street. Is that correct?
Yes.
Why did I have to park across the street?
I don't know.
So we saw on the body cam, right, that there was a huge fire truck, correct?
Yes.
There was police cars, correct?
Yes.
There was a CSI van, correct?
She was parked somewhere. I don't know where.
Next to the house, kind of, I guess, south of the house. So there was nowhere to park except for across the street. Is that correct?
No,
That's not correct?
that is not correct.
Where else could I have parked?
Well, the street's long. You could have parked anywhere along the street. You could have parked on the other street. That's where I parked. Or you could park on the other side of the street, south of the home, where there was plenty of parking. So there was other options to park.
But I parked as close as I could to the scene so that I could come talk to you. Is that correct?
Speculation, testifying.
Sustain.
So we can agree that there were lots of police vehicles blocking the house. Is that correct?
Emergency vehicles.
Correct.
Yes.
Yes, emergency, police, fire, CSI, all were there, correct?
Yes.
Okay. But even though all of those things were there, the scene was not chaotic. Is that correct?
Correct.
It was a very calm scene that day.
Objection asked and answered.
Sustained.
Do you know how hot it was that day?
No, but it was hot.
It was hot. Oh, that's what I was going to ask you. What was the extent of your duties that day? I know that you had arrived on the scene. You said dispatched was about 8:39 a.m. Is that correct?
Yes.
And then it took you about 4 to 5 minutes to arrive.
Yes.
And then you were the first on the scene.
No.
No. Who was the first on the scene? Do you know?
Wiz was.
Oh, that's correct. And then who arrived? How long after he arrived did you arrive? Do you know?
Oh, I was like seconds.
Okay.
Maybe 10, 15 seconds.
And then you were right there when Alex came out of the house,
I was.
and you were with him basically that whole time till he
Yes.
got into the police car?
Yes,
And then did you drive him to the station?
I did.
So you were in the car with him the whole time?
Yes,
So you really never didn't have eyes on Alex from the time he came out of the house till the time he got to the police station?
correct.
Okay. And did you have a conversation on the way to the police station?
I did.
You did. And that's the second body cam we didn't watch, is that correct? That has your name on it?
Yeah, there's another body worn camera we haven't seen.
Right, from the police car, I'm saying.
Yes, me driving.
You driving, but it comes from the car, not from the shoulder body cam, is that correct?
No, it comes from my body
Oh, it was
worn
still
camera.
on your shoulder?
Yes,
Okay. And in that, did you have a conversation with Alex on the way to the police station?
yes.
Objection asked and answered.
And did he express?
Hold on. When
Sorry.
there's an objection.
I'm sorry.
Wait for the ruling. I'll sustain the objection, but the answer will stand nonetheless. Go ahead. Next question.
Did he express to you that he kind of fell out of it because he hit?
Hearsay?
Sustain.
When did you make your report about the incident on July 11th, 2019?
I think it was the end of my workday that day, but I stopped and started it numerous times throughout the day.
So did you finish it that day or it still took a few days?
No, I finished at the end of my shift,
By the end of your shift, which was what time that day?
4 o'clock.
Okay. And did you make any revisions to that later on?
No,
So this is the only report that you made in regards to the day of July 11th, 2019?
it is.
You stated that there was red liquid on the rag towel that appeared to be blood. Did you think it was something other than blood?
Well, I had no way to test it, so I have to articulate it that way.
So he was bleeding from the back of the head
He was.
on the right-hand side.
Yes,
Is that correct? Okay. And then was it you on the body cam who briefed the detectives, Detective Moffett and Detective Inklin, in the front yard?
yes, I made contact with him, yes.
And then you had told them basically what Alex had conveyed to you, what happened?
Yes.
And then what do they do with that information? Do they just put it into a report?
I don't know, you'll have to ask them.
Okay. So your report goes to who after you're finished with it?
I sent it to my supervisor.
And who was that at the time? Do you remember?
That was Bill Nacella.
Oh, the same one?
Sergeant,
Okay.
yes.
Okay. And then did you speak to the case agent on this case regarding this incident on July 11th?
I did at the time. That's when I walked up to them at the front door area.
Okay. And was Detective Moffett the case agent at that time?
Yes.
Okay. And now it's Detective Duncan, as far as you know?
As far as I know, I don't know for sure, but that's what I've been told.
Okay. And how long do you think that you were at the residence? What was the whole time before you guys left to go to the police station? Do you remember? Do you recall?
No, I do not. It would be in my CAD history on when I transported him from the home to the PD, so I'd have to look at that, and I don't know, 40 minutes, half hour, 40 minutes, something like that.
Now, someone on the video, and I don't remember who it was, but put a phone into a evidence bag. Was that you?
I don't recollect that.
Okay. And then got into the car. Did someone ride with you to the police station?
from the residence? Just you and Alex were in the car?
Yes,
No other officers?
correct.
But before you got into the car, an officer came over and took his phone and put it in an evidence bag?
You're asking me from recollection. I don't remember that. It's probable because we usually try to bring their property to the area where we're going to. So it's probable.
I just didn't see it in your report, but I saw it on the body cam, so I wondered if you knew. Okay.
I'm going to object to the defendant testifying.
All right. Please only ask questions.
Sure.
When you make statements about what you saw or heard, that's testimony.
I apologize, Your Honor.
Go ahead.
So it says in your report that you were asked by Detective Moffett to transport Alex to the police station not handcuffed. Is that correct?
Yes,
And to the downstairs interview room. I'm assuming that's at Chandler Police Department,
it is.
correct? Okay. And it was just the two of you in the car on the ride there?
Yes.
Okay, thank you. Then, when you arrived at the police station, what happened next?
Walked him up to the room, had him sit down, or I think brought him some water, I think. And the detective was literally behind me. It wasn't very long before he walked into the room.
So then Detective Moffett took over and you were excused?
Yes,
Okay. And then was that the extent of your duty
it was.
at that time? And did you leave the police station after that?
Yes.
Did you stay and observe the interview?
No.
So Detective Moffett took over for you and you departed?
Yes.
Okay. Thank you. You said when you spoke to Alex that he was cooperative. Is that correct?
Yes.
Is it possible he could have been in shock?
Objection, speculation.
Sustain.
From your observation, how long did the cut on Alex's head bleed? I mean, you were with him for that 40 minutes, and how long do you think it was bleeding?
Well, I couldn't answer that because I wasn't standing in the back of his head when I first made contact with him. So to be honest with you, I don't know when it started. So I don't have the minutes.
Did it appear to be bleeding when he exited the house, or no?
I didn't look at the back of his head right away when he exited the house.
When was the first time that you looked at it? About how long after he exited?
I can't answer time-wise, but it was during the time I had him seated at the sidewalk when I was talking to him.
Okay. Before he moved over or after?
Oh, after he moved over.
Okay. Did you ever enter into the house?
No.
You were just there in the front yard
Yes.
the whole time? Okay. When you talked to the two detectives in the front yard and gave them your synopsis of what had happened, you said they got into a domestic fight consisted.
Objection.
I'm sorry.
I'm going to sustain the objection.
What was the legal objection?
Hearsay.
Hearsay.
Oh,
I was just reading his report. Okay.
Then objection, no question.
Please ask your next question.
You said in your report that at one point Alex's niece grabbed the bat.
Objection.
Hold on.
Hearsay.
That's
Improper
hearsay.
question.
Okay, you can't ask hearsay. Please ask your next question.
Did Alex tell you that he got hit in the head with the bat?
Objection, Your Honor. Hearsay prior ruling.
Yeah, it's sustained. You can't ask questions of what Alex said.
So you observed that he had this bump on his head, but you didn't know how he got it. Is that correct?
No, that's not correct.
You did know how he got it. Is that correct?
I was told how he got it, which is different than me knowing how he got it, if that makes any sense.
Correct. You did not witness it, is what you're saying.
Correct.
But you knew that he had an injury to the back of his head on the right side.
I did.
Correct. Okay. And how did you obtain that information?
Your Honor.
You can't answer if it calls for hearsay.
Did you observe the next door neighbor come out in her nightgown to speak to me?
I did.
And then there was another neighbor on the other side that came out that you told him to go back into his house? Is that
Well, he was
correct?
a neighbor, but it was just some guy. Yeah, I assumed he was a neighbor.
Right. So they had blocked off the street so the neighbors couldn't really exit the neighborhood. They couldn't go to school or work, or it's kind of an issue there.
Not really. I mean, when one car told us the layout of the neighborhood, then we realized that was the only person that wanted to exit. They told us they couldn't exit, so we just fixed it so anyone else could leave.
Right. But they were trying to come up to me to find out what was happening.
Objection,
Okay.
speculation, hearsay.
I'll sustain the objection. Let's take our afternoon break for the staff and the jurors. We're going to take a 15-minute stretch restroom break. Please remember the admonition.
All rise for the jury.
Juror 15. Juror 15. Is that your phone on the?
All right, sorry, I have to kind of speak low because Bot is asleep and it's literally 5 minutes to midnight. But did you guys just hear that? It was like Juror 15 had a phone? What the actual is happening? That is just absolutely crazy. You can't have your phone, can you? Like, hang on, can you have your phone with you when you are on? Oh, wow, my days, that is not good. Yeah, I don't think they can have phones like, um, that's, oh, my days. Is this your cracking point? Um, yeah, but still, yeah, 15 minutes, which is not too bad. So that'll be about, I don't know, 10 past the hour, something like that. Um, So it's not gonna be that bad. It's or that long the break. Um, yeah. Oh wow, that is not good. Oh come on, man. Jurors, like 5 after. Okay, thank you, Rebel. My brain needs to sleep. So, um. Oh, Sizzy, I hope you feel better soon, man. I'm so sorry, my friend. Definitely, that is not great. I mean, I'm not gonna lie. You know that nap that I just took? That was actually a quite good nap. Oh, mm, it was very, very good. Actually, she did put me to sleep. Um, so Denise, we had a juror just before we went to break. Judge was like, "Juror 15, is that your phone in your seat?" So yeah, so a juror apparently had a phone with them, and I don't think they are. Yeah, so they have their phone on them, and now we are on break right now. Stephanie, I really hope that yes, 15-minute break. Stephanie, I really hope that your family is all right, and that the car somehow it is fixable. I really, really hope so. I know, big whoops. If I was at me as an attorney, but obviously because Lori is her own attorney, she probably doesn't know. I would have moved to dismiss that juror. Like, bye. See you next life. So, but, um, Journeys, it's late, man. It is late. It's literally 4 minutes to midnight here. Here. So I have to go to work in 2 hours. And a half. I start work, which is crazy. I keep taking little naps in the background. I do apologize, everybody, but it's just helps me out. Um, Yeah, exactly. Yeah, everything is replaceable, but them. I absolutely agree. Um, well, they were. Where's my notebook? Hang on. So, jurors 12, right? There's 13 men and 3 women, so there was 16 altogether. So 12, 13, 14, 15, 16. There were 4, so now there is only 3. There's only 3 as alternates now because one was already dismissed earlier today. So there was literally 3 um, at the moment. So yeah. That's all right. It happens. No worries. I am a bit tired, but I am hoping that when court finishes, right? Um, yeah, it's 3 minutes to midnight right now. Yes, Journey. I'm hoping when court finishes, I can go. I have my alarm on. I'm gonna go to the sofa in the living room, and I'm gonna shut my eyes for like an hour, which hopefully that will be good. And then I will wake up, make my coffee, have a cup of coffee, and then go to work. So I'm gonna be doing that 3 days a week. Yes, journeys. So I'm gonna be doing that on Monday nights, which is right now Monday to Tuesday, and then Tuesday to Wednesday. I'm gonna be 2 nights a week. Sorry, I'm gonna be doing this 2 nights a week. To cover this trial. Yes. So yeah, so I start work. I have 2 o'clock in the morning my time. Finish a quarter to 9. Come home, sleep for a couple of hours until the end of this week. We're gonna be doing the Linda Stomach trial plus Lori, and but Linda's gonna finish this week anyway. So from next week, I'm just gonna do this one and try to rest as much as possible. But we should be okay. I'm also off next Monday as well because it's my birthday. I'm off that Monday. Gonna treat myself with a day off. So next Monday I'm gonna be off, so that's gonna be all right. Oh, it's okay. I'm gonna have like music on. I have music on at work. I'm gonna have plenty of coffee with me. Um I'm standing, so it's not like I'm gonna sit down and be on a computer or doing anything. So I'm gonna be moving. I'm gonna obviously splash some water on my face if I need to. Yeah. So not normally I start work at 5 a.m. my time, which if court finishes at 10 p.m., I have plenty of time. But because of this trial, I'm starting at half 2 o'clock in the morning. So yeah. So yeah. Oh no, I'll be fine because he has alarms and the alarms are quite loud. And normally I have my watch as an alarm as well that I put with when I turn on the oven, so it vibrates on me. So if by any reasons I fall asleep, it still wakes me up. So, like I can sleep, I can take a nap on my break. Like I can take a half an hour break. That's my entitlement break, and I can take a good nap during that time with no problem whatsoever. But my plan is as soon as I get home, I'm gonna go to bed and I'm gonna go sleep. So yeah, and that's gonna be what I'm gonna be doing until we start Linda's Therma trial. Um, yes, yeah, exactly. And then the thing is, Wednesday nights and Thursday nights, I don't work. I don't work Wednesdays. I'm not gonna be working Wednesday to Thursday or Thursday to Friday. I'm not gonna be. Ugh, I'm confused. England, yes. So today's Monday to Tuesday, Tuesday to Wednesday, that's my last night. So I don't work Wednesday to Thursday, Thursday to Friday. So I don't work that. I only work Monday, Tuesday, Wednesday. That's 3 days that I do at my current job because I'm very fortunate that to be able to that YouTube is starting to pay me a little bit more. You guys are so generous and help so much that it's gonna be fine. Um, sadly, yes, I am sure I have to work, Mel. Yeah, I would love nothing more than staying at home, yes, but it is what it is. I'll be fine. There's plenty of coffee. I've got energy drinks if I need as a last resort, but I'll be fine. I'm just mentalizing. I'm just mentalizing myself. It's only one more night after tonight, so it's not that bad, and I'll be okay. I promise, guys. Yeah. Yeah, at least this time trial starts late. This week is gonna be the hardest week because we still have the Lindestomber case going, and we have this one now. So until Lindestomber is finished, it's gonna be a little bit hard. But it's already Tuesday. So well, technically it's already Tuesday for me, but but they're gonna go back tomorrow, Tuesday, for Linda's Therma, and then we're gonna be catching up Linda for the rest of the week, and then we're gonna finish Linda fight by Friday. I mean, they said they're gonna go in deliberations either Thursday or Friday, so we'll be absolutely fine. So, um, well, yeah, because Rubber you streams at midnight Central, so and I'm always there. I'm definitely gonna be a wacky doodle. Absolutely. Without my lack of sleep, definitely. I know, I'm trying to be quiet, but to be fair, when he's asleep, I don't think nothing much can think. He was saying earlier that it was not, um, it was like, it was hard for him to fall asleep and all. So hopefully I'm not being too loud for him. I hope not, because he does need his rest, because he's working, has a full day on tomorrow. So yeah, and the thing is, like on Wednesday, you guys are gonna be with Zio and Rubber for the first couple of hours. They actually are gonna be the ones starting the stream. They don't know this yet, but they will. Because again, I have my commitment on Wednesday, and court starts at the time that I have to go. So they're gonna be starting the stream, which I need to talk to Robert and Zio about it. But yeah, and then I'll come in at um about about lunch break. I'll come in. I'll just lose the morning, and then about lunch break, I'll come in and just join you guys in the fun of the stream. So we'll talk in the back. Yes, Robert. We don't speak English at the moment, so yeah, that's the plan. We're gonna be okay. And then on, like, the thing is, on Thursday morning I can slip in, and I am gonna be turning off phones. Garden Bot is gonna have a piece of tape in his mouth so he doesn't talk to me in the morning, and yeah. And yeah, so it's not gonna be too bad. I'll be fine. We can do this, guys. Sometimes in life you have to do the hardest things, and so yeah. We just have to endure a little bit. Oh, are they back already? Hang on, hang on. No. Sorry, the camera's moving, so I don't know where the camera's going. Like, it's just panoraming around the corner or something. Yeah, I think the cameraman is having oh, that's Latin on the seal. Didat Deus, it's like God in Portuguese. The second word in the middle of the thingamajigga. The seal, sorry. Words. The thingamajigga. The second word in the I don't know if you can you see my mouse on stream? No, you can't. Means God. So, oh, are they at the bench? There's no sound. They're already back. Wow, that was a quick break. Have I actually been talking for 15 minutes? No, I don't think I have I? It's been barely 10 minutes. Wow. Ah, my days. Like, y'all, even at this time of the night and with, like, saying absolutely nothing coherent or anything that has a minimum interest for you guys and for people, I can literally talk about nothingness and making it to a break time. I mean, I'm sorry, but this must be a very good skill. This must be like one of those skills that it's impressive that someone can talk for 15 minutes about nothing and make time go fast. Sorry, I am still yawning. I think I'm a perpetual yawning person when I'm talking on stream because I'm here behind, chatting and chat, blah blah blah. And no, don't yawn once I start talking to you guys. When the court is on break and whatnot, and I start yawning. Oh, it's been 10 minutes, so we can still have the 5 minutes. I think in the first day of a trial, and I find that quite interesting, that you can find how an attorney, a judge is gonna be, if it's gonna be like on time judge, or is it gonna be like a laid back judge. Oh, sound is coming in. Hang on. Like, you can see, and I think this one is gonna be like a very on time judge. Is not gonna like be late or anything, which is good. I like it. I really enjoy that about in a judge. I'm not gonna lie. Hang on, my headphone fell. Hey, good morning, good evening, good morning, good evening, Brita. How are you? How are you, my friend? Hello, welcome in. Good to see you, my friend. We are just on break right now, and we're just waiting for to start again. Sorry, apologies. So yeah, sorry. I don't know why I decided now would be a good time for me to put my feet up. I don't know why I could literally waited 5 minutes and done it in 5 minutes and not and wait for the court to resume. So yeah, so we're just waiting on court to start back up again, and yeah, because they are on a 15-minute break, which runs out in a couple minutes, and then we can just enjoy the rest of the court. We're gonna be the last part of the day one. Lori has, well, not been that bad of a job, I don't think. Oh, judge is ready, y'all. Literally. Oh, really? Oh, wow. That's nice. Thank you very much, Lois. See, I didn't knew that Deus is God because that's like the same word in Portuguese. Deus, that's how we say God in Portuguese. But yeah, that's quite interesting. Thank you very much for that piece of information that is very useful sometimes. So we just literally waiting. Apologies for my no camera at the moment, but it's just like I'm literally. Am I cutting in and out? Well, at least I'm gonna be quiet for the rest of the stream. If I am, my apologies. Am I cutting in and out? Oh, oh, okay. Or maybe try to refresh the feed, my friend. Maybe so. Yeah. Oh, Jerry's coming in. They are, getting up. So, I was just saying apologies for no camera, but it is past midnight here. I'm extremely tired, and I have to go to work in about 2 hours. So I'm just having a bit of a rest before I do. But I'm still interacting with everyone. And with you all in chat and everything, which is fine. But just don't forget to leave your like. It does help the channel quite a lot, please. And thank you. And I think we are supposed to resume shortly. We don't know if Jury 15 got in trouble or not, or you were just got told that they left their phones. And here we go. Let's get crack on.
Just a couple more things. You mentioned that you briefed the detectives. Is that correct?
Yes.
And what did you tell them in that briefing?
Objection, hearsay.
Sustained.
Are his statements hearsay as well, Your Honor?
Any out of court statement is hearsay unless there's an exception or it's non-hearsay under the rules. So yes, his out of court statements are hearsay. Go ahead.
But you did brief the detectives before you headed to the police station? Is that correct?
I did.
And who was there? Do you remember?
Nate Moffat, Cassie, I think my
Is that
sergeant.
Detective Inklin? I'm sorry. I don't want to interrupt you.
No.
Oh,
And just off recollection, I think there was another one, but off of recollection, I don't remember.
and that was about how long before you left to go to the police station?
$10 minutes, maybe?
And how long do you think you were speaking with them?
Under a minute.
Under a minute
Yes.
for the briefing?
Yes.
Did you meet with the prosecutor to go over your testimony today?
I did.
When was that?
2 weeks ago, maybe?
How long did that meeting last?
Probably around an hour total.
Did you review this report before you came to testify today as well?
I did.
It was not part of your duty to check anything in the perimeter? You weren't looking for evidence, you were just dealing with the shooter? Is that correct?
Well, not just the shooter, but scene management, making sure the resources were en route. But yes, managed.
What all does that entail, scene management?
Well, once we knew there was not a threat out, I instructed Officer Wiz to set up an inner and outer perimeter with crime scene tape.
What else?
Make sure I had a supervisor en route, and then manage the people that walked up to the scene.
Who was that supervisor en route? Do you know?
Bill Nacella, my sergeant.
How many people do you think came up to you at that scene?
Well, not up to me, but I instructed one gentleman that was walking on the sidewalk towards us. He needed to just leave the area. This didn't concern him. And then you and your daughter walked up to me, and I just asked you to go back to your car.
Did you have any conversations with your supervisor when he arrived?
I did.
When was that?
At some point between me arriving on scene and me leaving the scene.
Closer to arriving or closer to leaving? Maybe.
Chocolate milkshake says about halftime.
Okay. How long do you think that conversation was?
Well, you saw it on the body-worn camera, so a minute and a half maybe.
And he was just checking in with you to make sure everything was going well, that you were scene managing. Is that correct?
Objection, relevance. And hearsay.
Overruled, he can answer.
I was briefing him on what I knew thus far, what I was told.
And that was less than a minute?
Yeah.
Objection, asked and answered.
Sustained.
So it took less than a minute to brief him on everything that had happened that day so far?
Objection, asked and answered.
Sustained.
And it took less than a minute to brief the detectives as well of what happened that day?
An objection, asked and answered.
I'll allow that one. Go ahead.
Not what happened, what my portion was and what I knew happened.
So what you wrote in your report, basically, what you were told. Is that correct?
Yes.
So it took you 3 pages to write what you were told, but it took you less than a minute to discuss that with the detectives? Is that correct?
Yes.
Okay. How long was that transport from the residence to the Chandler Police Department?
In miles, probably 8 miles, 10 miles maybe.
How long do you think that took around?
10 to 15 minutes maybe.
And then where did you enter into the police station? Is there a garage or something?
I don't recollect where I parked. There's various areas you can park at the police department to access the area that I access, so I'm unable to answer. I don't know where I parked.
Okay, and you were able to walk Alex into the police station, is that correct?
Yes,
And he was unhandcuffed, is that correct?
correct.
And then you took him into an interrogation room, is that correct?
Yes.
And then Detective Moffett took over.
Yes.
Just wanted to be clear. Okay. Did your supervisor, Nacella, did he come to the police station as well?
Not with me, nor did I talk to him. He might have, but I don't know.
You didn't see him there?
Correct.
Okay. But you saw Detective Moffett there?
Yes.
And you saw Detective Inkland there?
I don't remember Inkland. I just remember Moffett relieved me.
Okay. That's all I have, Your Honor.
All right, redirect.
Thank you. At the beginning of cross-examination, you were asked about Alex Cox's demeanor. Do you recall that?
I do.
And you had advised that he was nonchalant and calm, right?
Yes.
And you were asked whether or not you were nonchalant and calm too, correct?
Yes.
Had you just shot someone?
No.
You were asked if the firefighters were calm and nonchalant. Had they just shot someone?
As far as I know, no.
How about Officer Wiz? You said he was nonchalant and calm too. Had he just shot anyone?
No.
So it's not really exactly the same to compare you to the shooter, right?
Correct. I would not compare us.
When you went up to the scene, you had your gun drawn on him, correct?
Yes.
Still nonchalant and calm?
Yes.
You were asked a lot also about your nonchalant and calm appearance today in court. Are you stressed or just answering questions to the best of your knowledge?
The latter, just answering questions to the best of my knowledge.
You had to testify before?
I have.
You were asked about the injury to Alex Cox. We have seen the body-worn camera footage and we cut it off at some point. When Mr. Cox first came out of the house, he did not have his hand to his head, correct?
Correct.
You told us you didn't notice an injury at that point?
Correct.
When he first sat down on the curb before you moved him, did you notice an injury at that point?
I did not.
Was he touching his head at that point?
Recollection, I don't remember.
At some point in the video that we watched, did we see Alex Cox touch his head?
Yes.
When you were watching him, did you at times see him rubbing his head?
Yes.
The towel or paper towel or whatever that was in his hand, was that the only item you ever saw him using to rub or touch his head?
Yes.
Was it soaked or saturated in blood?
No.
Can we see it on the body cam that it's mostly white?
Yes.
So if we want to really know how long it was that he was seated before he touched his head, we could watch the time on the body cam, right?
Yes.
You were asked if you met with the prosecutor previously. When we met, did you have to watch that entire body cam?
Yes.
And is that when you actually initialed it, exhibit number 1 there, so that you would recognize it in court?
Yes.
You were asked about when you arrived and when you later transported Alex Cox to the precinct. Would looking at the CAD report help refresh your recollection as to when you had at least taken him to the precinct?
Yes.
If I could have my paralegal bring up the CAD report.
Go ahead.
Does that help refresh your recollection as to when you arrived back at the precinct with Alex Cox?
It does.
And when was that?
9:18 and 19 seconds.
And so the 911 call was at 8:36 a.m.?
That's when I received it. It could have come into the dispatch a few minutes earlier.
And you said you arrived, and we saw you on the body cam right after Officer Where's Biggie, who got there around 8:41?
Yes.
So you were with Alex Cox at the scene and talking to Lori Vallow and her daughter and doing those briefings in that 20, 30 minutes?
Yes.
No other questions, Your Honor.
All right, I see at least one juror question in a bin. If there are any juror questions, please pass them down at this time.
We get the beeping machine now. Yeah. So now the sound that we are listening is just the machine that I'm hooked up to. Yeah, that beep is gonna get annoying. Hang on. There we go. You guys don't hear that anymore. Yeah, now she can't get up. You cannot go to the sidebars up front because she cannot get in front of the judge. So I've muted the thing for you guys. I can still hear them, but I have muted for you guys so you don't hear the, life support machine. Sorry, it sounds like a support machine. I am so sorry. That sounds horrible. My apologies. Yeah, the juries have some questions, um, yeah, she has headphones because it's the way they're doing sidebars is through the headphones. Make sure everyone hears. So yes, I pushed two chairs together, and that's how I'm kind of laid down in front of the computer, and that's yeah. It's actually quite comfortable. Believe me, it is quite comfortable. But court should be finished any moment now, anyway. So it's gonna be okay. Yeah, sidebar because they are on jury questions at the moment, so just you know um make sure if anyone has objections to the sidebars and to the jury's questions or anything, so they're just discussing that. Oh, it's okay, I'm all right. I'm actually quite comfortable. It's actually quite nice. Oh, hang on.
Just one question, and I don't know if the CAD will help you answer that. Do you know when you were finished with this call? What time it was when you were finished or released from this call and able to go back out?
It was probably 5 minutes after, maybe 10, probably 10 minutes. I probably used the restroom, to be honest with you, and got something to drink at the station, water. So maybe 10 or 15 minutes after the detective came in the room is when I hit the 10-8 button and I went and took other calls for service.
Okay, so you were done with this call before the end of your shift?
Oh, yes.
Okay, you didn't go back to the scene to help with scene security or anything like that?
No.
No other questions?
Did the defendant have any follow-up?
No, we're fine, Your Honor.
All right, this witness can step down. You want to hand me that? Thank you. All right. You can call your next witness. the podium here and be sworn in by my clerk.
Can you spell your name for the record?
Scott, S-C-O-T-T,
Please raise your right hand. Solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes. Thank you.
All right, you're gonna come up this little ramp, have a seat right here.
Sir, would you please introduce yourself to the jury?
My name is Scott Cowden,
And where do you work?
Chandler Fire Department.
How long have you worked there?
Almost 26 years.
And talk to you a little bit about what firefighters do. Do you just respond to fires, or are you also responsible for something else?
No, the majority of our job is going to be EMS medical calls.
What kind of training do you have to work as a firefighter and deal with medical calls?
When you're hired, you're going to go through an academy that will certify you as a state firefighter. Typically, you're going to already be certified as an EMT. And then during the course of your career, I went to paramedic school and graduated from that in probably 2007.
Can you tell us what the difference is between a paramedic and an EMT?
EMT would just be kind of the more basic kind of entry level position. Paramedic is more advanced, so you have more advanced training. There's more advanced skills that you could perform. Some of our equipment would only be able to be used and utilized and performed by a paramedic.
As both a EMT or a paramedic, are you trained to perform CPR?
Yes.
And can you tell us, have you ever been a CPR instructor yourself?
Yes, I was a CPR instructor for probably over 12 years.
Was that for other firefighters?
I was certified through American Heart Association, a contract employee with Dignity Health. They have a variety of different classes that could be for just the lay rescuer, lay person that wants to know how to do CPR. They have classes that might be for certain businesses that want their employees. And then there's healthcare provider classes that it could be firefighters, nurses that are attending to be recertified. Every 2 years, you have to have that certification recertified.
Can you tell us what CPR is?
It stands for cardiopulmonary resuscitation. So you're kind of acting as the heart. The heart has stopped beating, so no blood is flowing through the body. You're doing chest compressions on the chest, and you're pumping and pushing that blood to the body.
When would you give CPR to a person?
If they don't have a pulse, you confirm that just by checking for a pulse, and you don't feel that. The heart isn't beating, and you would need to start chest compressions.
What is the point of that, of doing those chest compressions? You said moving the blood through the body. Why?
You're trying to, give them a chance, increase their chance of survival. I don't know what maybe the latest numbers and statistics might say, but in the past I've seen it say that if somebody's starts CPR within the first few minutes, it can double or triple their chances of surviving.
When you are called to a scene, are you guys being given updates by the 911 operator to your dispatch so you know what to expect?
Yeah, so you get dispatched and you already have an idea of the type of call, and then en route we call it PTI, and that will come across the computer screen. And so now you have more information of what you're kind of walking into, so you can kind of game plan it a little bit more.
If somebody calls 911 and doesn't know how to do CPR, what happens?
My understanding is that 911 would talk them through that and give them instructions of what to do.
Okay. When you are giving CPR, you talked about chest compressions. Can you talk to us about, is there any physical identification that you might observe on a person who has had CPR chest compressions?
That I might see
after a person has been given chest compressions?
Yes. So you need to perform it in the right location. So it's the lower half of the sternum or breastbone. To kind of find that, it's more helpful if you can see the skin, maybe lift up the shirt. So that's typically something we're going to want to do. If CPR has been done and it's been done effectively enough, you can see almost like a depression or an impression that is left there on the skin, because you need to do it forceful enough and deep enough that you're actually compressing the heart to push the blood.
So you said you might see a depression. Does that not just pop right back out when you stop?
No, you'll still see it. You'll see it like if you stop CPR during the call for whatever reason that it might be appropriate, and then you go back to resuming CPR, you'll see where your hands were. That area can be vulnerable to breaking. Ribs can break during CPR, so there's typically depression in the chest.
Do you ever actually hear anything when you are giving someone chest compressions?
I for sure feel it. I don't know if it's audible enough to hear it, especially with maybe the rest of the commotion that's going on, but you definitely feel that crunch or that crack. I kind of compare it to like if you're cracking your knuckles in your hands or something, your fingers. It kind of feels like something like that, but more extreme, I guess.
And this is something that you have felt multiple times in doing CPR?
Yes, and teaching CPR, you want to forewarn people of that too, that to kind of expect that and not necessarily kind of be alarmed. You don't want them to think they've caused more harm necessarily.
Does that crack or crunch occur each time you restart CPR in the same patient?
No, it's typically just the first couple of times.
Have you previously performed CPR on a person who was shot?
I'm sure I probably have.
Sorry about this, guy. This is not me. Let me try to refresh the feed to see if it fixes. Hang on 1 second. I think they are experiencing some technical difficulties. So just bear with me a moment. Oh, come on. Let me have a look if there is another feed. 1 second. I'm sure that there is another feed, but
You're going to be around the corner, around the block, a street away, whatever kind of might make the most sense based on where we're coming from.
Okay. How many people are on a fire engine?
In the city of Chandler, we typically have at least 4 on any of our fire engines and fire ladders.
And what was your role?
So you'll have a captain who's up front. That's the person that's in charge. I'm a fire engineer specifically, so I drive the fire apparatus. And then we'll have 2 firefighters in the back seat.
Do you recall in this case about how far away you were staged?
I mean, from a time standpoint, we might have been 30 seconds away.
Who were the other people on your team that day?
By names?
If you recall.
Okay, Captain Keller, firefighters Kaczynski, and firefighter Fife.
When you arrive at a scene like this, you told us that there's a captain, you're the driver. Does everyone sort of have a job, or how does that work when you first get there?
You typically may kind of talk about roles and what might happen. Also, like in this particular case, this was our first call of the day. So all of our calls, we're going to do some documentation and chart it. And so we typically start with the captain will start the first call of the day. So that meant Captain Keller was going to be charting it. So that would leave the other 3 of us to do the evaluation, assessment, and patient contact and skills.
So when you drove up to the scene, what did you see?
I remember us having to make a turn, and a couple of officers I feel like were already there, kind of navigate their cars, position, right in front of the house. Saw at least one officer outside, saw a citizen, I feel like probably in the driveway somewhere with that officer. And then we just kind of proceeded out of the apparatus.
When you guys entered the house, you said that Captain Keller was going to be charting. So does that mean he wouldn't be touching the patient?
More than likely not, unless we needed additional help. I mean, he possibly could have been the first one in. Also, the way we were parked, that passenger side of the fire apparatus was the closest to the front door. He might have been in first, because I'm going to be on the other side. The two firefighters are getting out and going to the back compartment of the truck to get the equipment. So he may have walked up and possibly checked a pulse or something like that first, but he didn't. I don't feel like he did anything else other than that, if that.
Okay. You told us that as you're going there, you're receiving information about the patient, correct?
Correct.
In this case, had you received any information about whether or not he was receiving CPR?
Yes, I recall we had that info two ways. We had it with the PTI on our computer screen, which would be coming from our fire department dispatch. And then we have the ability to also listen on the radio to the PD channels. And so we can hear communication between the officers that are getting on scene and then the PD dispatch. And they also communicated that at some point in time.
When you entered the house, was there an officer already inside?
I believe there was an officer inside with Captain Keller.
And did you observe anyone giving the patient CPR?
No.
Can you tell us what you saw when you first entered the house?
You walked in the front door, just kind of a little entryway, and it kind of, I feel like it stepped down into maybe a formal kind of family room or something, but it was empty with no furniture anywhere in the room. That jumped out at first because it makes it easier. Like sometimes we're on scenes where the patient could be between a bed and a closet and you got to move them somewhere. So those thoughts are already kind of in your mind that you may have to move a patient just to have better access, and that was not a challenge here.
Did you notice any blood on the scene?
Not until I saw it on the patient's chest, but I didn't see it in the room. It wasn't something that I was going to need to avoid kneeling in to do CPR, avoid standing in, walking around. There's four of us. We probably had at least 4 boxes of equipment in there. So we didn't have to worry about where we placed this stuff in terms of blood.
Have you been to scenes where there's a large pool of blood around the patient that you're trying to not step in, kneel in, get in?
Yes.
You told us that you saw blood on the patient. Do you recall seeing any blood pooling in his chest, neck area?
I don't recall it pooling. He still had clothes on, a shirt on, and so it had been absorbing some blood.
I'm going to show you an admitted exhibit number 3. Do you recall ever seeing this pooling of blood around his neck there?
I don't recall that.
Okay. When you first saw the patient, what was your first impression?
That he's lying there unresponsive. You're not seeing any signs of life. You don't see somebody that's maybe moaning from an injury, moving, no spontaneous breathing. What was your question again?
Just your first impressions of him as you are walking in and you're looking at him and assessing him.
Yeah, I guess that would be sufficient for my answer.
Did you think that he could be deceased?
It's definitely was a possibility. There was no, like I said, no obvious signs of life.
When you got into the room, did someone begin performing CPR on him?
So when I got to Charles' side, I would have performed a more detailed assessment, so to speak, rather than what I was seeing visually. So you're checking for responsiveness. You can move the patient. You're going to check for a pulse. Now you're closer to the chest. You're looking for breathing, seeing if you see the chest rise and fall. And we would call him unresponsive and pulseless and apneic. Apneic meaning not breathing. And then I would have started CPR.
So he wasn't breathing, he had no pulse, he wasn't moving, there were no signs of life.
Correct.
You told us that you had received information that someone had been doing CPR prior to your arrival, correct?
Correct.
Did that impact your view of the patient and your decision-making on what you should do next when you see this patient that is lifeless?
I mean, it makes you think that there's increased likelihood that of survival possibly, until we can, starting CPR is still appropriate to do, and then we can utilize some of our rest of our equipment. We can put an EKG machine on. We can actually see what the heart is doing. We can look at the rhythm. We wouldn't want to call a patient before taking some additional steps.
Okay. Who performed CPR?
I did.
And I'll put up Exhibit 4 here. Do you recognize who these people are?
Yes.
And who are they?
So standing to the left is Captain Keller. He's documenting. Standing to the right is firefighter Kaczynski. And then kneeling down back towards us is myself. And then kneeling down where you're pointing is firefighter Fife.
When you first began performing CPR, can you tell us what you felt?
So at first I didn't see a depression that would typically be left from somebody else previously doing compressions. So I thought that was odd considering the information we had en route. I started doing compressions. I felt that initial crack and crunch for probably the first couple of compressions that, again, you would typically feel when you're first starting compressions and if you're going hard enough and deep enough.
How long did you do CPR before you evaluated and utilized any other means to see if he might still be alive, savable?
If I had to estimate, I think I was probably doing CPR, chest compressions for at least a minute. It probably took them at least 30 seconds to minutes to maybe get in to the house where I was after I entered. They've got to set down that equipment and get some of that out. So I feel like at least a minute is a fair assessment.
What happened next? Is there some way to check his heart to see if there's
Right.
activity, or what do you do?
Yes, so I was doing chest compressions. I remember mentioning, because there's bullet holes going through them, so I remember mentioning to firefighter Kaczynski when she went to cut the shirt to not cut through a bullet hole. So she kind of went along the side, that's exposing the chest, so that way then we can put our heart monitor and perform an EKG on Charles to kind of see what his rhythm is doing. A person can typically still do chest compressions while they're doing that, and they can kind of work around you. But at some point in time, you're going to have to stop. That way you can just look at what the machine is showing you and telling you.
Was there any heart activity when you put on those EKG?
No, it was what we would call asystole, and it's just a flat line on the screen. There's no electrical activity of the heart.
At some point, you said you saw gunshot wounds. Do you recall how many you saw in the front there?
I saw 2.
Do you ever look to see if there's exit wounds?
We did roll him. I seem to recall and remember that we rolled him my way. I feel like the other 2 firefighters were then on that other side. Firefighter Kaczynski, who's the one that's standing up, I feel like she had a better view of what those looked like since he was rolled my way. But I remember her commenting that there was 2 wounds on that backside of the patient.
So when you say he was rolled towards you, he's rolled towards this mirror over here?
Correct.
Okay. When you had stopped doing the CPR to roll him and he goes back, did you notice the depression in his chest now?
After I resumed CPR, yes. It makes it kind of easier to find your landmark. So it's something that you typically look for.
So it was not there when you first started CPR,
Correct.
but it was after you had performed it.
Correct.
Do you wear gloves when you do this?
Yes.
Did you have blood on your gloves after you were doing CPR?
Yes.
You told us that when you first arrived, there was not much concern for having to navigate around blood that might be pooling around the victim, correct?
Correct.
After you had been doing CPR, was there more blood now around the patient?
There was definitely more on his chest. More was coming out of the wounds, specifically the one on the chest from what I recall. The shirt isn't necessarily there to absorb it anymore. We've removed it. I can't recall necessarily on the ground, like where I might have been kneeling, but
When you first arrived, did you see any blood exiting the abdomen wound?
I did not.
As you were at this scene, you guys did the EKG. There was no heart activity. What do you do after that?
At some point in time, we just kind of have to look at patient viability, and we're just looking at the facts and how he's kind of presenting. And we're considering time that we've already been on scene, time, staging, responding, all of that. And we ultimately, we do have offlines that we follow for different types of medical calls. And we felt that he fell into that category of not being viable and that we could call him on scene.
Now, you talked about you were not staged very far away, correct?
Correct.
Were you staged very long before you pulled up?
I felt like we might have been there for at least a couple of minutes.
When the patient was rolled, did anyone notice anything about, or did you notice anything about his skin that made you also question perhaps how long it had been since he had been shot?
Yes, it was pointed out because I didn't have a good view of that backside, the skin color, some modeling. There's changes in the skin color that are starting to occur from there's changes in the skin color that are starting to occur from, blood hasn't been circulating There's changes in the skin color that are starting to occur from, blood hasn't been circulating, hasn't been maybe. Blood hasn't been circulating, hasn't been maybe.
Okay, I don't think it's my problem. I think it is the problem of the fates or whatever is happening, because I don't know what's happening, because it's yeah. Hang on. Let's try another one.
He's going to be bleeding internally.
There we go.
And so some of that pooling causes color changes to the skin
Yes.
that were observed.
Yes.
Was there anything about this victim, about Charles, that made you think that CPR may not have been performed on him prior to you arriving?
It was just simply the fact that what I saw on the chest when I first looked at it before I started CPR, and then what I felt during my first couple of chest compressions.
After you guys rolled him, saw the modeling and the lividity, was any further CPR performed?
From what I recall, yes.
Okay. When did you call this then?
Say that again?
When did you call it? When did you stop performing CPR?
So I don't remember with 100% certainty if I feel like, from what I recall, I'm performing chest compressions, the shirt's going to be cut off, we're exposing the patient, rolling, looking for more wounds and injuries, confirming what we see on the back, pointing that out to Captain Keller so he can document it, rolling back down, resuming CPR, monitors going on, stopping again to look at what the monitor's saying, resuming again to then have a brief discussion based on, okay, what we found, what are we thinking, where does he kind of fall?
Ultimately, did you guys terminate any treatment at about 8:48 a.m.?
If that's what's on the documentation, I would agree with that. I know we responded in the morning. It was our shift starts at 8 a.m. This was our first call. I don't remember if you said earlier what time we were dispatched or not, or just established the date.
If my paralegal could approach with the charting, would looking at the charting help you refresh your recollection as to when you guys ended any life-saving means?
So it looks like our dispatch is 8:37. Looks like we might have made patient contact at 8:45. I know the dispatch screen that will have like times of responding and things like that might have an appropriate time on it also that I'm not seeing right here though, but I'm still looking. So I see our first monitored rhythm as the asystole, like I said, that date time, I see a time of 8:48. So that might have been when we called him. I can see the obvious signs of death that Captain Keller used as the reason for discontinuing ROSC, return of spontaneous circulation, no. So that would probably be the appropriate time.
After, well, let me say, so would it Does it seem about right that you were with this patient for maybe 3 or so minutes? Actively working?
Actively working, I think probably close to 5 minutes.
And once he's called, what do you do at the scene? What do you do with all your equipment?
So once he's called, it's kind of a PD scene now. So we're gonna leave the body. We're gonna gather up what we can, our equipment. Sometimes there's some stuff we might need to leave behind that's necessary to leave on the patient. But
So like the EKG monitors that are stuck on him, you leave those on him?
yeah, we can disconnect those exactly and bring the cables with us.
When you told us when you arrived that you noticed a individual with a police officer near the driveway.
Correct.
Did you see that same person still outside when you exited?
Yes.
Did you notice any bleeding or obvious injuries to that person?
No.
Did you make an assumption as to who that was?
Yes, our PTI en route said brother or brother-in-law shot brother, so performing CPR. So you're kind of assuming it's that person.
Okay. In terms of his size, is he someone that you talked about people may not be able to always be strong enough or able to perform CPR in a way to cause the depression or that crunching sound, for lack of a better term? In your experience, what type of people are we talking about for that, where you wouldn't be surprised that you may not have seen that depression or the crunching?
It's typically going to be maybe an elderly population, somebody that's not as big, not as strong, that might not be able to perform chest compressions hard enough and deep enough. Sometimes if a patient is in a bed, so mattress has give to it, compressions won't be as effective. You want to get him to the floor. Obviously, he was already on the floor, so that aids chest compressions.
Was there anything about this male that you saw when you observed him entering or exiting that made you believe that he had been injured?
No.
Based upon your training and experience and what you observed and did in this case, would you agree that the victim, Charles Vallow, was dead before you entered the house?
Yes.
Based upon your training and experience and what you observed and did in this case, would you agree that it was highly unlikely that anyone had performed CPR on Charles Vallow prior to you doing that?
Yes.
I have no other questions, Your Honor.
All right, cross.
You want me to go now, or it's 4:30? I didn't know if you wanted
How long do you anticipate your cross-examination?
It'd take a while, Your Honor.
All right, we'll break for the evening then. We'll need you back here tomorrow morning at 10:30.
10:30?
Yes. All right, we'll release the jury at this time for the evening. We'll resume tomorrow at 10:30 a.m. Please remember the admonition.
All rise for the jury.
I don't think there's nothing. All right, so that is it for today, guys. I mean, we have made the first day of the Lori Vallow trial. We did it. So 10:30 a.m. Arizona time, but remember that it's half an hour delay, so it's going to be 2 p.m. Eastern. But we are going to be live at 9 a.m. Eastern for the Lindestorm trial. First of all, we're going to do the morning part of the Lindestorm trial at 9 a.m. Eastern. And then we're gonna pause at lunch break, do a longer lunch break, and then jump on the Lori Vallow trial. So have a good night. You all have a good night. I'm gonna have a good morning. I'm gonna go to work, and I'll see you all tomorrow. Thank you very much for everything. You guys are amazing. See you later. Have a great evening. Bye bye.
And I'm a real-time crime professional.